This matter is for this instant petition is an execution petition. The execution petition has been for the order dated 5th August 2024 passed by your lordship in CS.com number 475 of 2024.
What is the urgency?
For the execution of the petition, lordship.
File the execution.
Yes, lordship.
What is the returnable date you mentioned in the presentation form? What was the returnable date in the presentation form?
When you file the presentation form, there is a date the matter is to appear.
When you filed?
Lordship, it is in 2024.
2024 filed? It's a commercial?
Yes, lordship.
Commercial hai to?
My lord, may I permit to mention one matter?
Yes.
This is the restoration application. Restoration application I have served to the opposite party.
And
today I mentioned.
When it was dismissed?
It was dismissed on 17th April 2025. And during the vacation bench, I have filed the restoration application.
Lordship, may I have your kind leave to mention an suit appearing as item 112 in your lordship's list. The suit is at the stage of cross-examination of the plaintiff's witness, lordship. The witness of the plaintiff has been extensively cross-examined.
02.
Lordship, 112.
112.
Turtle versus Industries, lordship. Lordship, may it be fixed on any date, lordship. The cross-examination of the plaintiff's first witness would be done.
Cross-examination is going on.
Lordship, it's appearing in your lordship list for quite some time, lordship.
If you want to fix the date, then it will go to the first week of August.
Lordship, any day it will. I don't think, lordship. I have duly given a notice.
Correct. I can fix the matter. I appreciate it is a witness action. It has to be fixed, but it will go. I don't think July there will be any date. You will get in the first week of August only. Ask your senior if.
I would be mentioning a matter which is already fixed at 3:45. We do not want the witness action. We want to file an application.
Today?
No, it is fixed on 16th of June at 3:45. Okay. Which I shall be 3 matters, which I shall be paying for.
But even I'll be.
So he can accommodate.
I just indicated to your lordship.
Which matter? Which matter?
This is there are 2 matters, and if you want to kindly seize the order, here a part decree has already been passed with regard to the principal amount and the pre-suit interest.
Correct.
Only which thing which is remaining is pendentility interest and post-suit interest.
No evidence.
I did not.
No evidence is required.
No evidence is required, my lord. I will file an application to that. But when we were drafting the evidence, we found that similar is really not required. So, my lord, that is why I was humbly beseeching.
This two matter. No matter.
There is one more. In all these matters, my lord,
all are fixed on the same day?
All are fixed on the same day. No, one is on 3rd of July.
3rd of July.
The last one is on 3rd of July. The first 2 which I handed over is on 16th.
That is at 2 p.m.
That is at 2 p.m.
So he can be accommodated on that day.
My lord, may I pray for the 3rd of July?
3rd July I am not
there. If you're
16 June है. ठीक है एक काम करो तीनों और उसका मैटर को एक साथ कल टू बी मेंशन कल रखो.
My lord, but may I pray for the 3rd of July time, my lord? Because
okay,
this is the South Point. No, this is the South Point matter. If your lordship recalls, my lord, your lordship by an order dated 6th of May had fixed it on the 12th of June and the 17th of June at 3 p.m. My lord, 12th of June, my lord, I'm being led by Mr. Bachawat. He's in some personal difficulty on the 12th. So if
but the other parties are though,
they're all there.
Your lordship, they have to argue. So.
My lord, we have to argue. So 12th of June, my lord, 17th is there. So 17th can stay. My lord, if 12th of June, if your lordship kindly keeps it on the 3rd of July, as my Mr. Gupta mentioned, or if or any earlier date if possible.
Come tomorrow, give the number.
I've given the.
So it will be listed tomorrow as to be mentioned. I pass up to
May I be permitted to mention one non-contentious probate petition from Justice Mukherjee's list, my lord.
But here I am not. This court is not.
This court is having the urgent determination, my lord. The executor is the
urgency.
Executor is a senior citizen, my lord. That is the urgency, my lord.
May I have
kindly, my lord.
Sorry.
May I have my lord's kind leave item 123 of my lord's list today. My lord, it's an undefended suit that was specifically fixed yesterday at 3:45 for arguments. My lord fixes any day conducive to my lord's list. And my lord, if I may seek an indulgence, may it at least be 3:30. We can then prevail upon 15 minutes of my lord's time. This is the fourth attempt
You not
we've
come
been.
tomorrow yesterday.
My lord, I had mentioned the matter yesterday. I was being led by Mr. Dotto. In view of the resolution, my lord, it was perhaps a little sensitive for him to appear after 3:30. Any day conducive to my lord.
It is very difficult. You catch hold of any of the fixed matters who is going to take adjourn, then I will adjust.
My lord, any day. No, I am not seeking for a hearing today. It may be fixed on any day.
12th June. 12th? लेकिन उसको उसमें फिक्स करेंगे 16 उसका 2 मैटर, इसका एक एविडेंस है और उनका एक एविडेंस है। 12 जून नहीं होगा, 12 जून 2 PM 3 PM उसका ना 5-15 मिनट का है। ठीक है, रखो 12 जून में रखो।
12th June time. I am obliged, my lord.
Lordship, I am mentioning under a peculiar situation, Lordship, CSCOM 501 of 2024. My instruction from the client is to withdraw the suit with liberty to file a new in the same.
Which matter?
I am
It is listed? No.
I am opposing this. First of all, your lordship doesn't have the determination because this is an IP matter. So this has to go before, my lord, the regular bench.
Lordship, the problem.
Yes.
My lord, it has to first go before the regular bench. My lord, there were directions also, my lord, where your lordship, while your lordship had the determination for payment of costs, etc., nothing has been done, my lord. This is what your lordship's order at that point of time. And my lord kindly takes, we've been served with an amendment application where, my lord, the praise are also there. My lord, we have not been served with the suit.
Substitution application.
Kindly have a look at the
No,
praise.
it's okay, but it's the IP matter.
Yes.
So how this court can
Lordship,
take...
the problem my advocate on record is facing is that his clerk is going to the department. That department is saying that no, there is no order from the court.
What?
That the matter should be transferred to the IP division.
No, no. Can go to the determination.
Yes.
Then
If
there is no necessity. There is no necessity to mention. You mention before the appropriate.
I have mentioned before the appropriate court. But his lordship is sending to the department for transferring, and department is saying there is no order from the court.
So that is a department and the court. What
So
this court?
kindly passes an order.
This court. How this court can pass an order?
Grateful to you.
Lordship, may I leave to mention, Lordship, one matter for drawing up of the order and judgment dated 21st March 2025, Lordship. What else?
Yes. Written notes.
Yes, my lord. Only one indulges me. I, my lord, hand it over in the today itself because my lord, just we stitched and all, not this way. They have got it. So my lord, may I just hand over at the time of my lord the rising, or my lord at 4:30? Any of my juniors going to mention, or I am going to mention the matter, my lord. Kindly, my lord, allows that, my lord.
Fine, notice it. I have any judgment
stipulated and brought it before my lord. But that's not right, my lord.
I am recording filed you for.
Yes, well, I will file it today itself.
So suffering for the plaintiff, so suffering for the defendant. Defendant number 1.
Yes.
Defendant number 1. Both the parties have filed their written notes of argument. Let the same be kept with the record. CAB.
Great. Great.
लेगा इसमें डाल देना, नहीं देने से बता देना. Yes.
Well, directions were given to complete the examination on commission by your lordship's order of 21st April by 10th of June. The learned commission was like to file his report by 10th of June. Lord, I'm praying for an extension.
10th of June?
10th of June, paragraph 10 of your lordship's order of 21st April.
Okay. You are for the plaintiff?
My lord, I am appearing for defendant number 2.
What is the stage? Evidence
Chief is
होगा?
going. No, chief is going.
Going on.
Chief is going on. It will take 2-3 more sittings in the
Further.
chief.
Of the plaintiff only.
Yes.
Then defendant.
Then defendant cross. But
Yes.
at least 2 months, your lordship. Yes.
What is the submission?
Sir, I have no objection.
So suffering for the plaintiff, so suffering for the defendant. Number 2. You are appealing for
Defendant
the
number 2. Yes.
Yes, my
Number
lord.
two.
Number
They are the only contesting defendant.
The case is fixed today for filing report by the commissioner. Senior counsel appearing for the plaintiff submit that still the examination chief of the plaintiff witness is going on and there's a chief raise for extension of time. In view of the submission made by the counsel for the party, time to file report by the commissioner is extended till 19th of August 2020.
So there's one more matter, my lord. I'm sorry. Lord, I don't know how to take.
19th August. Yes.
Your lordship, I came across my practice directions which your lordship has given regarding delayed filing of written statement income. Similar, my lord, I think a practice direction is required to be framed by this court regarding, my lord, the fees to be paid by the court officers when they attend commission, my lord. There is no fixed fee structure.
No, yeah, initially I used to do that.
Yes.
But in between there was some contradictions has come.
So, my lord, that's
some problem has come. That's why I am not dictating that point. That
yes, but
point
my lord, what is your lordship's order does not provide, but my lord, other courts may not provide. Now, my lord, there is a wide disparity which happens, and then my lord, it becomes very difficult for the instructing attorneys. If your lordship kindly sees this order, for example. Kindly see the second page, my lord, fourth last paragraph.
Staff deputed shall be paid traveling allowance of 400 GM per day.
My lord, the commission takes place at the Par Library Club, my lord, across the road in the main building. So becomes, and then if your lordship sees the fees of the commission, this works out perhaps more than. So some practice directions your lordships will kindly frame. Something has to be done. Otherwise, my lord, this whole practice will suffer. Then parties will insist.
Correct.
They want to trouble the court and they'll say this is becoming prohibitive.
Okay, I will see to that.
Kindly see.
I will take it.
Please, my lords, kindly take this up. My lord, your lordship, I'm told that the registrar has also not fixed. I mean, the court has the registrar original side or the commercial division. There's no fixed fee structure.
That is there are so many things are there that has to be carried out.
Lordship
We
will
are
kindly
working on
consider
that.
this.
We'll see to that. How it.
But do not complete for
No, उनको देना order.
I am for the defendant.
Yeah, not उनको.
My lord will kindly recollect I had mentioned
Yes.
yesterday, my lord. My lord, it was extended up to 3 months, but it was mentioned as 10th June, date of filing of report. And I was humbly praying if another 2 months can be added to that.
What is the stage?
My lord, my evidence will begin. I am the
Plaintiff
defendant's witness.
Is going on.
It is going to start.
Not yet started.
Not started. Defendant's witness not started.
is over.
When your witness was over.
My lord, it was some time, my lord. Thereafter, certain things had happened, my lord. My advocate on record had an accident, was not here. There was a bereavement with the commissioner also, my lord.
I think this court is faster than the commissioners.
Yes.
My lord, it is.
Any day.
High courts
Any
are faster, my lord.
So and suffering for the plaintiff, so and suffering for the defendant. The matter is fixed today for filing report by the commissioner. Full stop. Counsel for the defendant submitted due to some personal difficulties of the advocate on record, the defendant could not adduce the evidence before the commissioner. Accordingly, she pressed for extension of time to file report by the commissioner. Considering the submission made by the counsel for the defendants, time to file report by the commissioner is extended till 19th August 2025.
Grateful.
Let the matter appear on 19th August for filing report by the commissioner. Next.
I appear for the defendant. In this matter, my lord, your lordship was pleased to appoint an advocate commissioner for recording the evidence of the defendant.
Correct.
Now, my lord, the chief is going on, my lord. My lord, there was a direction by my lord to file the report on today, my lord. So, my lord, if the time be extended, my lord, we shall complete, my lord, the evidence of the defendant, my lord, and thereafter we
How much time it take?
My lord, I think, my lord, 1 month more.
Defendant's witness.
Defendant witness.
Plaintiff witness is over.
My lord, plaintiff witness over. My lord, defendant witness has come into the box. My lord, chief has been going on. My lord, only thing, my lord, kindly makes it time bound because, my lord, the report of the commissioner insofar as the plaintiff's first witness was completed in December. My lord, we are today in June. My lord, my lord, kindly makes it time bound. That's the only prayer, my lord.
So bring for the plaintiff. Plaintiffs. So bring for the defendant. The matter is fixed today for filing report by the commissioner. Police counsel for the defendant submitted. Defendant witness is going on. And due to some personal difficulty, the examination could not be completed and placed for extension of extension. Counsel for the plaintiff raised objection and submitted that plaintiff witness has been examined. Plaintiff witness is over in the month of December 2024, but till date the defendant could not complete the evidence of the defendant's witness. Consider the submission made by the counsel for the defendant, counsel for the parties. For the interest of justice, time to file report by the commissioner is extended till 28th of July 2025. It is the commission is directed to complete the examination. The defendant is directed to produce to complete the evidence before the commissioner on the date fixed. Let the matter appear on 28th July for filing report by the.
So grateful to your lordship.
Next.
So I am for the plaintiff. Today, your lordship has fixed for the commissioner to file his report, the advocate commissioner.
Not yet completed. Completed.
I have made separate compilations. One is the report. Then there are two compilation. One is the index of the minutes. Then the depositions of the two plaintiffs' witness and the compilation of the correspondence which has been exchanged. But because there has been several adjournments, several delays which I had wanted to.
Okay.
May I serve on
both the parties have adduced evidence?
No, your lordship will remember in this matter, the defendant witness, after giving the first days of evidence, thereafter made a adjournment prayer on the basis of his having some accident and went back to Bombay. But your lordship has closed their evidence, and it was of 7th May. Your lordship has passed this order.
So what happened?
So your lordship had closed the defendant's evidence and directed the commissioner to file his report today. So a date may be fixed for the final argument.
Remuneration paid?
No, few is outstanding.
Who is the
few of the
plaintiff?
last sittings. Is appealing for the plaintiff and.
No, it will be done. It's been it comes from Delhi corporate. It will be done. That we are always up to date, more or less.
Who is for the defense? You. So opening for the plaintiff, so opening for the different plaintiffs, so opening for the defendant. Commissioner is also present and has filed the report. Have you served the copy?
Yes, on both the sides.
After serving the copy to the advocate appearing for the parties, let the report be kept with the record. As the evidence of the plaintiff is over and this court has already closed the evidence of the defendant, let the matter appear on 7th July 2025 for argument. The parties are directed to pay the remuneration to the commissioner by the date fixed. Let the commissioner pay, then I will discharge.
Your Lordship, I appear for the plaintiff, Your Lordship. I'm led by Mr. Thakkar, praying for a short pass over, Your Lordship. Mr. Thakkar will press here in.
I'm led by Mr. Pan.
Praying for a short pass over, Your Lordship. I'm led by Mr. Thakkar, Your Lordship. He is on his legs, Your Lordship.
Just
a short pass.
Filing of the report only.
It's for filing of a report, without prejudice. This was directed. We have points with regard to maintainability of the suit
Mr.
itself.
Thakkar will press for some interim relief.
No, there's question of maintainability. How can there be any question of interim order?
Lordship, praying for a short pass over, Your Lordship. He's on his legs, Your Lordship.
They only mentioned for filing of the report yesterday.
Lord, I'm for the first respondent, Lord.
I'm
I was
obliged.
seeking your lordship's leave to file my affidavit by 2 days. I was filing within the vacation.
Your lordship, we are also praying for the similar prayer to file the opposition.
Opposition, but without prejudice to our rights. The suit is not maintainable.
The only thing I appear for as the mediated appointed one, may I file the report? That's all.
Mr. Banerjee, you're appearing for yourself today.
Settled or not?
He tried very hard. And we had a sumptuous lunch.
Affidavit exchange?
No, Your Lordship, I'm praying for extension of time to file the opposition.
Can you give us 2 days time, till Thursday or Friday?
Yes.
Your Lordship.
I was praying for a passover, Your Lordship.
What?
Led by Mr. Thakker, he would have pressed for some interim relief, Your Lordship.
It has been refused.
Kindly let Mr. Thakker appear and kindly gives a short passover, Your Lordship.
But affidavit is not completed.
Yes.
Your Lordship, kindly.
I'm praying for a week's time, Your Lordship, without prejudice to the maintainability of the
Affidavit is completed. I will hear the.
Yes, yes, my lord. Kindly.
Yes.
What interim order you want now? Mediation failed. Earlier the court has not granted and affidavit direction because without completing this direction, how this court could take the interim order, interim application?
Your Lordship,
There is a direction of filing affidavit.
If your Lordship allows one opportunity to please, Your Lordship, just one short passover, Your Lordship.
All seniors are there, madam. See, all seniors.
Can you keep it on Friday, Thursday or Friday? In the meantime,
No. If it can be taken
Kindly keep it next week, my lord. Then we'll come with the affidavits and our application.
1 week for filing of the opposition.
Not next week, Your Lordship. This week itself, then Your Lordship.
This week, 3 days only. So suffering for the plaintiff, so suffering for the defendant number 2, and so suffering for the defendant number 1, 4, 5, 8 to 16. The London mediator has filed the report. Let the same be kept with the record. Remuneration paid?
Oh, yes, it will be done.
As the mediator has filed the report, he has been discharged.
We have paid after some mishap.
Police stuff. The counsel for the plaintiff press for hearing of the interim application, but the learned counsel for the respondents press for extension of time to file affidavit in opposition. Let affidavit in opposition be filed by 16th of June 2025, reply by 19th of June 2025, list the matter on 20th June 2025.
Your Lordship, only thing, the maintainability of the suit be kept open because there is an arbitration clause, Your Lordship.
That is already there.
File my report, my further appearance.
May I pray for a copy of the report? May I pray for a copy of the
what?
Report, copy of the report.
There is nothing. I give him a copy.
Just circulate.
Just record it.
It's failed. That's all, my lord. The mediator has to, my lord. 28th, my lord, is, my lord, can it be 23rd of June, my lord? Is it possible? Monday, my lord.
Okay, instead of 23rd.
I'm grateful.
Lord.
Grateful.
As new motion, huh?
Grateful.
Well, item number 7, I appear for the plaintiff, my lord. It's my suit for recovery of money. Yes. My lord, I'll tell your lordship the background, my lord. So my suit is against the sole defendant who is a guarantor. Now, my lord, an agreement was...
the guarantor you filed?
Yes, my lord.
Where is the principal borrower?
No, not exactly the principal borrower, because the agreement said that he's not a borrower per se, the person who's going to provide me certain services and also reimburse me the excess sum paid by me for the services which he couldn't render. Now, my lord, the reimbursement that he had to give me back has been guaranteed by the sole defendant. Now, initially, my lord, I could not proceed against the company because the company in the meantime had gone into corporate insolvency resolution process before NCLT Chennai. Hence, my lord, I've proceeded against the defendant, my lord, who is the guarantor for that particular agreement, only to reimburse the money for the services which couldn't be rendered by the company. Now, my lord, the agreement, if your lordship finds...
Why you are not claiming raise your claim before the NCLT?
My lord, I am here, my lord. The cause of action is accrued within your lordship's jurisdiction, my lord, because the agreement was executed at 1B Old Post Office Street, my lord, within the jurisdiction. Now, my lord, the guarantor had given certain post-dated checks, my lord. They have bounced. Now, my lord, that has happened
within your lordship's jurisdiction at the Dalhousie branch of Yes Bank, where I hold an account. Hence, my lord, the cause of action has arisen. So today, my lord, in this suit for recovery of money, I am playing for leave under clause 12 and also 12 capital A, my lord, because since the main company has gone into corporate insolvency resolution process, my lord, and the guarantor who's made certain part payments and has kept assuring me that the money will be paid. My lord, I have a total due of 1.5 crores, out of which 20 lakhs has been paid in February. Pursuant to that, also, my lord, I have received certain assurances, but to no avail. Now, my lord, since the main company is into corporate insolvency resolution process, and I don't know what the guarantor has given further guarantee obligations, my lord. Hence, I'm praying for 12 capital A leave, my lord, under the Commercial Courts Act. My lord, I shall also.
Why you're not gone for the mediation against the guarantor?
My lord, the guarantor, my lord, several checks have bounced prior to the agreement.
When the check was issued and when the check was bounced.
My lord, the check has bounced in January. 7th of January 2025. My lord, your lordships will find page, kindly take page 96. I'm sorry, my lord. The check is at page 99. My lord, the check is dated 30 November 2024. Your lordship has that, my lord?
Yes.
Page 99. Thereafter, my lord, if your lordship takes page 96, that is the check return advice. And this is after the agreement, my lord. Prior to the agreement, also, several checks had bounced for the company. And after the agreement, my lord, the checks of the company have also bounced and the check of the guarantor has also bounced. Thereafter, my lord, page 97 is the envelope, my lord. Yes Bank, Dalhousie branch. Page 98 is the courier receipt, my lord. So this is the check which is bounced, my lord. And your lordships will find page 102. My lord, page 102 is my bank statement.
That's correct. Where is the urgency? It's correct. January the check was dishonored.
Yes.
When you issued the notice.
My lord, I'll tell. My lord, 138 notice was already given after the check was dishonored.
Correct. So
Yes.
what is the urgency?
My lord, the urgency is this, my lord. If your lordship kindly takes, I'll tell your lordship, my lord, the main company is undergoing corporate insolvency resolution process. I'm here against the guarantor, my lord. The liability is coextensive.
Maybe.
That company has already defaulted and it's under IBC. Now, my lord, the guarantor, since he has coextensive liability with the company, my lord, he will also have guarantee obligations vis-a-vis that company before NCLT Chennai. My lord, my concern is that since the checks have been repeatedly dishonored, my lord, there are no funds in the only bank account given to my understanding that the guarantor has, my lord. And he is in the process of alienating all his assets basically to deny me my rightful dues. Company goes into CIRP, guarantor has certain guarantee obligations there. He defaults on his guarantee obligations here. My lord, nothing remains. Now, my lord, that is my concern. Insufficiency of funds.
No, sir. Well, as to you have to comply with. You go to the mediation. This is not the urgency which you have played at. Several times the check has been dishonored.
Yes.
This is not the ground.
My lord, I'll tell your lordship the difficulty. My lord, I'll tell your lordship the difficulty. Today, there's also, my lord, my apprehension, why I'm before your lordship. I could have gone for mediation. Why I'm here because is the company is undergoing corporate insolvency resolution process. I am an operational creditor. I won't be able to realize my entire dues because there are financial dues for the company.
The first question has been put by this court to you.
Yes.
You have not raised your claim before the before.
I have lodged my claim.
So then,
my lord, I won't be able to realize. But if your lordship sees, my lord, Contract Act.
No, if you lodged your claim,
Yes.
so naturally the tribunal will look into.
No, my lord, against the company before the resolution professional. And my lord, I'm an operational creditor, so I'm not entitled to the entire dues anyway because the financial debts get precedence.
So then, and here is the company is not you. Here is the guarantor.
Yes, my lord.
He is not before the IBC.
No, he is not. That's why I've instituted this suit against the guarantor before your lordships because he's not before the IBC. Otherwise, I wouldn't have been able to come.
You go and lodge the mediation process. Let it come before the mediation process. There's no urgency, sir. You go through.
My lord, the only difficulty is, my lord, this is the problem. Problem is, my lord, that the company is undergoing corporate insolvency resolution.
That's why the company is not here. You file the suit against the guarantor, and you kindly come to the paragraph 32. Only because the check has been dishonored several times that there is an urgency. That is not a
Yes.
ground for the 12A.
Part payment made in February.
Maybe.
My lord, checks have bounced several times. My lord, the only difficulty is if there's further delay in my attempt to recover the dues, my lord, he'll anyway frustrate my decree, which I'm anyway entitled to against him.
Your check was bounced. You have sufficient time. You go for the mediation. 3 months you have a time. What do you want? Order or you withdraw?
I want an order from your lordship
Okay.
for the admission of plaint, my lord.
I will not admit. I will return this plaint. Court is not satisfied with the urgency. 12A.
Done होने से क्या? Lord, may I come back on Thursday if it's possible?
As per the prayer made by the counsel for the plaintiff, case is set down. Let the matter appear on 19th. No, 12th.
12th. 7 and 8, my lord, both matters.
7 and 8 both?
Yes, my lord. Different plaintiff, but same defendant, same company.
In both cases. Come on 12th, huh? Under the same ID.
Your Lordship, I'm appearing for the contemner 1 to 4. Your Lordship, before my learned friend submits anything, Lordship, we were directed to file an affidavit whether we have used the AWS Amazon services. We did affirm the affidavit on 20th of May, Your Lordship, but unfortunately, the department did not accept on the ground that the petition has been amended and we were not having the recitals. The copy was not served to us. We did send a letter to my learned friend, but the copy has yet not been served, Your Lordship. If some time can be granted, Your Lordship, and a direction can be given that amended petition copy to be
So
served.
why you not taken leave from this court? Without the amendment, you can file affidavit.
I'm appealing for the respondent number 6, 7 and 8. 8 and 9. This is the affidavit on behalf of respondent number 6, 8 and 9, my lord. 2 affidavits.
Have you served the copy?
Yes, I have served the copy. Mr. Vinit Thakur is appearing or virtually in this matter.
Your Lordship, one more submission. We are the main contemners 1 to 4. We have not been served any copy from the other alleged contemners. If copies can be served to us.
My lord, I am appearing for the contender number 7, Your Lordship. Pursuant to Your Lordship's last order, there was objection to personal appearance. The person is present. 5 has disclosed that home creation is doing. But no contempt petition was served upon us, nor any order. But we only came to know about the contempt. My lord, the rule was served upon us on 29th May, Your Lordship.
Who is he?
My lord will kindly direct them to serve a copy at least to us.
Who are you?
Check the report. They have already been served.
Have you served?
Yes, sir.
Yes, yes, we have served.
Where is the affidavit service?
You are for which party?
7.
Yes, 7 has been served.
Lordship of 21st of day of April 2025. 99 acres.
Yes.
What is the good name?
6163.
99 acres.
99 acres.
Yes, Your Lordship. 99 acres.
Affidavit of service?
Yes, delivery confirmed.
Where is that?
Lordship,
The affidavit of service, Mother. Page
21st day of April by Mr.
page
Chittaranjan
16.
Affidavit upon on?
21st day of April 2025. But you would kindly come to page 13, where we have given the postal receipts.
13.
Page 13.
Yes.
The second receipt belongs to 99acres.com.
Yes.
That you would kindly mark the registration number. It's EW10429616
96163IN. Yes.
That you would kindly come to page 16. The track report. It was delivered on 4th of April 2025.
Yes.
The fourth category.
Quentin, we have not received kindly at our cost, application can be taken.
Okay, give one copy to him.
Yes, Your Lordship. But may I say that we have already complied with your Lordship's order?
What you have complied?
You have removed it. Let me file a compliance report.
File the compliance report.
You will file a compliance report. Give us 2
Give the
weeks, Your
copy, one copy. Serve the one copy.
One copy to us also, Your Lordship. Contemner 1 to 4.
Lordship, there is one thing, my lord, if your Lordship kindly takes up the affidavit in opposition of the contemner number 5. If your Lordship comes to paragraph.
What is the name? What is the name?
Saurav Gupta, my lord.
Today filed?
No, it was filed previously, my lord.
Saurav Gupta?
Yes.
देखो मनोज सौरभ गुप्ता का एफिडेविट page.
Well, it kindly comes to paragraph 1. Kindly see your Lordships gave some directions. It is stated that the added respondent number 5 is a registered company and is an advertisement platform which helps connect buyers and sellers and is not a party to any transaction in any manner whatsoever. Then, that the added respondent number 5 acts as a medium through which prospective buyers can get in touch with sellers. That the advertisements and put up on the added respondent number 5's website either directly by buyers or purchasers or realtors or brokers. Then that the added respondent number 5 allows for advertisement to be made on its website in lieu of a fee, and the prospective buyer or seller or realtor or broker directly gets in touch with the person at whose behest the advertisement has been put up, that after paying a platform fee or charge, one can put up an advertisement on the added contemner number 5's domain. So if they have done it, they have had to pay a platform fee. Then, my lord, paragraph 5. It is stated that one Om Creation, through its representatives being one Rani Agarwal and one Susmita, had contacted the added respondent number 5 on 16 January 2024 in order to advertise the project Solaris on the added respondent number 5's website. The Om Creation was at that point of time already an existing customer of the added respondent number 5. That Om Creation has paid a platform fee in respect of which they had posted the advertisement in the project Solaris on the added respondent number 5's website. The Om Creation had approached the added respondent number 5 initially in 23 and again in 2020.
Om Creation, they have to say with Om Creation. They are linked with Om Creation.
So Om Creation is not here.
Now they have also not disclosed who is Om Creation.
Rani Agarwal.
How they are linked with the contemners. Respondent number 5 is not disclosed with it. They have not also said that Om Creation is an independent person.
Who has affirmed this? Saurabh Gupta.
Yes.
Who is he? Saurabh Gupta is?
Well, contemner number 5's.
Contemner number 5.
Contemner number 5.
Property wala.
Yes, he's a director.
Who is the property wala? Who is appearing for the property wala? Who is appearing? For the respondent number 5?
Property wala who is appearing?
One Shayak Chakravarti.
Last time, Mr. Shayak Chakravarti appeared, Your Lordship.
Today is not appearing. Today is not appearing.
Your Lordship, on that ground, may I humbly submit one thing? If this name has come up and we need to file an affidavit, can all the copies be served to us to at least contain us one?
That I will go to, but if the respondent number 5 is not, then I pass an order for appearance in person.
Well, the only thing is that, my lord, the difficulty is, my lord, this parties needs to be added first because Amazon, upon whom, my lord, notice was issued, my lord, they have come up and said, since there is no order against me, I am not going to follow it.
That the court will see.
But Amazon, perhaps, my lord, was informed by the contemners 1 to 4. They had said that I had informed Amazon so that they do not put it up. In spite of that, being aware of the order of your lordship, Amazon says I am not going to abide by it. So for that reason, my lord, Amazon needs to be made a party now as a contemner or as a pro forma contemner, whatever.
Where the Amazon says.
Your Lordship, that is part of the affidavit that we are supposed to file as per the last direction, but we could not file.
Okay.
So we did write to, before that we had written to them, but they say we are not going to.
Okay, you do one thing, you serve the copy to this.
1 to 4.
You are appearing for the respondent number, content number 1, 2, and
1
4.
to 4, Your Lordship.
1 to 4 and 7. You serve the copy to them and let
But
that.
Amazon has said that if you are unable, thank you, based on the nature of your report, we believe it might be more efficient for you to communicate with your customer directly. If you are unable to do that, please understand that we are prohibited from taking actions on accounts with a valid and binding court order or equivalent legal demand services on the applicable AWS contracting party, instructing AWS to take expected actions. They have taken actions. They themselves said that we have informed contemner on the basis of which your lordship directed notice to be issued.
So appearing for the petitioner. So appearing for the container number 1 to 4. Container numbers 1 to 4. So appearing for the container number 7. Who is for the 6, 8, and 9?
I am for that.
So appearing for the container number 6, 8, and 9. None appears on behalf of the container number 5.
My lord, in that event, my lord, the contemner number 5 is evading. Now, if your lordship would kindly issue, my lord, warrant of arrest.
By an order. The container number 5 has filed an affidavit on 15th of May 2025, wherein the container number 5 has admitted that the container number 5 acts as a median through which the prospective buyers can get in touch with the seller. The advertisements are put up on the container number 5's website either directly by buyers or purchasers or realtors or brokers. He has also stated that the container number 5 allows for advertisement to be made on its website in lieu of a fee, and the prospective buyers or sellers and the realtors or broker directly get in touch with the persons at whose behest the advertisement has been put up. It is also mentioned in the affidavit that after payment of a platform fee or charges, one can put the advertisement on the added container. In the affidavit, he has given the name of one Home Creation, who has Home Creation through its representative being one Rani Agarwal and Susmita had contacted the container number 5 on 16 January 2024 in order to advertisement of the project Solaris in the website of the container number 5. Full stop. Though the container number 5 has filed the affidavit, but is not represented today. And not represented. The container number 5 had the knowledge with regard to the restraint order passed by this court, but the container number 5 has not prayed for any apology or has given any undertaking that he will not advertise the said publication, has not made any publication in their website. Accordingly, this court has no other option but to direct the container number 5 to appear before this court in person on the next date fixed. The petition is directed to take appropriate steps.
But only one thing, Amazon needs to be made a party. If your lordship will not kindly.
Now let their affidavit come on record, then we'll see to that.
The personal presence of the respondent of a
Police. The counsel for the respondent number 1 to 4 submit that though he has affirmed he has prepared the affidavit, but the same could not be affirmed as the department is not accepting the same because the affidavit is affirmed on the unamended application of the unamended cost title of the contempt application. He prays for a direction upon the petitioner for to serve a copy of the amended copy of contempt application. Police counsel for the alleged content number 7 is present in the alleged content number 7 is also present in person, and he submits that he has also not received the copy of the contempt application, and he prays for a direction upon the petitioner for service of copy of the contempt application, and he submitted he will file the affidavit of compliance on the next date fix. In view of the submission made by the counsel for the respective parties, the petitioner is directed to serve the amended copy of the contempt application to the learned counsel appearing for the alleged content number 1 to 4 and 7. In course
Lordship, in addition to that, the affidavit filed by the added contempt as a copies to be served on 1 to 4.
In course of the day,
already served.
in course of the day, course of the day, full stop. The content number 1 to 4 and 7 are directed to file their affidavit within a week from date after serving the copy to the learned counsel for the petitioner. Let full stop. The affidavits filed by the parties be exchanged between the parties in the meantime. This is the matter.
Lordship, contempt 1 to 4 are physically present here.
For the time being, the personal appearance of the alleged content number 1 to 4 and 7 is dispensed with. 1 to 4 and 7 are dispensed with. This is the matter.
My lord,
before 2 weeks because it gets affirmed in Gurgaon, Your Lordship.
Let the matter appear.
Along with the copy of
Lordship, may I submit?
The rule was issued along with the copy.
Let the matter appear on 24th of June 2020.
Your Lordship, my humble submission. I am appearing for 6, 8, and 9, Your Lordship. My affidavit has been filed, Your Lordship, and the copy has also been supplied to the parties, Your Lordship. So kindly that may be taken on record, Your Lordship.
So instance appearing for the alleged content number 6, 8, and 9. The affidavit is filed after serving the copy to the learned counsel for the petition. Let the same be kept with the record.
Much obliged, Lordship.
My lord, if your lordship would kindly direct the petitioner, my lord, to serve a notice, my lord, on Om Creations.
No, that's why you want to hear the first the other person.
Well, that is there in the affidavit of respondent.
Affidavit, they have given the affidavit. They have not asked for an apology, or they have not stated that they will not.
Yes.
First, they will file an affidavit. They will not publish.
Wait. On 27th.
कब बोला 24? 24.
Much obliged, Lordship.
Yes.
In 10, Your Lordship, this is my contempt application. On the last occasion, Your Lordship directed the alleged contempt number 3 to appear personally. Your Lordship.
Yes.
On the last occasion also, Your Lordship, before that.
Content number 3 is appearing today?
No, Your Lordship, today has not appeared despite the repeated, Your Lordship, direction on 28th April and 7th May, Your Lordship. Today he is not here.
You filed the reply?
I have filed. My reply is ready, Your Lordship, in connection with the 1 and 2, Your Lordship. I am praying that the ruling may be issued, Your Lordship, against the
content number 3.
Just I have received the copy, Lordship. So for the 2 in 1 and 2 is
appearing for the petitioner. So appearing for the alleged contender number 1 and 2.
We have already filed our affidavit.
Then appears on behalf of the contender number 3. It is fine from the report. Several directions have been passed by this court for appearance of the contender number 3 in person before this court. But in spite of several directions, the contender number 3 failed to appear before this court. By an order dated 7th May 2025, this court has made it clear that on the date fixed, if the contender number 3 fails to appear before this court in person, appropriate order will pass. In spite of the said order, the contender number 3 failed to appear before this court today. According in considering the above, this court find that there is no other option but to issue rule upon the alleged contender number 3 for appearance before this court Thank you. In person on the returnable date. The petitioner is on the returnable date. The petitioner is directed to take appropriate steps for issuance of rule. Let the matter appear on what is the address?
Your address is Bihar Siwan, Your Lordship.
Bihar.
Bihar.
Your Lordship. Let the matter
Last
appear
location, Your Lordship.
on 27th of June.
27. Lordship, I filed my reply in connection with 1 and
Affidavit
2.
of reply filed by the petitioner after serving the copy to the London Council for the alleged content number 1 and 2 be kept with the report.
Lordship.
Next.
I am for the defendant, my lord.
Yes.
15. Lord, I appear for the plaintiff, my lord. Lord, this is my applications, my lord, for seeking, my lord, to rely upon additional document in a commercial suit, my lord.
What is the stage of the suit?
My lord,
The plaintiff.
yes, my lord. We have filed, my lord, supplied to them, my lord, the affidavit of the evidence. But subsequently, my lord, it has transpired, my lord, a document which is a banking document, which was, my lord, initially not an relevant document for the purpose of this proceeding. But during, my lord, conference, it was, my lord, appointed by the London Senior Counsel, my lord, that would be a relevant document for the purpose of that is why, my lord, we have taken out this application, my lord.
I wish to use an affidavit here, my lord. I have 2020 suit filed, 2022, 2025 document, and this document was, my lord, in their possession, and my lord, the statement of truth and those, my lord, compliances, the affidavits which are filed pursuant to, my lord, when you file a suit, my lord, they say, my lord, all documents which are in my power control. So the law is now settled, my lord. We are having that Supreme Court decision also, but I'll put in an affidavit and then lordship may decide it.
Lord, only
Suffering for the plaintiff.
I didn't go in.
Suffering for the defendant. Plaintiff has filed an application being GA Com 2 of 2025, saying for allowing the plaintiff to adduce to praying for allowing the plaintiff to adduce additional document. Counsel for the defendant prays for time to file affidavit in opposition. Let affidavit in opposition be filed by 2 weeks. Reply, if any, that will be filed within a week thereafter.
But the witness examination was fixed tomorrow. Now this application has come in, so my lord, that cannot happen.
Yeah. Or
Yes.
before the commission?
No, before your lordship.
So
tomorrow at 2 o'clock.
What will be done?
My lord,
Witness.
yes, my lord, my lord will
Without
kindly
this
fix
document,
after.
possibly, my lord, he won't be in a position to do it. Unless I
Kindly, my lord, fix it after, my lord, we shall do it after your lordship. Your lordship allow is along with it.
Release the matter on 3rd of July 2024. It is submitted by the learned counsel for the parties that the suit is fixed tomorrow at 2 p.m. for witness action. But the plaintiff has filed an application for additional document, and thus it is not possible for the plaintiff to proceed with the suit for witness action and prays for adjourn the matter. In view of the above, the hearing of the suit, which is fixed on 11th of June 2025 at 2 p.m. is adjourned. Let the matter appear on 3rd July.
Great.
Let the suit along with the interrupted application be appeared on 3rd July.
No time is fixed, my lord.
Hearing
application.
Oh, lordship is fixing the application. And tomorrow's, my lord, suit evidence is adjourned. Great.
As new motion, huh? As new motion. New chamber application, sorry.
Grateful.
I'm for the plaintiff.
Lord, I am the special officer, my lord. Your lordship, today is fixed for filing of the report. I have brought my report.
Yes.
Lord, I had visited the premises, my lord. What I have found. Lord, this is for the court, my lord, and my lord, I'm serving it to the king. My lord, defendant is not appearing, I'm carrying the copy. My lord, what I have found, my lord, your lordship, earlier, my lord, I was directed to paste the notice of symbolic possession
in the office as well as in the residential flat. The directors of the defendant have removed that notice without, my lord, communicating it to me, my lord, and my lord, without knowledge of this court. My lord, subsequently, my lord, your lordship had given me direction, my lord. I had visited the premises. I had faced resistance. I had to approach the police, my lord, and my lord, with the help of police, my lord, I had pasted the notice of the attachment in the office, my lord, as well as in the residential premises, and in the office, my lord, I had put the padlock. That your lordship will find at page 6 of the report. I had given the summary, what has been done and what has not been done. But in the residential premises, my lord, they refuse to leave. The directors are residing there. They refuse to leave, my lord. So, my lord, no padlock could be put in that premises. I'm carrying the keys, my lord. It's in this envelope, my lord. But if my lord,
how many two premises have been put under lock and key?
no, my lord, only one. Your lordship may kindly see page 6.
The office room.
Only the office.
Office.
The office was already under padlock by someone else, but I'd put a padlock, and my lord, I'm carrying the keys. But the residents, my lord, since they're residing, they refuse to come out. That is why, my lord, that couldn't be done. My lord, just one more, my lord, clarification. Your lordship, in the order dated 16th May 2025, had directed me to initiate appropriate proceedings. My lord, I seek my lord's clarification as regards that, my lord.
Where it is?
In 16th April 2025, your lordship has recorded that I have to initiate appropriate proceedings, my lord. I'm actually not aware, my lord, what proceedings is my lord referring to.
Have you served the copy?
No. Yes, the report.
I have received it, my lord. I have received.
Go through the report.
I have gone through the report, my lord. I am also aware of the fact what my client
Because,
has
my lord,
communicated
this was
to
done
me.
in the presence of the plaintiff. Your lordship,
The plaintiff was present. Both the plaintiffs were present, my lord. But there's a complete resistance from the directors, both directors, as well as their daughter, and one elderly lady was also there. What I am told, my lord. And even the police authorities, although they were present, but since there was a specific direction by your lordship to, my lord, probably because of that, my lord, the learned special officer could not evict them from the premises. So, my lord, if your lordship kindly direct a specific direction upon the police authorities, or your lordship can appoint my lord, a bailiff from this court, my lord, similar to the execution proceedings, so that they can, my lord, before that a notice can be issued to them, vacate the premises within such and such period. Alternatively, my lord, with the use of force, my lord, they may be evicted and the padlock may be put in the premises, and the learned special officer may take possession.
You filed.
But just one thing, my lord, as regards notice is concerned, the defendant is a private limited company, and the directors, they have intimated that they have resigned from the company. And my lord, the notices which I'm sending in the official email ID, I'm, my lord, bouncing back. I've annexed those copies. So, my lord, sir.
What is the application you filed?
But it's in the nature of order 38 rule 6, my lord.
Attachment before judgment.
My lord, attachment before judgment, my lord.
What order was passed?
My lord, the order was passed to lordship. The lordship initially appointed receiver, and thereafter, my lord, directed them to take symbolic possession, and thereafter, my lord, physical possession, my lord.
For attachment.
For attachment.
But this property belongs to the defendant. This defendants.
My lord, these properties belongs to a
their name.
In their name, my lord. My lord, I've also caused a search. My lord, it is in their name only. My lord, I can, if your lordship directs me, I can produce those searching.
One thing, you bring the total document, it is in the name, then the order is to be passed not to the registering authority, not to change the.
My lord, lordship will then kindly
proceed with the suit.
My lord, lordship will kindly.
It is only attachment. What is the?
My lord, my lord.
Attachment before judgment, only attachment.
Attachment, my lord.
So one of the property attached, one they are residing.
My lord.
And it is in the name. So you bring the documents on record. They are the.
The lordship will kindly permit me to file a supplementary affidavit, my lord. I shall come back with all those
My lord,
documents.
may I keep the my lord, copy of the report for the defendant and the keys with my my lord, Lord's court offices? There are 4 set of keys, my lord, in this envelope, my lord. And your lordship may kindly, my lord, provide a clarification as regards that proceedings are concerned.
Which page? Which
My lord,
order?
16th May 2020, 16th April 2025, page 2, my lord, paragraph 5, the second last line.
Page paragraph 5.
Yes, my lord. 16th April 2025, paragraph 5. The sentence starts, my lord, but in the presence of the plaintiff and to make appropriate proceedings at the time of attachment of property.
Yes, appropriate proceedings means you have to draw the proceeding what you have done.
And my lord, this
done,
removal of this removal of notices which your lordship had directed the special officer to fix in the front of the premises, it amounts to contempt of court, my lord.
That's so I see it. It is a judgment before attachment before
My
judgment.
lord, my lord.
Correct. Now attachment proceeding has been done.
Yes, my lord.
They removed or whatever it is, the report is there.
My lord.
So, but only attachment, it is not possible. You don't know whether, though attachment is there nowadays, you know, any person can purchase the property. They
Yes,
can
my
sell
lord.
the
That
property.
taken.
You have to take up property
My
steps
lord,
with regard to that
Your
property.
lordship will kindly give me the liberty, my lord. I shall file
The persons who are residing the court at this stage, you cannot say that they have to be removed and to log that all those things. One person are residing in the premises, attachment, he has identified that, he has put the notice, then if they are removing that, you take appropriate proceeding, you file appropriate proceeding, the court will pass appropriate order. Not in all this, all the thing cannot be done in this application.
Your lordship will then kindly give me the liberty to file supplementary, my lord. I shall come back with the proper documents.
Appearing for the plaintiffs, none appears on behalf of the defendant. A special officer is present and filed report. After serving the copy to the learned counsel for the plaintiff, as regard the report of the defendant is kept in the case file. The special officer has also kept the how many keys?
4 keys, my lord.
4 keys in the
चाटी चाबी है
in the seal. And देखो 4 key है ना? In the seal cover. Let the same be kept in the police. Counsel for the plaintiff prays for time for taking appropriate steps. Let the matter appear on.
My leave may be granted for filing supplementary, my lord.
Counsel for the plaintiff prays for time to file supplementary affidavit. Prays for leave. No, prays for leave to file supplementary affidavit. Let supplementary affidavit file within 2 weeks.
2 weeks.
This is the matter on 26th June 2025.
Great.
The next matter 17 is just for extension of time, my lord.
What?
This item number 17 is just for extension of time to of the interim order, my lord. That's all. And my lord, I believe
Who's for the other side?
they are
But I am appearing for defendant number 2.
they want to file their affidavit.
I want to file my affidavit.
Where is your wakalatnama? File wakalat?
Yes, my lord. I have already filed.
So you want to file affidavit in opposition?
Yes, my
How
lord.
much time?
My lord, at least 6 weeks, because my client has to come from Bangladesh.
Whether he will be able to come to,
Yes,
to India?
Yes, my lord. Yes,
You for the defendant number 2?
Yes, my
What
lord.
about the HDFC? Nobody is there. So appearing for the plaintiff.
Let there be directions for all, my lord, all defendants to file, my lord. I'll
Appearing
communicate
for the
that.
defendant number 2. None appears on behalf of the other defendants. Counsel for the defendant number 2 prays for time to file affidavit in opposition.
Sure.
The defendants are directed to file their affidavit in opposition within a period of file affidavit within 4 weeks. 4 weeks.
My lord, my client will come at mid-July, matlab 6 weeks.
6 weeks, comma, reply if any there to be filed within 2 weeks thereafter. Please the matter. 6 to 8 weeks. Yeah. Please the matter on 3rd September 2025. Interim order is extended till 8th of September 2025 or until further order, whichever is okay.
Well, it's similar order in item number 37. They're also same. She is appearing.
Item number 35. 35. 35, not 37. तो देखिए ना, 35.
List 35, my lord, I stand correct.
35. Same.
Same. Absolutely same. Your lordship's order will be the same.
Same order.
That's also expiring today.
Item number
It is
18 also, my lord, the extension for interim order. Item number 18, it will expiring.
Which for the other side?
Well, I'm for the other side, my lord. My lord, I seek extension of time to file my affidavit in opposition, my lord.
Record on 18.
My lord, and there is also a section 10 application on board, my lord.
I will file my affidavit in.
Counsel suffering for the plaintiff, counsel suffering for the defendant. Counsel for the defendant prays for time to file affidavit in opposition.
My lord, extension of
prays for extension of time to file affidavit in opposition. Fully. Counsel for the defendant further submitted. The defendant has also filed an application under section 10 of the Code of Civil Procedure. Counsel for the plaintiff prays for time to file affidavit in opposition. Let affidavit in opposition be filed within 2 weeks. Reply, if any, there to be filed within a week thereafter. Please the matter.
My lord, for the injunction application also, my lord, extension by 2 weeks.
Please the matter on 15th July 2025.
And my lord,
the interim order is extended till 18th of July 2025 or until further order, whichever is earlier.
Great.
My lord, item number 19.
July.
My lord, item number 19.
18.
My lord, item number 19 also.
No,
will
no, no.
only trouble my lord for 30
Yes,
seconds.
call.
They appear for the defendant, my lord.
Plaintiff.
देवाशीष कौर
क्या बोलते हैं माइके बोलते हैं
हाँ देवाशीष कौर
स्पेलिंग
DEVASHISHKAR VASH
देवाशीष कौर KAR कौर
Mr. Kaur, kindly take up Exhibit C. That is the agreement dated 1st March. Cross
resumed, huh?
Cross has been commenced, my lord. It is.
First, it is now commencing.
No, commencing, continuing.
Prior
Been done on prior occasion.
Resumed today.
My lord.
Resumed. It's resumed.
1st March 2009. Exhibit C.
Is the deed of agreement
the deed of agreement
between Martinma Limited and Hira Market Shopkeepers Welfare Association.
Yes, what is the question?
And Hira Market Shopkeepers Welfare.
Mr. Kaur.
Martin Bond Limited and Sriram
Market
Shopkeepers Welfare.
Dated 1st March 2009.
Sriram Arcade Shopkeepers Welfare Association. Between তাদের মধ্যে সেটা
নিজের মতন পড়ে যাচ্ছে
Mr. Kaur,
Oh.
kindly come to page 15 of this agreement and tell the court, are the closed shops mentioned therein disclosed by you as to which are the ones which are closed?
Page 15.
Page 15.
Modular operandi for execution of the maintenance.
The shops which have been closed.
পুরোটা করবো
যে দোকানগুলো বন্ধ আছে সেই দোকানগুলোকে এখানে মেনশন করা আছে আপনি শুধু সেটা গোটা বলুন একটু দেখে
কোনগুলো করবো
Kindly come to page 15, clause A, which refers to the closed shop inside the shopping complex. Have you disclosed which are the shops which are closed in the shopping complex?
No.
Your answer is no.
They shall be entrusted with the responsibility of safeguarding non-operative, that is all closed shop inside shopping facility. Reopening of the store code shall be permitted by marginal only with the advance information in writing, electricity supply and this and that.
The question to you is, have you disclosed before this honorable court which are the closed shops?
Pardon?
Which shops are closed?
Yes, I have disclosed.
Can you kindly indicate from the agreement?
আপনি বলতে পারবেন কোন কোন দোকানগুলো যেগুলো বন্ধ হয়ে গেছে?
দোকানগুলো অফ লিট তো বলা যাবে না। কোনগুলো? There are 286 shops.
Sir,
over there.
have you understood the question? His specific question is that, have you mentioned in the agreement which shop number is closed?
My lord.
Have you specifically mentioned in the agreement in paragraph 15? Page 15, paragraph, page 15, paragraph 1A.
Paragraph 23A, my lord.
23A. Have you mentioned with regard to the shop, exact shop number, which is closed?
যে দোকানগুলো বন্ধ হয়ে গেছে সেগুলোর নাম্বার কি আপনি এখানে
নাম্বার তো এখানে নেই, কোথায় থাকবে কোথায়?
আপনি আগের উত্তরে বললেন হ্যাঁ আপনি মেনশন করেছেন আগের উত্তরে আপনি
কোথায়? No, no.
Let's see.
Not say that whatever the shops are closed, not is mentioned over there.
Not mentioned.
not mentioned over there.
Serial number of the shops are not mentioned over there.
Yes, next.
Kindly come to page 18 of the agreement.
Yes, sir.
Do you find a heading which reads financial obligations to be fulfilled by Martin Byrne on 31st July 2008?
আপনি কি দেখতে পাচ্ছেন এই হেডিংটা?
Financial obligations.
Such obligations, will I be correct in saying that such obligations are enumerated till page 24 of the agreement?
Yes. এটা তো electricity.
কথা বলা হচ্ছে সেগুলো পেজ 24 পর্যন্ত উল্লেখ করা আছে, আপনি দেখুন দেখে
29,000.
আপনি দেখুন 24 নম্বর পাতা পর্যন্ত এগুলো উল্লেখ করা আছে কিনা অব্লিগেশন গুলোর কথা। 24 পর্যন্ত স্যার
দেখো
এখান থেকে শুরু ফাইনান্সিয়াল অব্লিগেশন।
হ্যাঁ দেখছি তো ফাইনান্সিয়াল অব্লিগেশন তো মেইনটেনেন্স অফ দিস পেমেন্ট অফ
18 থেকে
just tell me what you want to say.
Answer
Okay,
okay.
Financial obligations.
Now, kindly read clause 1B, which pertains to the security deposit held by Martin Byrne against air conditioning and maintenance payable to Saswa, that is the defendant. Can you indicate the amount?
1B, sir. 1B.
1B, the security deposit is security held by Martin Byrne Limited, air conditioning and maintenance.
কত টাকা অ্যামাউন্টটা বলুন?
29,73,600.
29,73,600.
600.
The amount is.
These were all set.
Have you paid such amount to the defendant, or is it still being withheld by the plaintiff?
আপনি কি অ্যামাউন্টটা ডিপেন্ডেন্টকে পে করেছেন না এখনো পর্যন্ত পে করা?
It has been regularized.
How has it been regularized?
It has been regularized. So far, the electricity is concerned, I can just tell you very honestly. It was around 29.
Yes, right.
Matter has been regularized.
The matter has been regularized.
Matter has been regularized. It is ঠিক মতন চলছে না. Matter has been regularized. And so far, the electricity concern is there. It was 29 lakhs at the time of agreement. Now it is 50.88 lakhs in April 2024 with CAC. which you don't know. 50 lakhs 88,000 deposit with CSC, and in April 2024.
And in April 2024,
50 lakhs 88,000 security deposit lying with CESC as on April 2024.
If there is an alleged dues of 50 lakhs, what do you mean when you say it has been regularized?
50 lakhs যদি ডিউস থাকে তাহলে আপনি যে বলছেন রেগুলারাইজড হয়ে গেছে সেটা কি করে হয়?
রেগুলারাইজ হয়ে গেছে বলতে কথাটার মধ্যে অন্যরকম মানে থাকে।
এটা কি অ্যামাউন্টটা পে করা হয়েছে না হয়নি? আপনি
এইটা
the payment has been
এইটা
regularized.
this has been regularized.
That's why he's telling.
This has been regularized.
ঠিক আছে।
Advocate has put the specific question. You stated that the 29 lakh was regularized. Now you are telling that the 50 lakh rupees is was pending in the WBS CSC. So how this 29 lakh were regularized? It is question. How this 29 was regularized?
This is related to air conditioning of this thing, is it? This has been related to air conditioning. It relates to shopkeepers' welfare associations. It's nothing to do with Martin Van legacy there. You have installed in one new AC also there, which you must be knowing also there, which is related to the shopkeepers' welfare associations.
What you want to say, please say it slowly so that it can be taken record. What you want to say, you
slowly. একটা করে সেন্টেন্স বলুন।
So this relates to air conditioning of this thing.
This relates to air conditioner.
This thing. New AC plant has been installed in the shopping complex, and
it has been installed in the shopping complex,
and this should be taken care of by the shopkeepers' welfare associations.
Should be taken care by the shopkeeper association.
Associations. Anything more?
My question to you was, my question to you was that you had said that a sum of 29 lakhs has been regularized.
Which you were talking about 1 or B? 29B.
1B, yes. So if it has been regularized, how is it that you are alleging that there is a dues of 50 lakhs?
Listen to me. I know what I know. I have said to you. This has been regularized.
I know
this has been regularized.
I know this has been regularized. বলুন তারপর।
এরপরে কি বলুন, কোশ্চেন বলুন।
Have you filed any documents for the purported regularization before this honorable court?
আপনি যে বলছেন regularized
This has been
আপনি কোনো ডকুমেন্ট কোর্টের সামনে জমা করেছেন?
No, which I don't think we have submitted any quotation to that.
We have submitted such documents regarding that.
Have you mentioned about such regularization in your plaint or in your affidavit in chief before this honorable court?
Plaint বা affidavit of chief এ আপনি কি এই রেগুলারাইজেশনের ব্যাপারে কিছু উল্লেখ করেছেন কোথাও?
Listen to me. This has been regularized. This is this.
উল্লেখ করেছেন না করেননি?
কোথায় উল্লেখ করেছেন?
Plaint বা
Plaint we say no to that. We say no to that because this has been regularized. How it has been regularized, that I can't say at present.
I can say it has been regularized currently.
That question has gone that not presently. That has it gone? I cannot say how it is regularized presently. Currently.
উনি মনে হয় at present বা কিছু একটা বললেন। উনি at present বা কিছু একটা বললেন। ওটা ঠিক করে নিন, নাহলে আবার গন্ডগোল হয়ে যাবে। at present কিছু একটা বললেন।
মেনশন করা নেই আপনি বললেন, তাই তো? Plaint বা
Plaint, no due is mentioned over there.
কিন্তু রেগুলারাইজেশনটা হয়েছে আপনি বলতে
it has been regularized.
It has been regularized. At present currently
Yes, next.
Mr. Kaur, kindly turn the page to page 19 and see at serial number 2 the amount payable by Martin Byrne Limited. Can you indicate the sum thereat?
Yes, the security police, 40,000.
অ্যামাউন্টটা বলুন
Amount will my 49,948.68.
49,900 sir one minute 49,948.68. Yes sir.
Is the plaintiff still with
This has all been regularized. But take it from me.
No. Is the
This has
is
all
the
has been
plaintiff
regularized.
still withholding the same? The answer is this has all been regularized.
Yes, next.
Have you filed any documents for such regularization as indicated by
Regulation is gradually it has been regularized. It's nothing to file a document to that.
Gradually it has been regularized.
Yes, next.
Slow sir. সামনে এসে বলুন।
what do you have to say about the other heads mentioned at pages 20, 21 and 22, which is the obligation of the plaintiff?
21 এবং 22 নম্বর পাতায় যে অব্লিগেশন গুলোর কথা বলা হয়েছে সেগুলোর ব্যাপারে আপনার কি বক্তব্য বলুন?
কোনটা বলছো?
21 আর 22 পাতায় যে অব্লিগেশন গুলোর কথা বলা আছে
আমার
Additional maintenance for it, maintenance of license, electricity, leave, this thing. You have shown me a page. You have shown me a page. This relates to the all of maintenance part. It should be taken care of the shopkeepers' welfare associations.
I am unable to get you, sir.
These all points relate to maintenance, and it should be taken care of. It should be taken care of by shopkeeper welfare associations. Nothing to do with Martin Byrne.
If that be so, can you tell this honorable court why such maintenance are under the financial obligation to be fulfilled by Martin Byrne as indicated in page 18?
It has been gradually regularized. Listen to me. This is a part of maintenance. It has been written over there. It doesn't mean that obligation is there. This is a part of maintenance.
Part of maintenance.
It should be taken care of the shopkeepers' welfare association. Even it is written over there. And it is way back to 2009 when the agreement was made.
Agreement was
Made.
If that be so, then kindly turn to page 24.
Because 24 কোথায় কি? এটা ভুলভাল জিনিস বলছে।
And tell this honorable court if you can find a heading obligations or requirements to be fulfilled by Saswa the defendant.
Fulfilled by the arrangement of obligatory or compulsory requirement to be fulfilled by SASWA list. Arrangement temporarily of a wide office visibility and not obtain labor license, government for business. Service tag registration.
Yeah, Mr. Kaur, you find that heading too. আপনি ওই হেডিংটা পেয়েছেন
obligatory.
Yes. So if
obligatory whom is obligatory?
My question to you is, if the obligations for Saswa is categorically mentioned in a different head at page 24,
And the financial obligations of the plaintiff is mentioned at page 18. What is the difference between the two, if according to you, all the obligations are to be carried out by the defendant?
As I told you, listen to me. This portion, first of all, let me answer to the this question. This portion to obtaining license, এটা শোনা যাচ্ছে না ঠিক মতন. This portion of obtaining license, this thing, it should be taken care of the shopkeepers welfare association. It relates to service tax registration. It should
Sir,
be
please. You cannot argue with the advocate. You whatever you want to give the answer to the court. It will be recorded. It is not the essay writing. The advocate is putting your question, you give the answer.
Secondly, you wanted to have the financial obligation is there.
Please slowly. It has been recorded.
As I told you, আপনি বলেছেন তারপর বলুন আস্তে আস্তে বলুন স্যার as I told you
Whatever the financial obligation is there, these were all regularized, and this portion is related to the
this portion is relating to the
relating to
this portion is related to the some of the licenses, service tax registration. This thing is to be taken care of the shopkeeper welfare. Obtaining labor license, service tax registrations, professional tax registration, it should be taken care of the by the shopkeepers welfare associations. এখানে আজকে শোনা যাচ্ছে না
Yes, next.
আনসারটা একটু আমাকে বলবেন? So I take it that according to you, the financial obligations at page 18 are not to be taken care of by the plaintiff.
তাহলে কি আপনি এটা বলতে চাইছেন যে 18 নম্বর পাতায় যে ফাইনান্সিয়াল
জানি তো দেখতে পাচ্ছি তো financial obligation to be fulfilled by Martin One Limited, that is the bill payment for this thing for the opening of the shop on account of rent, maintenance, electricity charges, security report held by Martin One Limited. এটা তো বলে দিয়েছে বোধহয় আচ্ছা তো এয়ার কন্ডিশনটা ওদের পান payment of Martin One on rent, maintenance, electricity bill. Martin One for open shop on account of rent, maintenance, electricity bills. Listen, all shops of the shopping complex, 286 shops, were all lease, sublease already. Already sublease, and therefore this has been all regularized.
and therefore this was
All shop of the shopping complex have been subleased, and therefore matter has been regularized. Therefore matter has been regularized.
Lord,
Yes.
I'm praying for an adjournment, my lord. I have a leader. My lord, may I read, my lord, the answers and come back, my lord?
This is the problem. You persons all knows when the matter was give the last order.
My lord, I am aware that the matter
Then
was prior to the vacation, my lord.
Then
Have you been receiving timely rents from the defendant?
ডিফেন্ডেন্টের কাছ থেকে আপনি কি সময় মতো রেন্ট ভাড়া পাচ্ছিলেন?
We have been receiving lease rent from the sublessees regularly at the rate of ₹2 per square feet.
2 per square feet.
Can you kindly elaborate? What do you mean by the term sublessee?
সাবলেসি বলতে আপনি কি বোঝাতে চাইছেন? একটু বিস্তারিতভাবে বলুন।
কি বলবো আরেকটু?
সাবলেসি বললেন না আপনি
হ্যাঁ,
শব্দটা ইউজ করলেন।
sublessee means the shopkeepers now. Sublessee means shopkeepers. 286 shops total. Sublessee means shopkeepers. Now total 316 from whom we receive lease rent at the rate of ₹2 per square feet.
According to you, how many shops are there?
কতগুলো দোকান আছে সেখানটাতে?
বলে তো দিলাম, there are 286 shop constructed and existing shop 30 number 30. The total comes to 316 shops.
টোটাল অফ
শোনার একটু অসুবিধা হচ্ছে।
Is it on record in the agreement dated 1st March 2009?
Yeah, it is recorded.
Can you kindly show the honorable court where it is mentioned?
এটা মেনশন করা আছে।
Sorry. It is লেখান 82 shops. এই পর্যন্ত লেখা আছে 286 shops. The time 286 shops. Shop category unsold, sold. 228 such as 304 page. Have a look to the page 8.
Page 8 of?
In the page 8 it is written like this. I have gone through the
এই ডকুমেন্টটা কি বলুন? পেজ 8 অফ
ঠিক আছে, পেজ 8 of exhibit C.
পেজ 8 একটু ব্রেকআপ দেওয়া আছে, পরিষ্কারভাবে দেখা যাওয়া নেই।
Yes, next.
You have deposed that there are 316 shops.
Yes, absolutely.
Can you find from this page 8 that the figure 316 is appearing?
Listen to me, there is after that.
This agreement is
12
exhibited.
inside shop.
My lord.
So
Real 12 inside.
why you are wasting the time? Exhibited document. If it is not there, you can argue the matter.
My lord. How have you been receiving the rent from the sublessees at the rate of ₹2 per square foot?
আপনি রেন্টটা যে পেতেন, আপনি বললেন সাবলেসিদের কাছ থেকে কিভাবে রেন্টটা পেতেন, কিভাবে দিত তারা?
We raise bill on them monthly and they pay us.
কিভাবে পে করতো? টাকায় দিত, চেকে দিত?
Check, cash, both they were paying. পেজ 8 সম্বন্ধে একটু আপনাকে বলে নিই।
ওটা হয়ে গেছে, মাই লর্ড বলেছে।
হয়ে গেছে না, এখানে একটু কিন্তু অন্যরকম আছে।
ও মাই লর্ড, দ্য উইটনেস। হ্যাঁ বলুন তাহলে।
Page 8 full figure has not been given over there because thereafter the lease has been granted after that 2009 এর পরেও। তো এইখানে দেওয়া আছে 304 total is.
Please be slow, it is being recorded.
Total is where some shops were leased out. Leased out. Total shop leased out is 286 shops. 286 bracketed litigation constructed by Martin Byrne, and there were existing tenants, that is inside is 12, it is written over there 12.
Over there, number 12.
12 inside shop and outside shop is এটা 17 জায়গায় 8 এটা ভেঙে গেছে দিয়ে 30টা হবে
12 inside shops and
inside and outside shop total will be 30 numbers ওইখানে একটু একটু ভেঙে গেছে
চলবে অনেক করে না
yes total 316 হয়
My Lord, may I humbly beseech your Lordship, my Lord, I have spoken to my learned friend. If it commends to your Lordship, my Lord, if this can be continued in commission, because my Lord, the chief itself took 4 days. It will take a lot of time, my Lord. If your Lordship, we are beseeching before your Lordship, if it can be done on commission, my Lord.
This court is having good experience of the commission. It will never finish till my retirement by the commissioners. The other judge will come and they will also extend. It will take further 20 years with the commissioner. I did not find any of the suit. During my tenure, I appointed the commission and commission is over, completed the except the undefended suit.
There is one exception.
Whatever.
That our Rahi suit, the Mr. Drolia suit, commissioner completed it under compulsion.
My Lord, my learned junior, my Lord, indicates that he has completed, my Lord.
ওটা আমাদের অন্য ওটা কিকে দলিয়ার ভয়ে কমিশনে শেষ করে দিয়েছে
My Lord, I was humbly beseeching, my Lord, if your Lordship. What? My Lord, I have a learned leader in the matter, my Lord.
Why you persons are not coming with the leaders? You have
My Lord,
knowledge that the matter is
I am aware, my Lord, some personal difficulty on his part.
Census and suffering for the plaintiff, census and suffering for the defendant. Plaintiff witness is present, cross-examination resumed, and after cross-examination, the witness at length, counsel for the defendant prays for time. According cross-examination is deferred. Let the matter
6 বছরের দাও
appear on.
লম্বা ডেট আবার কি যেরম দেবে সেরম নেবে
Give the date.
লোয়ার কোর্ট নাকি লম্বা ডেট দা পেশকার নাকি
আগুন
না এমনি अवेलेबल আছে
August. First of August at 2 p.m.
Commercial, it a commercial.
No, 11:30 month. 11:30 month रखिए कोई. 4th of August at 2 p.m.
Obligement.
Next.
Number 90.
Number 90, the time for the degree holder.
Yes.
After yesterday's hearing, my lord, the other side had approached our client, my lord, and I have the instruction that today they are going to make some payment.
No, not payment. Also, he is not advocate on record. Is not here, Your Lordship. We in my office it was discussed with his client, Your Lordship. We were supposed to take 2 weeks time, Your Lordship. In the meantime, we will sit and we'll finalize the amount. What the amount has already been discussed between them, Your Lordship. Their clients, the clients were supposed to take up the instructions that how much amount they will be able to pay in what period and times, everything, Your Lordship. So accordingly, it will be fixed and we'll sign the settlement, Your Lordship, and it will be fine.
Again settlement.
Then whatever they will decide. It's not my client.
Now we are on payment, my lord.
Correct.
No agreement, nothing. We are on payment.
Whatever
If
they will decide between them, Your Lordship.
What you want?
They want 2 weeks time, my lord, to finalize it. I have no problem, my lord.
As per the prayer made by the counsel for the decree holder, the case is adjourned. Let the matter appear on 22nd July.
Good.
Item number 20, my lord, I am for the
Judgment debtors.
I'm for the decree holder, my lord. My lord, the parties have already entered into talks of settlement. My lord, I'm humbly praying for an adjournment for 2 weeks for crystallizing
We have
the matter.
execution, what settlement?
Yes, and my lord, we have paid already a portion of amount we have paid. The rest we are going to pay very soon, my lord. So, my lord, kindly fix the matter after 20th.
20th of June.
June, my lord. The matter may be settled for full and final, my lord.
Yes, my lord. That is my instruction.
So and so appearing for the decree holder, so and so appearing for the judgment debtor. As per the prayer made by the council for the parties, the case is adjourned. Let the matter appear on 25th of June 2025.
Grateful, my lord. Great.
Grateful, my lord.
Next.
To item 21, I appear for the plaintiff.
Yes.
The defendants had said that they would be taking instructions whether they want to settle the matter.
Nobody is there.
We had offered them a chance at a dealership. They had said that they would be considering the same. They have only asked for the dealership.
None appears.
On the last occasion after the
No
hearing,
request.
they had approached us for a dealership. We said that we were agreeable.
Take instruction.
They said that they would be taking instructions.
Not today. Let come tomorrow, we'll see today. Not today.
Day after tomorrow. Lordship, could it be day after tomorrow?
एक record करो. So and so appearing for the plaintiff. 21, huh? None appears on behalf of the defendant. For the interest of justice, case adjourned. Let the matter appear
Lordship would kindly keep it on the next week then.
on 18th of June.
Grateful.
Inform the other side.
Yes, we'll inform the other side. Grateful.
That 22 that I'm for the respondent. Now that Lordship remembers by an order passed by your Lordship, my right to file written statement in this proceeding was rejected. I filed an application. Lordship did not allow the application. Now that we had filed an appeal, but appeal was not maintainable in view of the Commercial Courts Act. So we have to go to Supreme Court. Now in the Supreme Court, we obtained somehow, I do not know, somehow we obtained an order of stay of operation of all matters. I have the copy of the order in my phone, but
इसी में आया था ना कल रिपोर्ट आया था ना इसमें तो you have an order.
I have the order in my phone. Well, I can
give.
order a copy টা আছে তোর কাছে?
We've been told that there's a stay on the suit and further proceedings, although, my lord, we've not been formally communicated.
Let me see.
I have the copy. Just may I hand over it?
Now, they ought to formally communicate it.
I am told that by today morning by email it has been communicated, but I do not have the copy of the email as well. This is the order.
Record and all.
So the only thing is kindly keep it adjourned as sine die with liberty.
So and suffering for the plaintiff, so and suffering for the defendant number 1. In view of the order passed by the Supreme Court in SL special leave to appeal within bracket C number 15785/2025 15785/2025 dated 6th of June 2025. Let the matter go out of the list for the present.
Not with liberty to
With
mention.
With the liberty to mention after notice to the parties. Give the copy to.
I'll just.
Not received, my lord. We'll even, my lord, they ought to.
I can send her right now, but I formal communication.
See the order, Mr. Dasgupta.
Formal communication will be made by today.
I'm grateful.
Grateful.
23 I appear for the defendant lordship, Mr. Sengupta is leading. This is that matter, lordship remembers, with the leave of Mr. Sengupta. This is that matter which I mentioned yesterday. In respect of one of the suits.
Lord, I am appearing for the defendant, my lord.
Acha, yesterday, yes. What about this?
And this one, Lordship, Justice Mukherjee had sought for certain clarifications. The matters are identical. Justice Mukherjee has sought for certain clarifications. listed on 1st of July. Kindly.
You're for the plaintiff.
And for the
Well,
defendant.
I'll just indicate one thing, if your lordship permits me. There were two suits, similar suits. One suit, my lord, the plaint has been returned, my lord, for lack of jurisdiction because there was a forum selection clause. In the second suit, my lord, there is some dispute because some of the invoices had Kolkata as jurisdiction as also, and some of the invoices, my lord, had Jharkhand and other places as jurisdiction also. But our contention is that the part of the cause of action has not arisen within Kolkata. So in that regard, my lord, the hearing has been kept by Justice Mukherjee in June. So
Okay.
kindly, my lord, adjourn the matter till then.
Let Justice Mukherjee pass an order, then we'll see to that.
Grateful. That's good.
So appearing for the defendant. It is found that the matter is pending before the coordinate bench for passing appropriate order. In view of the above, for the present, let the matter go out of the list, liberty to mention. Great.
Lordship, on the last couple of occasions, this matter was held up because of the pendency of GA3, which was my learned friend's application for stay of suits. Now there is a judgment and order dated 21st May 2025 by which GA3 has been dismissed. So now GA2 is on board today, your lordship. GA2, the pleadings are complete. So your lordship may fix it on any consequent day. We can.
What is the GA2?
GA2 is for injunction.
Interlocutory
Judgment upon
application.
admission together with
Injunction.
injunction.
Pleadings completed?
Yes.
Pleadings are complete, your lordship. Pleadings were complete a long time back, your lordship. So
You're not preferred an appeal?
No. This was passed just before the vacation.
just before the vacation, it was passed, your lordship.
By Honorable Justice Arindam Mukherjee because he had heard the matter was concluded there.
Sense appearing for the plaintiff, sense appearing for the defendant. It is found that pleading in connection with GA2 of 2022 is completed. Let the matter appear for hearing. Date and time, then it will go to
Date and time, any. Let it come up in the list on any consequent day. We'll take our chances. August.
Or on let it be continued in the list.
Yes, let it be let it continue in the list.
Let the matter appear on 24th June.
Your lordship, may I hand up a copy of the judgment and order? একটা copy আছে ভালো যেটা stamp punch করা?
Okay, on the next day.
I'll hand up on the next day, your lordship. I'm deeply obliged.
Item number 25 and 26, madam.
So I'm for the petition.
I appear on behalf of the respondent, madam. I was requesting if this matter can be kept next week, madam. I'm being led by Mr. Anirban Ray, madam. Mr. Anirban Ray is leading me in this matter. He's not in town.
KP credit. After that one.
I'll tell you what this matter is, madam. This is that matter where.
Yes.
Yes, your lordship. I have the same instruction, your lordship. I appear for the petition.
Sense appearing for the plaintiff, sense appearing for the defendant. As per the prayer made by the counsel for the parties, the case is adjourned. Let the matter appear on 25th of June.
I'm
deeply obliged, your lordship.
Next. Divij.
Lord, here, Lord, I am appearing for the defendant. Lord, we have made an application for amendment of written statement. Now, Lord, affidavits are exchanged. It seems, Lord, plaintiff is not there. Lord, I simply Lord, asked for, Lord, we had to prefer an appeal because initially, Lord, we suffered a summary judgment. Now, Lord, from that, Lord, we had to prefer an appeal. Lord, we made an application for stay there. Now, Lord, that appeal went in our favor. The pleadings, Lord, those were there in the stay application. Lord, I intended to incorporate those because the written statement that was filed, Lord, it seems same fact. Only, Lord, the language is different. Lord, in a simpliciter way, Lord, we have tried to explain. Now, Lord, we have borrowed those statements. Those have been made in the stay petition. Those have already been taken into consideration by the Honorable Division Bench without any demurrer. Now, my Lord, those I intend to incorporate in the written statement. That's what my prayer is, which is not changing the nature and character of the pleading. Yes, that is the whole difficulty.
None appears on behalf of the plaintiff. So appearing for the defendant. For the interest of justice, the case is adjourned. Let the matter appear on 2nd July.
2nd July get a fixed touch.
Next.
We can actually.
In item number 28, my lord, I appear for the plaintiff petitioner. IAGA number 1, my lord. Now, my lord, just to indicate, my lord, recalls, my lord, the defendant number 1 was contesting and had taken out an application for deletion of their name. My application GA1 was for judgment upon admission as well as for injunction. Now, my lord, subsequent thereto, defendant number 1 has gone into CIRP. Now, my lord, defendant numbers 2, 3, 4, 5, 6, 7, my lord, we are proceeding against. Now, my lord, it was your lordship's direction, my lord, that I served. I've served and I've also filed an affidavit of service in respect of defendant numbers 2, 3, and 4, my lord, who have refused service. And in respect of the others, that has been served. It's recorded in the earlier affidavit of service. I've affirmed another affidavit of service in respect of defendant number 5, who is based in Dubai, my lord. Now, my lord, that has come back with the endorsement unclaimed. So, my lord, I'll try and satisfy your lordship insofar as refusal is concerned, deemed good service, my lord. In case of unclaimed also, there are judgments that it has to be deemed as good service. Now, my lord, apropos that, my lord, I would like to proceed with the application fixes any day so that I can actually proceed in respect of different numbers 2 to 7.
So appearing for the plaintiff. None appears on behalf of the defendants. Counsel for the plaintiff submits that the defendant number 1.
Defendant number 1 has suffered CIRP.
Defendant number 1 has gone into CIRP, but the plaintiff intend to proceed with the suit against the defendant number 228.
227.
227. He submits that the notice upon the defendant number 227 has been 226 have been affected, but in spite of service of notice, none appears on behalf of the defendants. As regard the defendant number 7.
Well, that's defendant number 5, my lord.
5.
Dubai.
2, 3, 4, and 6.
6 and 7, my lord.
As regard the defendant. As regard the defendant number 5, the notice was sent to the defendant number 5, the same was written as unclaimed. This court is of the view that the unclaimed is the good service. Accordingly, the same is treated as service upon the defendant number 5. In view of the above, this is a notice of GA1.
GA1, my lord.
In view of the above, let GA1 of 2022 filed by the plaintiff be fixed for hearing on 4th July.
4th July, my lord. Grateful.
Lord, item number 29, I appear for the plaintiffs, my lord. My lord, the parties have settled their disputes, my lord. May I file the terms of settlement, my lord? The defendants have also signed the terms of settlement.
What is the suit for?
The suit arises out of breach of a memorandum of understanding, my lord. We've paid for loss of damages and profit, my lord. Thereafter, my lord, the parties entered into this terms of settlement, which contains an arbitration clause, my lord. Therefore, my lord, the parties are agreeable to go before the named arbitrator according to.
Going for arbitration?
Yes, my lord. There's an arbitration clause in the memorandum of understanding. Accordingly, my lord, we've reduced those terms in this present terms of settlement, which we filed before your lordship.
So suffering for the plaintiff. You are for the plaintiff?
Yes, my lord.
None appears on behalf of the defendant. The plaintiff has filed the suit for paying for a decree for a sum of rupees 14,11,48,486 on account of loss of profit and loss of chance and on account of damages along with interest. Counsel for the plaintiff submitted during the pendency of the suit, the parties have come to a settlement for referring the matter to the arbitrator, and by terms of settlement entered between terms of agreement entered between the parties on 11th of March 2025. An arbitrator was appointed with the consent of both the parties. In view, full stop. This be kept with the record?
Yes, Milord, that will
Full stop. The original terms of referring the matter to the arbitration entered between the parties on 11th March 2025 be kept with the record. As the parties have decided to settle their dispute to the arbitrator, and the arbitrator has been appointed in terms of the agreement, entered between the parties. Let parties in view of the above, CS number 224 of 27. What is the count number?
So that's what I'm asking. You want me to pray for that?
Number 29. CS Com 426 of 2024 within bracket old CS 224 of 2022 disposed of in view of the terms entered between.
Yes.
The terms of agreement referring the matter to the arbitration dated 11 March 2025 entered between the parties with the kept with the record.
Not only one thing, Milord, urgent photostat copies of this, Milord, the certified copies of this order, if applied for, may be granted, because, Milord, this particular terms of settlement contains the name of the arbitrator, Milord. In case we require
You
that.
do one thing, you give the copy to.
Very well, Milord. In that case, we'll provide a copy, Milord, if that's.
Copy of the agreement is kept with the record. And give the copy to.
I'm so grateful.
Consequently, all connected applications also disposed of.
I'm grateful.
There are two applications. When GA3 is my application for judgment upon admission, and GA4 is the defendant's application for rejection of the plaint. So for GA3 is concerned, my judgment upon admission affidavits are complete. Now, so far the rejection of plaint is concerned, my lord, we have filed the opposition in the month of January. We have served them. We are filing today. Now, there is no reply has come. From the defendant in the applicant in rejection of plaint. Now, what I find from rejection of plaint, the grounds are money lent and advanced our cases, the commercial side we have filed. They say that is a Lady Moon, hand loan, simple hand loan, no mercantile document. So you could not have filed in the commercial division. This is the first defense. And there is no provision for transfer from commercial to non-commercial. Lordship has held in that.
No, now it is decided.
Lordship has held that.
This court has held, now the appellate court has stated that it is vice versa.
Okay, that I have checked only my lord's review matter. That I have checked.
The appellate court is
okay, that is vice versa. Okay, then I am saved the second leg. Okay, I have checked my lords that Mr. Shah, that matter I have checked. Now the second ground is that the other two defendants, the persons, some Shonjoy and there's some 95 proceedings under the IBC proceedings, informed with the bankruptcy court. So moratorium has been declared. So you cannot proceed against them. So in even so far the company is concerned, there is nothing. So that is the two grounds in the rejection of plaint. Now I cannot proceed with my.
Who is for the defendant? Devdatto.
It a file. This is my opposition to rejection of plaint.
Of GA3.
No, of GA4. GA4. But the advocate on record I find is Diprav Deb. Deprive. DIPRAV. Diprav. Is prompting me deprived. No, deprived, sir. So now I cannot proceed with my because of this rejection of plaint. Any of it has to be heard out, the rejection of plaint. They have not used a reply.
Both can be taken together.
Both can be taken together. Yes, yes.
Either this way or that way.
Either this way or that way. Because so far my judgment upon admission is there, balance confirmations, and
if it is found that it is not, then not. If it is found, it
yes,
is
and I have to show only thing that there are mercantile documents.
That means
there are mercantile documents that are.
The other side is not here. What can be done?
We will give a notice to them. Where is serve a notice to them?
I am fixing a date. Inform
My
the
lord,
date.
yes. But date fixing will take as whatever.
Not fixing. I am fixing.
Oh, yes,
another
yes,
date.
yes.
Not date and time.
August actually.
Since appearing for the plaintiff, since none appears on behalf of the defendant. Full stop. The plaintiff has filed affidavit in opposition in connection with GA.com 4 of 2024. Let the same be kept with the record. As none appears on behalf of the defendant, for the interest of justice, the case is adjourned. Let the matter appear on 25th of June 2025. The petitioner, the plaintiff is directed to inform the next date of hearing to the learned advocate on record of the plaintiff defendant. It is made clear that on the date fixed, if the defendant failed to appear in spite of the having knowledge of the date, the applications will be taken up for hearing in their absence.
And in the meantime, if they want, they can file the reply. That whatever this always open to oblige.
Next.
Your Lordship, I appear on behalf of the respondent. It was their GA application, so it was partly heard at the last instance.
You are for the
respondent, Your Lordship.
Yes, hearing, so many hearing has been done. Where is the advocates?
Led by Mr. Sarkar Pankasan.
This is a matter where the petitioner had already made his arguments. Mr. Kumarjit Banerjee was appearing in this matter, had made his arguments, and after that we had given reply to that. They were in rejoinder, where they started taking time, and they have been taking time ever since after that.
Correct.
So many adjournments, If you I'll leave it to your lordship. What would be the fate of this application? They do not even now pray for an adjournment, or some bother to come before your lordship to pray for an adjournment. An application for passing of an interim order in the way of in the nature of attachment.
Correct.
Which was refused at the ad interim stage.
Okay, I'm fixing a date. On the date if they will not come, then I will pass a paper.
I'm grateful. I'm grateful.
None appears on behalf of the plaintiff. Concession suffering for the defendant. It is fine from the record. For the last several days, on the prayer made by the counsel for the plaintiff, the case is adjourned. Though the matter in though the application being J1 of 2023 was heard at length. For the interest of this adjourned, let the matter appear on 26th of June 2025. It is made clear that on the date fixed, if the plaintiff failed to appear, appropriate order will be passed. Next.
I'm grateful, Lord.
I appear for the plaintiff respondent.
Yes.
This is an application for rejection of my plea. Before I take your lordship, Mr. Mitra had concluded his submissions.
Lordship, I'm appearing on behalf of the petitioner. I'm being led by opposite.
They had concluded.
They have concluded our part.
Yes. May I at least start, my lord? Your lordship kindly takes Order 7, Rule 11. This is the only grounds under which a plaint can be rejected. The provisions of Order 7, Rule 11, which applies to a chartered high court for rejection of a plaint, are essentially Order 7, Rule 11A and D, where the suit is barred by law. Well, in my respectful submission, it has not been shown to your lordship that from the averments in the plaint, it can be shown that the plaint is barred by any law. For example, my lord, under Section 10 of the SEBI's Act, in relation to matters relation to SEBI, I make an averment. SEBI is taking action, restrain SEBI. From the averment, it would be clear that it is barred under Section 10 of the SEBI Act.
Yes.
Or, my lord, if I state in my plaint that I am an unregistered firm, I have entered into a contract with the defendant who is not known to me, and this suit is for recovery of money. Straight away from the averments in the plaint, it would be apparent that the suit is hit by Section 69 of the Partnership Act. My lord, in my respectful submission, it has not been shown to your lordship that the suit is anyway barred by any law, by any provisions of law. On the contrary, my lord, after the amendment of the Specific Relief Act, Section 10, the Supreme Court in Santosh Amma's case has said that a suit in respect of an immovable property for specific performance is no longer discretionary.
Yes.
That has been discussed. My lord, may I just give a brief background? My lord, the matter, there was an interlocutory application also which was filed when we presented the plea. My lord, the interlocutory application was disposed of. The entire arguments which were made before your lordship, the same arguments, I will demonstrate from that order of Justice Saraf, that same arguments were made before you, my lord Justice Saraf. Justice Saraf considered and granted me 2 injunctions. First, restrain them from terminating. Second, granted me the mandatory injunction asking them to execute a power of attorney so that the balance work, because the building has already been constructed, the balance work can be carried out. Aggrieved by that, they preferred an appeal. So far as the mandatory injunction was concerned, the division bench was of the view that the mandatory, by granting the mandatory injunction, it would tantamount to decreeing the suit. So, my lord, to that extent, whereby, my lord, Justice Saraf had granted me a mandatory injunction, that part was vacated, but the other part, so far as injunction is concerned, that continued. Now, my lord, if your lordship kindly comes to, my lord, the pleadings, the forms of pleadings, my lord, here, if I plead this, my plaint cannot be bereft of a cause of action. My lord, if your lordship kindly sees the forms appended to the CPC, my lord. My lord, it's Appendix A, form number 47 and 48. That relates to specific performance. That is with regard to immovable property, my lord.
Yes.
This is with regard to sell, but
Form number?
Form number 47. So if my pleading contains this basic averments, it cannot be said that my plaint does not disclose any cause of action. By an agreement dated such and such, he contracted to buy. Here,
yes,
he has agreed to give me possession to develop the land.
Yes.
Well, if it was a simpliciter construction agreement, maybe I wouldn't have had a cause of action.
Yes.
But a certain portion of the constructed premises would belong to me.
Yes.
And described and referred for a sum of rupees. Plaintiff applied to perform, but the defendant has not done so. Is ready and willing to perform. The plaintiff claims perform and do all necessary acts, my lord, and to pay costs.
Correct.
And my lord, also form number 48, entitled to the immovable property. My lord, here I am entitled to percentage of the immovable property which I have already constructed. Sufficient instrument, they do not say that the document is inchoate, has not executed any instrument, ready and willing. So if my plaint contains this basic averments, my lord, it cannot be said that my suit does not, the plaint does not disclose any cause of action and the suit deserves to be dismissed. Now, may I straight away come to the plaint and few paragraphs of the plaint and, my lord, the development agreement. Please, my lord, the plaint starts, my lord, there is a stamp paper, my lord, it's a 50,000 rupees we have given. So, now, my lord, the plaint starts from page 31. Both the plaintiff and the defendants are companies. So, it is not an agreement between two individuals.
Yes.
Now, my lord, if your lordship kindly takes paragraph 4, that they approached us. This might not be relevant because, my lord, prior negotiations are not cannot be looked into once a formal agreement has been entered into. Paragraph 6. And I'll rely on few of the clauses of the agreement. Relying on the representations made by the defendant and believing the same to be true and correct, the plaintiff acted in good faith and agreed to enter into a registered agreement for development on 17th August 2015 on terms and conditions contained therein. A photocopy of the registered development agreement. It's a registered document. It is not their case that it is inchoate. In order, the defendant was required to execute a general power of attorney in favor of the nominee of the plaintiff developer. Because, my lord, I have to apply for sanctions. I have to apply for fire license. Somebody has to do it. While constructing a building, these licenses are required. So the owner does not take the onus on him, and the entire responsibility lies with the defendant. The defendant in this case is a company.
Correct.
So it had to be a director or somebody, some office bearers of the plaintiff. In this case, the power of attorney was given to a gentleman by the name of Mahesh Agarwal.
Correct.
And the building was constructed. He died on or about he died in the peak of COVID, 4th of April 2020. We write to them that the building is constructed. We require certain more permissions are required for KMC to do the balance work. We have also set out what are the balance. 97% of the work has been completed. That is where the dispute starts. They say, whatever you have spent for constructing the building, I am willing to pay it. That cannot be, that cannot be equitous.
Because that's why they have raised the objection only for executing the power of attorney, whether the specific performance.
Yes, I will show I'll show that. Yes. I have an interest over the land also. The company has an interest over the land also. I will show that, my lord. My lord, I will, my lord, here I will skip the clauses from which I have called out in the plaint, and I will show straight away from the agreement what are the clauses. Now, my lord, kindly comes to paragraph 10 at page 42.
Yes.
The development of the subject premises at 1 Upper Wood Street was being carried out by the plaintiff on the aforesaid terms and conditions contained in the registered development agreement, as well as on the strength of the registered general power of attorney executed in favor of its nominee Mahesh Kumar Agarwal to do all such acts necessary for the purpose of obtaining sanction clearance from various authorities to appoint architects, engineers, contractors, valuers, surveyors, and such other acts incidental to or concerning the said development work at the said subject premises. Therefore, at all material times, the parties have acted upon the said development agreement. Therefore, the plaintiff has performed the agreement, save and except the part which it could not perform due to the defendant's breaches. Now, my lord, the next paragraph is interesting because Mr. Mitra has emphasized much on this, that they have given a value. Now, they are not entitled to specific performance. But even under Section 21 of the Specific Performance Act, in addition to specific performance, I can ask for compensation. On account of development of the subject premises, the plaintiff had incurred a sum of rupees 5 crore 33 lakhs 888 as on March 2019, and the further sum of rupees 5 lakhs towards the security deposit against the development agreement between the parties. The said expenditure incurred by the plaintiff would be evident from the audited balance sheet. Now, my lord, here the dispute starts. The work was progressing smoothly until the demise of Mahesh Kumar Agarwal on 3rd April 2020. Copy of the death certificate of Mahesh Kumar Agarwal is annexed here too and marked as annexure A. After the demise of the said nominee of the plaintiff followed up with the defendant on numerous occasions, both verbally and in writing, requesting the defendant to execute the said power of attorney in favor of Meena Agarwal, the nominee director of the plaintiff, in place of Mahesh Agarwal. However, till date, no steps have been taken and no explanation provided by the defendant as regards granting a fresh power of attorney in favor of the nominee to complete it is pertinent to mention that more than 90% of the work is complete and furniture and fixture have been installed. Due to the recalcitrant attitude of the defendant, the balance work could not be completed, though materials worth in excess of 50 lakhs are lying at site. The scheduled property is in exclusive possession of the plaintiff. Due to the wrongful acts of the defendant, the materials lying at the site are getting damaged, as without the fresh power of attorney, the works which are enumerated herein below could not be carried out. Photocopies of the letters, these are the letters. Now, my lord, what is remaining is given in paragraph 15. This is the civil work. My lord, may I also read paragraph 14? In view of such inaction on the part of the defendant, the development work, which has substantially progressed, has come to a grinding halt, as the balance work requires sanction from various authorities and application, which can only be done on the strength of a general power of attorney duly registered by the defendant in favor of the plaintiff's nominee. Because that power of attorney in name of Mahesh Agarwal can't be used anymore. He is no longer in this mortal world, so that cannot be used. So I have to apply afresh.
What are the conditions?
My lord, I'll just come to the clauses of the development agreement, and let me just. My lord, what is to be required to be done, your lordship kindly sees. It's a 9-floor building, completed. The following civil works remain outstanding as on date: exterior work, some exterior work, water tank, drainage, window installation, doors, plumbing, lift line installation, fire plumbing, finishing of common area, mechanical installation. Next, my lord, the plaintiff states that without the power of attorney being granted in favor of the nominee director, the plaintiff would not be in a position to apply for necessary permissions and sanctions which are required for completion of the work under the development agreement. The above work is dependent on the renewal of the building sanction plan, which is due to expire. It had not yet expired then. For the drainage and water line as well as the carriageway, the plaintiffs need to apply to KMC on behalf of the defendant. The plaintiff also needs to apply for transformer for 250 kV HT power supply. Under the terms of, my lord, this is important, my lord, because if it was a simpliciter construction, my lord, my case would not be maintainable. Under the terms of the agreement, the plaintiff has been allocated 35% of the sanction, because there was a bit of history behind it. There was a judgment of Justice Bhaskar Bhattacharya holding that a development agreement, a specific performance for a development agreement, does not lie. It was referred to a larger bench comprising of 3 Justice Banerjees: Justice Sanjeev Banerjee, 3 Justice Banerjees, Justice Indira Banerjee, and Justice Ashim Banerjee, as far as I remember. So Justice Sanjeev Banerjee had delivered the judgment where he said, if it is for a simpliciter construction, specific performance, but when it is coupled with an interest in the property, it can be specifically enforced. And this view has been approved by the Supreme Court by Justice Chandrachud, my lord, that when it is coupled with an interest in the property, it is specifically enforced. Can be. So I have been given 35% ownership, and the defendant has been given 65%. Under the terms of the agreement, the plaintiff is entitled to deal with sale and transfer and enter into agreements for sale and transfer in respect of their respective allocation, for which no further consent of the defendant is required. However, it is incumbent upon the defendant to execute a deed of conveyance in favor of the plaintiff and or nominee, because he will sign as a confirming party. And for such purpose, the defendant is required to execute and register a power of attorney in favor of the nominee of the plaintiff, on the strength of which the plaintiff can execute all relevant documents, deeds, etc. Although
What is the position of the building now?
It's a 9-story building.
Still lying as it is.
It's still lying as it is from 2020, after the death of Mahesh Agarwal.
Who is in occupation?
I am. That's what my instruction.
I'm appearing on behalf. I'm so sorry, man. Video is not functioning. I'm appearing on behalf of the owner and the sole defendant. Well, they have failed to complete the project. That is why the building was lying unfinished. They could not complete the development work, and in the meantime, the license.
Okay. Mr. Sama, I will. Yes.
We are in use, but it is lying idle. Absolutely. Fixtures, furnitures, my lord, and
allotment.
they are exposed to rain.
No allotment,
Nothing.
The permission, only, my lord, only one thing I would like to, the 3-year permission which was given for building sanction and expired. They failed to do the work, that is why it is lying there.
Okay.
Building construction, time is never of the essence, my lord. That also I will show. Paragraph 19, my lord, although the plaintiff is willing to perform its obligation, but the same is dependent on the defendant. My lord, these are the standard. Now, my lord, what have I prayed for? My lord, paragraph 23 is important because this pleading has to be there. At page 47, the plaintiff has been and still is ready and willing. I have to show my readiness and willingness. Now, my lord, what is the prayer? There is a development agreement which is registered. I don't require a specific performance of the development agreement. It was vehemently argued they have not sought for specific performance of the development agreement. It is not required. My lord, what is required is prayer A Roman 1. This is what is important. We have asked for a decree for specific performance of the registered agreement. I have asked for specific performance. But in what manner? By executing a power of attorney in favor of the nominee of the plaintiff, namely in terms of the development agreement. Now, if your lordship kindly comes to the agreement,
Page 137.
which starts at page 137. Well, it kindly takes page 137. This is a development agreement dated 17th of August 2015.
Yes.
And if they say this 36 months, the work continued till 2020, till the death of Mahesh Agarwal. If it is 36 months, then 17th August 2015, 2018, it gets over. And my lord, one more important thing, if my lord makes a note of it, they have never terminated the agreement. They have never terminated the agreement. My lord, between Syndicate Realty Infra, which is the defendant.
Yes.
Now, my lord, page 150, 140, my lord, such and such referred as to as the owner, the expression shall excluded, such and such include successors, represented by its director. It's a company, it has to be represented by its director. Then my lord, with whom? With the plaintiff, Mono Orion Foods India Private Limited, an existing company within the meaning of Companies Act 1956.
So who are you?
I am Mono Orion, the developer.
Because he was the director.
He was the director.
Director.
I am his widow and I am a director.
That's why what is your status? You are also director.
I am a director. But I means the plaintiff is a company. But the nominee in whose favor I have asked for a power of attorney.
The lady.
Yes, she's the widow of Mahesh Agarwal, and she's a director.
She's the one of the directors. Yes. Or after the death, she became the director.
She was a director.
She was the director.
She was a director. Yes. Mono Orion Food India Private Limited, an existing company within the meaning of Companies Act, having its registered office at such and such, Middleton Street, which expression such and such, represented by its director, Mahesh Kumar Agarwal.
Correct.
Now, my lord, few of the clauses, my lord, kindly comes to clause 3.1 at page 146. This agreement shall be deemed to have commenced on and with effect from the date of execution of this agreement. So there is a commencement date. Now, if your lordship kindly comes to clause 5, my lord, 3.2, time cannot be of the essence. My lord, your lordship has come through various judgments. including Hind construction to Bern standard, that in construction contract, time can never be of the essence. This agreement, this is very important. 3.2.
Till such time the entire construction is complete.
Till the entire construction is completed and subject to terms and conditions. But this has to be read in conjunction with clause 5.2. 5.3, I'm sorry, Mike. 5.3, which is at page 147. The developer shall construct and complete the construction within 36 months from the receipt of the building permit sanction of the plan. However, this time may be extended on mutual consent of the parties. This should have ended in 2018, but it continued till 2020, till the disputes did not start, till Mr. Mahesh Agarwal was in this mortal world. No. Okay. Bills were also shown that in 2020 also, till the pandemic broke out, the work was going on. Okay. Now, 4.1, this is where the owner shall execute a general power of attorney in favor of the developer. Developer it cannot be because it's a company, or his nominees, or nominees for the purpose of giving effect to and or implementing this agreement. However, the developer on this base, however, the developer shall on the basis of power of attorney be entitled to deal with and or enter into agreement of the developer's allocation. This is also required because my allocation, if I have to sell of the building to be constructed to the prospective buyers / purchasers and to accept consideration amount from time to time, the owner shall sign and execute the deed of conveyance at the time of registration and it's a bit blurred and
as and when asked by
the developer. All costs of charges and expenses of construction, erection and completion of the new building will be incurred by the developer, but if there is any deposits and or payments to be made to CHC, the same will be shared by the parties in proportion to their respective allocation. This was also required.
This is to be read with 6.6.
And this is to be read with clause 6.6, which is at page 149. The 149.
Yes.
The owners, it's a bit longish clause.
6.6.
My lord. The owner shall execute the deed of conveyance or conveyances in respect of the developer's allocation in
favor of the developer.
Favor of the developer and or its nominee or nominees in such part or as shall be required by the developer, provided, however, the cost of such conveyance or conveyances, including stamp and registration expenses, shall be paid and borne and discharged by the developer or its nominee or nominees. For the purpose of expediency, the owner shall execute and register a power of attorney in favor of the developer or its nominee. So at my instance, he has to give that. Who on the strength of such power of attorney shall be entitled to execute all relevant deeds, instruments, documents in respect of the developer's allocation in name of the owner. So it is not his prerogative. It's my prerogative and he is bound to do it. Excellent.
Yes.
Now, my lord, so far as the allocation is concerned, your lordship kindly comes to clause 6.2 and 6.3, which is at page 148.
Yes.
The owner's allocation will comprise of 65% of the total sanctionable area in the floors as mutually agreed by and between the owner and the developers, which include covered and or open car parking spaces, herein referred to as the owner's allocation. The developer's allocation will comprise 35% of the sanctionable area in the new building and or buildings, which includes covered and or open car parking space, will form part of the developer's allocation in the new building. The owner and the developer hereby agree to identify their respective allocations within 30 days from preparation of the plan and sanction by specifying the same in detail. both the shall be deal to transfer and or enter into agreements or sale and transfer in respect of their respective allocations for which no further consent of the other party shall be required, and all sales proceeds shall belong to them respectively. Now, my lord, if your lordship kindly comes to clause 10.6. That is at the next volume, my lord, it's at volume 2.
ये वॉल्यूम 2 का है
Wait, my lord, mine is bit 10.2.
10 point.
My lord, 10 point. I will just show 10.6 first, and then I'll come back to 10.2. Each of the parties shall be entitled to enter into the agreement for sale and transfer of their respective allocations, and it will not be obligatory on the part of either party to be party
to pay
to any agreement being entered by any party or with any
any intending purchaser and
intending
its agreement by itself.
and shall be treated as the consent. So what is required?
Yes.
Now, my lord will kindly see. This is where I require the power of attorney in favor of Meena Agarwal. It is understood from time to time to facilitate the construction of the building by the developer, various deeds, matters and things.
Not herein specified.
Not herein specified may be required to be done by the developer, and for which the developer may need the authority of the owners and various applications and other documents.
May
I ask my junior to read it out? It would be
may be required to be signed. To be signed,
To be signed or relative to which
relative to which specific
provisions
may not have been mentioned herein. The owner hereby undertakes to do all such acts, deeds, matter, and the owner shall execute any such additional power of attorney.
Even an additional power of attorney they were required to do. They are required to do under the agreement. And to my nominee.
To my shall. The emphasis on the word shall.
Imperative on him. The word is shall.
Page 150, clause 7.1.
Yes.
Now, shall execute any such additional power of attorney and or authorization as may be required by the developer for the purpose, and the owners also undertake to sign, execute all such additional applications and other documents as the case may be, provided that all such acts, deeds, matters, and things do not in any way infringe on the rights of the owners and or go against the spirit of this
I have
agreement.
not asked him to do that. I have asked him to execute a power of attorney so that the building can be completed.
The owner shall hand over all the certified copies of the sale deed, conveyance, or documents, any documents related to the said premises. The owner shall also hand over all the papers, documents of the pending cases referred above to the developer.
Yes.
Now,
If your lordship kindly reads this with clause 7.1, which is in the earlier volume. I am troubling your lordship with
150. 150 page.
It's the last page of the last volume, earlier volume page.
Yes.
This is specifically on power of attorney, and I'll just show the power of attorney after this.
Yes.
On execution,
Power of attorney 179 page.
on execution of the agreement, the owner shall execute a general power of attorney in favor of the developer's nominee directors for the purpose of obtaining the sanction of the building plan and necessary permission, approvals, and sanction from different authorities in connection with the construction of the said new buildings, and also for pursuing the and following up the matter with the Kolkata Municipal Corporation, Urban Land Ceiling such and such, Pollution Control Board, etc. for sewerage connection such and such. Malad, this is what is to be required
for the purpose of urban. Yes.
What is the purpose? The said premises keeping the totally indemnified. Now, my lord, apropos this, my lord, a power of attorney was executed in favor of Mr. Mahesh Kumar Agarwal, which is at page 177, volume 2. I am seeking enforcement of this.
Page 1.
Now, my lord, clause 179, after the recitals.
Yes, this is not denied. With regard to the power of attorney, it is not only their contention.
It cannot be given to Meena Agarwal,
correct,
and the period of construction has
is
expired.
over.
But the contract says that I can ask for further power of attorneys, and it is my prerogative to ask for it for the purpose of completion. Until date, there has been no termination. It is to continue. Your lordship has seen the clauses. It is to continue till the construction is concluded, as is completed, and the time may be extended by mutual consent. Understand? Now, my lord, we had filed an injunction application. My lord will kindly
Page 240.
Now, my lord, I had written them letters. Despite that, there is no response from them. The letters your lordship will find.
When when you given the letter to the defendant after the death of Mukesh?
After the death of Mahesh Agarwal.
When?
2021, my lord.
এখানে আছে very very illegible. এখানে রিসিপ্টটা আছে, পোস্টাল রিসিপ্ট লেখা আছে।
Receipt is here.
Page 222 তে।
228. This was on 9th of August 2021. When they received. When they received. Before that, we have signed.
আর এই যে 228 এ এসো, ট্র্যাক রিপোর্টটা আছে।
Mahesh Agarwal, my lord, had died in Singapore, the midst of COVID. And there was a lockdown, restrictions and everything.
Yes, page 223.
Later 228 is
But even an email I had sent, which would be evident at page 233.
This was in July, and in the letter also we have stated that more than 90% of the work has been completed.
And we have stated in these letters.
Yes.
90% of the work has been done. So, my lord, that injunction application was filed.
236 page.
My lord, the notice of motion would appear at page 236, and the prayers of the notice of motion is at page 237.
Yes.
Order of temporary injunction, creating any third-party rights in respect of the subject interfering with the or to enter into agreement from executing any fresh agreement. My lord, this part where 238, an order of mandatory injunction directing the respondent to execute a power of attorney. My lord, this was also granted by Justice Saraf, which was set aside by this press C was set aside.
Only that portion.
Only press C was set aside, not A and B.
Only because it would be.
It would tantamount to, because the division bench held that it would tantamount to decreeing the suit.
Only that's why we did not get it.
Now, my lord, the argument, the order starts at page 243. Push. Order of Justice Saraf starts at page 243.
Yes.
The same arguments, same judgments.
What taken as defenses to the interim application and dealt with.
Please, I mean, comment it. Page 243, your lordship will.
So the mandatory injunction was the division bench set aside.
Set aside. But
Correct.
there A and B was not set aside.
Not set aside. So now what is your prayer in this application?
It is their application. But the same prayer, same arguments made in a interlocutory application was considered and rejected. And on the basis of that arguments, they are seeking for rejection of a plaint. Now, my lord, will kindly see arguments at page 245. Mr. Bachawat was leading me. He is still leading me, my lord. My lord, we rely, your lordship kindly comes to paragraph 4 because they had taken that point of 36 months.
Yes.
My lord, will kindly, I will not read the entire order, my lord. His construction is referred to in paragraph 4, argument of Mr. Bachawat. Now, my lord, then paragraph 5, that after the amendment to the Specific Relief Act, it is no longer discretionary in respect of an immovable property whenever interest. This is now reported in SCC, but that time it wasn't. I'll give your lordship the SCC reference, my lord.
Yes.
Then, my lord, the Calcutta High Court was, I think it was a Maniram Bangur was a division bench judgment. Now, my lord, kindly comes to paragraph 7 onwards. The same arguments. This I will read out. Mr. Such and Such, appearing for the defendant, argues that the register does not create any right in the property and the development agreement is not an agreement for sale because no stamp duty has been paid by the plaintiff as per such and such. Further, it is argued as per section 14B of the Specific Relief Act. This was exactly what was argued before your lordship. The contract which involves the performance of a continuous duty is not specifically enforceable. The defendant relies on Sushil Kumar Agarwal, reported in 2019 to SCC 2.1 to state the specific conditions as mentioned in 14(3)(c)(1 of the Specific Relief Act are not fulfilled by the plaintiff, which would allow the relief sought by the plaintiff. Subsequently, it was submitted by the counsel for the defendant that the development agreement was dependent on the personal qualification. What personal qualification? Do I need any personal qualification to apply to CMC or to the fire brigade? The defendant's power of attorney holder. The defendant does not have faith. My lord will kindly see. Does not have faith in personal qualification, though there is not a single letter, no response to my letters of qualification, whom the plaintiff wants to be appointed as a new power of attorney holder of the defendant. Hence, 14C, which states that the contract of which performance is dependent on personal qualification, is not specifically enforceable, would be applicable in the instant case. Next, my lord, this is what again Mr. Sharma had argued this morning. The counsel for the defendant submits that the contract for the development expressly comes to an end on expiry of 36 months from the receipt of the sanction plan. He primarily relies on 14D of the Specific Relief Act to state that the nature of the development contract makes it terminable. Thereafter, it is submitted by the defendant that the time is of the essence. He places reliance on Venkateshwara versus Jugal Kishore, reported in AIR 86 Karnataka, and more particularly quotation from Supreme Court in Keshavlal. These were all related to sale of goods, my lord. Furthermore, the defendant submitted that by virtue of mutual consent clause for extension of development contract comes to an end, as both the parties did not mutually extend the time period beyond 36 months. I have bills to show that it was going on till...
clause for termination in the contract?
There is no clause for termination. In any event, they have not terminated. He relies on an Anandram such and such to buttress this argument. Subsequently, the defendant avers this time that the time is much of essence in a contract for transfer of immovable property, as in the case of movable property. He relies on this, but not this also has been relied before And then paragraph 10, the defendant further place the judgment passed in Ambalal Sarabhai to contain amendment of section state expressly excludes explanation N, which has earlier created a presumption that breach of contract to transfer an immovable cannot be adequately. This has been considered in Santosh Amma, my lord, which I will rely on. Now then he places on Sushil Kumar Agarwal. These are all the judgments which has been placed before your lordship. Now, my lord, the 249 starts, my lord, the decision of my lord Justice Saraf. My lord, it's already 150. Okay. No, he considers all the clauses which your lordship will find at page 250. The entire, my lord, may I carry on?
Okay, next.
But when do we come back?
कल फिक्स है क्या कुछ कल फिक्स है
Lordship, any other date apart from, kindly do not keep it tomorrow, any other date apart from tomorrow.
So suffering for the plaintiff, so suffering for the defendant. Counsel for the plaintiff had argued the matter at length, but due to paucity of time, hearing could not be completed. Let the matter appear on 19.
Lordship. Great.
Pleasure to fix any time.
Time there is no. At the top. 19 June 2025 at the top. Thank you.
Prepare.
affidavit of evidence. Judges brief we have prepared. I am seeking some accommodation, my lord.
Why you persons are not mentioning earlier the fixed matter? What will the court will do for the
Yesterday
1 hour?
Appeared, I couldn't come
You
yesterday.
could have been yesterday. You could have been mentioned, but you are not mentioned. So what will do the court for 1 hour? No advocate will be appear here because the fixed matter is there. What will happen to the court's time?
I'm very sorry, my lord.
Okay, pay the cost. And the matter was fixed.
Yes, I should.
2nd April it was fixed. 2nd April order, the case is fixed today. After 2 months, the matter has come. More than 2 months, 3 months is going to pass. 2nd April.
Apologize, my lord.
Okay, pay the cost, then no problem. Fixed matter, it is very difficult to this court. Now nobody will come. What the court will do for 1 hour? So and suffering for the plaintiff. The matter is fixed today. The matter is especially fixed today for witness action by an order dated 2nd April 2025. Today, when the matter is called, former learned counsel for the plaintiff press for time on the ground that he has not prepared the affidavit examination in chief of the witness as well as the witness is indisposed. Considering the submission made by the counsel for the the plaintiff had the knowledge that this court has especially fixed the matter for witness action. But in spite of the same, the plaintiff failed to inform the court that the plaintiff will not adduce the witness on the date fixed. And when the matter is called, only the plaintiff has informed this court that the plaintiff is not able to adduce the evidence. Considering the submission made by the counsel for the plaintiff for the interest of justice, the case is adjourned subject to payment of cost of rupees 20,000 to the listed legal service authority within a period of 1 week from date. List the matter in the combined monthly list of August 2025.
Yes.
Next.
Judge's brief of document let that be kept on record.
The judge's brief of document filed by the plaintiff be kept with the record.
May it please, Your Lordship. In item number 33, my lord, I am appearing for the defendant in the matter, for the plaintiff in the matter, my lord, and for the respondent in the application. This is an application which has been filed by the defendant, my lord, for revoking an order which has been passed by this honorable court on 1st of March 2024, where, my lord, the matter was transferred to the commercial division. My lord, if your lordship is pleased to take up that order of 1st March, my lord, my learned friends were represented, and my lord, in their presence, this order was passed.
1st March.
1st March, my lord, 1st March 2024.
Yeah, order na 1st March. 1st March 24.
24, my lord. May I read it out, my lord? It's a 2-line order. Actually, four lines, my lord. Suit shall be transferred to commercial division since the dispute involved in the suit is commercial in nature. And my lord, they were represented. Mr. S. Jhunjhunwala, my lord, had appeared for the defendant.
Correct.
Now, my lord, they take out a petition, my lord, challenging that this is not a commercial suit, it's a non-commercial suit. Affidavits have been exchanged in the matter, my lord. And my lord, we have filed our affidavits. It's ready for hearing, my lord. We are ready to make our submissions.
Yes.
Defendant number 1, my senior is appearing.
Who is your senior? He was here morning.
Yes, madam. Kindly keep it, madam. Next week, madam, we'll argue this matter.
My lord, I'll not stand in the way, but on the last day, my lord, 16th of April 2025, my lord, second page, there is a recording in paragraph 7. My lord, I'll not make any submissions. I'm just indicating it to the honorable court, my lord. I'll not make any submission. I'll not stand in the way, my lord.
Conditional order.
My lord, kindly keeps for the last time.
What will happen to the conditional order? Have you gone through the last order?
Yes, my lord.
Kindly go through the paragraph 7 of the order.
My lord, I have to go through it. My lord, kindly keeps it next week, my lord. My lord.
I can fix, but what will happen to the last order? There's a conditional order.
For the last time, my lord.
Milord, I'm not standing in the way, Milord. I am leaving it to your lordship.
Census and suffering for the plaintiff, census and suffering for the defendant. Defendant has filed the present application being GACOM 8 of 2024 for recalling of the order dated 1st of March 2020.
It's 1st of March 2024.
21st? 1st of March.
But 1st of March 2024, my lord.
2024. Police counsel for the defendant waits for time. It is fine from the order dated 16th April 2024. This court is clear that if the defendant failed to appear before this court, the application will be taken up for hearing in the absence of the defendant. Though when the matter is called today, the defendant is present for his press for time. For the interest of justice, as a special chance, the case is set. Let the matter appear on 2nd July.
I'm very deeply obliged, my lord. Deeply obliged, my lord.
34, my lord, I appear for the plaintiff. My lord, it was the defendant's application for reference, my lord, under Section 8 and for production of the arbitration agreement which the defendant was arguing.
Oh, plaintiff.
Yes, plaintiff.
My lord, may I be permitted to... My lord, the Rajeshri Roy and Asif Hussain is out of town, my lord.
Huh?
Mr. Asif Hussain, the counsel in this matter, is out of town, my lord. So I'm praying not this week, my lord.
Where is Mr. Datto? He is appearing.
Yes, he is also
There,
not
he is
here.
in the court premises only.
I have been told by Mr.
Swami is
Asif Hussain.
appearing in the matters.
Without Asif Hussain, he won't.
Without Asif Hussain, he cannot argue.
Yes, my lord.
But the interim order is expiring today. Should we
Your
extend that?
interim order. Swan suffering for the plaintiff, Swan suffering for the defendant. Counsel for the defendant prays for time. For the interest case is adjourned. Counsel for the plaintiff prays for extension of interim order. Interim order granted is earlier is extended till 17 July 2025. Let the matter appear on 14th of July 2025.
14th of July.
14th July.
May it have some precedence. I'm not asking for fixing of any time because then it will go to August.
So now it is come up.
If it could be
14th August at the top.
14th July.
14th July at the top.
Man, I'm grateful.
Much obliged.
I appear for the defendant, my lord. This was my application, my lord, for dismissal or return of the plaint because the my lord, it was my contention that the dispute were not commercial in nature.
You are for the defendant.
I'm for the
Who
defendant.
is for the plaintiff?
But Mr. Nilan, you know, Neelad Das or someone was there.
Ajit Banerjee.
Yes.
Neela Sengupta.
Nilesh Gupta, sorry. He was there.
Yes. Have you gone through the order?
The division bench judgment, my lord, I have gone through. But if your lordship wants, my lord, I can address your lordship on that point.
But other party is not. No, what your contention is it is a commercial.
No, it is not. I had taken out an application for dismissal of the suit or in the alternative return of the plaint. But that, my lord, they
wanted to go through
the plaintiffs, my lord, on last occasion had relied upon a division bench judgment wherein the division bench
it cannot be dismissed, it can be transferred.
But that was in the special circumstances of that case, firstly, and secondly, my lord, under Order 41, Rule 33, my lord, that in an appeal, the division bench has wider powers than my lord.
No,
I have come. I can address your lordship on that one.
Kindly come to the page 12. Page 12, paragraph 21.
22.
Paragraph 21.
Yes, my lord.
Paragraph 21. The last 1, 2, 3, 4, 5, 6, 7, 8, 9. Ninth line from bottom. Paragraph 21.
Can be exercised in absence of any provision.
Thereby, it is clear that the commercial division is an extended arm or another wing of the ordinary original civil jurisdiction of the High Court. In such circumstances, a plaint originally presented could be transferred in exercise power to the commercial division, which is in fact a wing of the very same ordinary original civil jurisdiction of the High Court, and vice versa.
Thereafter, Lordship, may I place paragraph 22. That firstly, this discussion is for the purpose of deciding the extension of interim order till it is presented before the commercial division. For that purpose, this discussion was made. Thereafter, paragraph 25. The defendant has already, what in appropriate cases, so what was the case before the Honorable Division Bench? May I place that? The defendant has already filed its written statement and there is no requirement to serve a fresh writ of summons upon the defendant. In this case, that is not so. I have not filed because I had taken out this application and not filed my written statement.
That's correct.
The learned,
That's
so
correct.
let the-
Petition is of 2025.
That's
This
correct.
petition was filed.
Yes. When the matter is called, you not come. When the other party is arguing the matter, then you started in between.
Thereafter, the learned single judge is requested to consider the pleadings already filed in relation to injunction and summary judgment and decide the issues on the basis of such pleadings.
Correct.
The
That
parties are
is
not
with regard to the injunction, no, because this could.
But in these circumstances,
in such circumstances, the plaint original presented could be transferred in exercise of power of commercial division.
Yes, but in this case, we have not filed the written statement. So he has to take out if it is transferred, it will be from this stage only. So I will be deprived from filing a written statement.
No,
Because
if it is transferred, then you can make an application. What if it is a non-commercial division, non-commercial suit, so there is no mandatory provision. You can make an application. The court can allow you. There's no, and you will get the opportunity of this.
This is the latest case status.
29, paragraph 29. Nevertheless, the suit was actually returned. In view of the return of plaint, the suit shall now be
Returning the plaint of the plaintiff filed in the commercial can be considered as deemed to have been filed in the original. That is the problem. That's why, see, my contention was 12A from the non-commercial to commercial, it can be.
Yes.
But here there's nothing because there are so many procedures. It has to be written, then because this procedure cannot be adopted. And in this commercial division, only for transfer in the commercial matters. But the division bench has come to some findings how this thing upon this court.
One thing, in paragraph 18 onwards, Lordship, the division bench has already held that it cannot be, there is no provision for any transfer because this is not a pending. May I just place this? In the instant case, both the parties have.
Paragraph 19.
18.
18.
Page 9.
Yes.
In the instant case, both the parties have agreed that it is not a commercial dispute coming within the purview of Section 21C of the Commercial Courts Act. The court has also independently come to a finding that it is not a commercial suit. In such a situation, the plaint is required to be returned to the plaintiff to be presented before the competent court. This power is exercised under Section 151 for the ends of justice, as Order 7 Rule 10 is not applicable to the Chartered High Court in view of Order 47 Rule 3. Look, there is no difficulty. Under 151, Lordship can and under 151 transfer this. Return the plaint, although it is not applicable to the Honorable High Courts. The plaint shall be deemed to have been filed before.
With due respect, that is also not correct. That has been amended subsequently.
Perhaps I had one researched on this. Perhaps that amendment was only for Andaman and Nicobar. Subject to correction, because I have found I could not readily find out that notification, but at one point of time
I have dealt with one matter.
I am not.
I have dealt
that
with
notification is not readily available. But that notification, if I remember correctly, was with respect to Andaman and Nicobar High Court.
No, here I am dealt with, and the same.
Because there are
okay,
older
whatever
judgments also by division by Justice Shonji Banerjee recognizing this, that it is not applicable even much after probably in 17 or 2017 or 18, that it does not apply.
Okay. The plaint shall deemed to have been filed.
The plaint shall be deemed to have been filed before a court not having jurisdiction over the subject matter, and the only mode by which a party can continue with the cause is to pray for return of the plaint so as to enable the plaintiff to present it before the appropriate court. If at any time it appears to the court on the averments made in the plaint itself that it has no jurisdiction, either pecuniary or territorial, or over the subject matter, the court can suo motu direct return of the plaint. In the instant case, continuation of the suit in commercial division would be before a court without having jurisdiction to decide the suit, as it is treated as an ordinary suit. Consequently, a decree would be without nullity. The commercial division cannot decide a commercial dispute. Thereafter, Lordship will kindly take paragraph 19. The return of the plaint cannot be equated with the power to transfer the suit or application, as the case may be. It is not akin to power of the Honorable Chief Justice or a district court judge to allocate work to various judges, including transfer of a case. The return of a plaint is a judicial order. The suit could not have been transferred in exercise of the statutory power under Section 15 of the Act. The suit was not pending on the date of commercial division of the High Court becomes operational. For a suit to be transferred after it is instituted, after a commercial division is constituted and made functional, it can only be in exercise of powers under Order 7, Rule 10, and the Chartered High Court under Section 151 of the CPC. So, the division bench has upheld that it cannot be transferred. The only way is it has to be returned.
Correct.
Under paragraph 21, now the division bench gives the judgment. In paragraph 21 is the division bench actual consideration.
Yes,
They say that the it has to be
what I'm saying is, with the deepest respect, the appellate court perhaps under Order 41, Rule 33 has wider powers than the suit court. May I just place this for my benefit, this is what I was Order 41, Rule 33, power of Court of Appeal. The appellate court shall have powers to pass any decree and make any order which ought to have
Order
been
41?
Rule 33.
Yes.
May I please? The appellate court shall have power to pass any decree and make any order which ought to have been passed or made, or to pass or make such further or other decrees or orders as the case may require. And this power may be exercised by the court, notwithstanding that the appeal is as to part only of the decree, and may be exercised in favor of all or any of the respondents or parties. Although such respondents or parties may not have been filed an objection, I'm not going into that. So, under perhaps it was in appeal it was possible, but after his lordship's having held in paragraph 18 and 19 that it can not be transferred, and the only way is it has to be returned. Perhaps it was not the intention, or at least not would appear from the judgment that it was this power was also interpreted
but
to be
21. However, it cannot be overlooked that the commercial court has no independent existence and is closely connected with the ordinary original civil jurisdiction. Where the High Court is having the ordinary original civil jurisdiction, the Chief Justice of the High Court may, by order, constitute commercial division having one or more benches. Thereby, it is clear that the commercial division is an extended arm of the another wing of the ordinary civil jurisdiction. In such circumstances, plaint origin presented could be transferred in exercise of power commercial division, which in fact the wing was very ordinary original civil jurisdiction of the High Court, vice versa. So here also it cannot be transferred, but the plaint is to be written and it has to be filed in the
yes, plaint can be. I was originally my prayer was for dismissal. That I cannot say anymore.
Correct.
It has to be written under 151. It can be written.
Plaint is to be written.
Yes.
It cannot be given to transfer. The same number will not carry.
Yes.
It has to be returned.
It has to be returned, and he can present it again before, and whatever limitation he faces. Yes, return. I'm not standing in the frame. Perhaps I cannot
My
check
lord,
it
may
as
I
far as
show the
return is concerned.
recent case status, the case status of the appeal, the suit that was transferred to the non-commercial. The commercial suit was renumbered to an ordinary suit. That has to be done. Now the plaint has to be returned. It will be before the master.
Correct.
I will do, but my injunction will stand. Whatever interim order I am enjoying right now, it will stand.
If the plaint will return where
But in the order itself, it has been written that
That
the
is
interim order.
perhaps where the powers of an appellate
the
court
appellate
cannot be
court, how this
equated
court can say the
with,
My lord,
with
my
humility. I
injunction
say this,
application
my lord.
is also there. My injunction application will also change the color as said in the division bench order. It has been stated in the division bench order regarding the injunction application. My lord, may I place the relevant paragraphs. Paragraph 24 onwards. In the instant case, we find that the plaintiff has been enjoying an interim order. On returning of the plaint, the pleadings filed in the commercial division can be considered as deemed to have been filed in the ordinary original jurisdiction for the purpose of interim relief and other reliefs, as the provisions of the original side rules shall now apply in deciding the suit and the application. It is really a matter of conversion. It is now required to be heard by the honorable judge in the non-commercial division. The defendant has already filed the writ statement. That is thing. The learned single judge is now the learned single judge is requested to consider the pleadings already filed in relation to the injunction and summary judgment and decide the issues on the basis of such pleadings. The parties shall not be prejudiced by such direction. The interim order the plaintiff was enjoying stands vacated by reason of the return of plaint shall continue for a period of 4 weeks, as we find that the refusal to extend the same would cause serious prejudice. On the plaint being represented, the parties shall be at liberty to file additional pleadings if necessary. The pleadings filed in the commercial division can be considered afresh upon the suit being presented before the learned single judge. That is the direction of the honorable division bench. Now, in my matter, my learned friend has failed to file in opposition. My lord has blocked the filing of the opposition because repeatedly they have failed to file it. It was vacated. That liberty was given, that was vacated. That they cannot file opposition. Now, when the matter will be transferred to the non-commercial division, it has been clearly said in the division bench order that they will get opportunity to file additional pleadings. They can file their opposition in that.
Automatically, see,
They will get benefit.
Once it has withdrawn and given and returned and it has been filed before the appropriate the new guidelines.
It will benefit them only. It will benefit them only.
The order 7 rule 10, it's treated to be a fresh suit. But
It will
they may
benefit them
get the
only.
benefit of the limitation.
My
That is a
learned friend's
separate.
client will not be prejudiced by the transfer, or else it will be better for
So
them.
the question is not whether I will be prejudiced or not. The question, my lord, in my humble submission is whether there is any power to transfer.
Division bench has laid down the power,
the
laid
division
down the
bench
guidelines to be
has
followed.
powers,
Now
my
my learned friend cannot change the division.
The
challenge
division
the
bench
division
has
bench
nowhere
order is
held
there.
that this powers, my lord, whatever has been held in paragraph 24 and 25 can be, my lord, exercised by any court. It was not such interpretation. Perhaps, my lord, subject to being corrected.
But this is the direction of the division bench that has to be.
Yes, in that matter.
Where is the application? GA1?
No, my lord. Yes, my lord. GA1. GA.com 1 of 2023. That is appearing in the list also.
No, GA1 is the judgment upon.
Yes, judgment upon admission. There I have got an injunction interim order.
Ours is GA4.
No, with regard to this transfer.
Transfer is GA4.
GA4.
Yes. So it can be returned.
Returned. Lord, I'm not standing. I was filed for dismissal of the suit, but it can be returned.
Return, and my lord will kindly protect me by standing 3 weeks time or 2 weeks. The division bench order says it, my lord. But there has not been said that it cannot be allowed. It cannot be. It has not been said. My learned friend is now challenging the division bench order and twisting the terms of the condition, my lord. It has been already said that the injunction application.
So suffering for the plaintiff. So suffering for the defendant. The defendant has filed the present application being GA.com 4 of 2024. Praying for rejection of the plaint and dismissal of the suit on the ground that the suit filed by the plaintiff is not connected with any commercial disputes. Counsel for the plaintiff has drawn the attention of this court to the order passed by the appellate court in APOT 63 of 2025 with a review RVWO number 31 of 2024 in CS Com 384 of 2024 in IA GA Com 1 of 2025 within brackets Sudarshan Prasad Bangaria and another versus Harshvardhan Thimka and another dated 26th of March 2025, wherein the Honorable Division Bench has held that set out paragraph 19, ठीक है, 19, 20, 21, 20. Considering the judgment passed by the Honorable Full Stop, the plaintiff is submitted that if this court will return the plaint, he has no objection, and he will file the said plaint before the appropriate court. In view of the submission made by the counsel for the respective parties, and considering the judgment passed by the Honorable Division Bench, Supra.
My lord, only one thing. My lord has said that the plaint will be returned and I have to file it. But that is not the direction of the division bench, my lord. My lord,
If you return what, well, it will go.
my lord, kindly see para 29 once of the judgment. Para 29 once of the judgment. Kindly see. In view of the return of the plaint, the suit shall now be assigned a new number.
That is in
My lord may pass the direction. My lord has to pass the direction, or else the new number will not.
I have not passed the operative portion of the order.
Yes, my lord. That is
I passed the operative portion of the order.
The file appropriate division, my lord, that has not been given. The department will do that.
Let the matter go out of the.
No, my lord. My lord, kindly not do that, my lord. My lord,
go out of the.
I'm only placing, my lord. I did not hear, my lord.
Yes.
Kindly not do that, my lord.
Call the matter.
My lord, kindly not do that for my inconvenience, my lord. Kindly.
Defendant.
I appear for the defendant, my lord. My lord, I had filed
this matter, my lord.
I filed a counterclaim, my lord, along with an application under Order 38 Rule 5. My lord, the defendant's Order 38 Rule 5, the plaintiff has used an affidavit in opposition, but my reply is not yet ready. But you'll kindly grant me a 10 days time. We'll file the reply to the opposition filed by the plaintiff, my lord. And my lord,
when you file the opposition, Mr. Shah?
21st.
21st of May, my lord.
My lord.
Since suffering for the plaintiff, since suffering for the defendants, counsel for the defendants, prays for extension of time to file affidavit in reply to the affidavit in opposition. Let affidavit reply be filed within
10 days, my lord.
In 10 days. Let the matter appear on 26th June.
My lord, similar direction may be issued. My lord, I have not filed an opposition in GA3, which is the plaintiff's application for extension of time to file their additional written statement to my counterclaim.
GA3?
Yes, my lord. GA2 is there, GA3 is there. GA2 is my Order 38 Rule 5. GA3 is the application of the plaintiff seeking extension of time to file their written statement to my counterclaim. Lord, I need 10 days time to file my opposition to that application, my lord. If it's so kindly, if your lordship is pleased to consider that.
For the defendant, prays for time to file affidavit in opposition in connection with Com 3 of 2020. Let affidavit file within 10 days.
Yes, my lord.
10 this within 2 weeks, comma reply if any there to be filed within a week thereafter. ऊपर जो date बोला change करो. Let both the application, that is GA2, whatever the GA1.
Pleadings complete.
But GA1
is
pleadings
my
are complete.
application, my lord.
That's Mr.
Yeah,
Shah's
that can also be
application.
that
All-
can also be heard finally, my lord.
Let all the application be placed before this court on 8th of July 2020.
Grateful, my lord.
Grateful, my lord.
This matter, my lord, we are out of time to file the opposition to my learned friend's application for addition of party. My suit, they want to be added as a party. My lord, I have to file my affidavit. My lord, kindly.
Actually, they don't have any objection, my lord. They cannot have any objection.
Till now.
Suit of
Let us
this
see.
nature.
Let us see.
Till now, there is no objection.
The draft of my affidavit is ready, my lord. It will be affirmed.
It will always be ready.
Can we also have
Yes.
Mother, kindly see the date of direction in a simple, innocuous application for addition of party.
ঠিক আছে, ঠিক আছে।
When you want to bring it on record. I understand that Mr.
Now, they
Datta-
want to restrain the other advocates to appear in the matter.
Yes.
This is
They already have
so
they already
grossly
have their suit.
unfair. So
They have
grossly
their suit
unfair.
agitating their suit. Why
Acha,
can't
my
my
suit I will agitate. His suit he will get a decree and walk away.
against your principle?
Yeah. So
You have
that's
been
that's
inducted.
well. When in eviction proceedings,
GA5.
5 and 6. 5 and 6.
5 is substitution, addition of party.
5 and 6 are both addition of
Six are also.
Yes.
two applicants, my lord?
Two are separate applicants, my lord.
How soon you will file?
they are out of
1
time.
week, my lord. 1 week.
1 week.
1 week.
You are also.
It's ready. So 1 week.
1,000 GMs per day. So that's 1 week 7.
It will not come to you, don't worry. Not that you need it also.
So and so applying for the plaintiff. So and so applying for the defendants. And so and so applying for the applicants of GA5, GA-Com 5 of 2025 and GA-Com 6 of 2025. Counsel for the plaintiff and the defendants prays for extension of time to file affidavit in opposition in connection with GA-Com 5 and GA-Com 6 of 2025. Let affidavit in opposition be filed within a week. Reply, if any, there to be filed within a week thereafter. List the matter on 8th of July.
8th July.
In GA1, my lord, the interim order is still today. Oh, sorry, in GA3. Let the interim order be extended.
Interim order is extended till 10th of July 2025 or until further order, whichever is earlier.
कब रखना?
10th.
8th July.
No, my lord. 8th July instead of 8th. Well, if your lordship keeps it on the 9th or the 10th.
Okay, 10th, 10th and the interim order is extended till 14th of July.
My lord, 10th, 11th, I won't be there. My lord, personal difficulty.
Okay, keep it on 15. Interim orders in 18.
Very well, 15th.
15 and 18.
10th to tomar crucial.
Yes, next.
Eta to.
39, my lord, I beg to appear on behalf of the plaintiff petitioner. One application is pending under order 13A, my lord. They were supposed to open their arguments, rather continue with their arguments, my lord.
You are appearing for?
Lordship, Mr. Cord is appearing for the defendant. Was supposed to appear for the defendant. He's engaged in another court. I'm praying for not today.
Then, my lord, kindly fixes up a date, my lord.
Any day, Lordship.
Since April it is going on.
Yes, my lord.
They have concluded on 24th of April. Defendant has started the argument on 24th of April. Thereafter nothing. Now 2 months has been passed.
Lordship, Mr. Cord has instructed me that he will take only 15 minutes. So, Lordship can fix it any day.
So appearing for the plaintiffs. So appearing for the defendants. As per the prayer made by the counsel for the defendants. Case is adjourned. Let the matter appear on 3rd July.
3rd July, my lord. Kindly fix up a time, my lord. If
Time, then you come on August.
very well, my lord. We'll come back on 3rd July. Grateful, my lord.
Yes.
But it's a
Amendment in the written statement.
It's defendant's application for amendment in amendment of the written
But due to positive time has concluded, is but due to here for the you have to argue.
I am for the plaintiff, not.
Yes, you have to argue. They have concluded.
I'm led by Shubhankar Nak.
Huh?
I'm led by Shubhankar Nak. He's on the way, my lord.
Now, my lord, in the this matter, my lordship would remember, this was once decreed. This suit that was filed in the year 2014 as a regular suit. Then, my lord, matter proceeded. There was a judgment upon admission. Then, from that, there was an appeal. In the appeal court, it was found that that judgment was not right, so it was set aside. But at that point of time, the Commercial Court Act had already come into force. So the suit was then in the appeal court was transferred and converted into a commercial suit. And by that order, the defendant was directed to file the written statement within particular date 2019. Now, my lord, thereafter that date had expired. The defendant did not file any written statement. We being the plaintiff, after the COVID-19, the lockdown got over, we mentioned the matter, and we, as a commercial suit, we proceeded with that suit because there was no written statement. Issues were framed, not issues were not framed, but charges issue of document was filed, evidence, and then the decree was passed. But when decree was passed, they filed an application for recalling of the decree under Order 9 Rule 13 as it was an ex parte decree. Now, in the Order 9 Rule 13 stage, they argued and they lost. Then there was an appeal from that order. In the appeal court, a stand was taken that the written statement, which was directed to be filed in 2019, was already ready, but could not be filed. In view thereof, the appeal court said that very well, since written statement was ready, they shown a written statement was ready, they should get a chance to defend.
Achha, that one?
Yes. So then they got a chance to defend. So then matter came back before this thing, in fact, my lord was sitting in court number 41 at that point of time. So what they then tried to do, they tried to produce a absolutely new written statement before your lordship. That was rejected. Then they again went back to the appeal court and said that the old written statement was in the different form because it was in the regular division form. That is why, and the person who had affirmed that written statement was no longer alive, so they can't file it now. And then the appeal court had said that, be that as it may, whatever you have and you had shown us, file that. Then, if law permits, you may file application. That is application is the appropriate step according to them. The amendment. Now they are trying to amend their written statement, which they said that they had prepared in the year 2019. Now, lordship would find that the documents that they have shown in this new amended application for amendment.
GS7.
This is blood.
GS7.
GS7 blood. Yes. GS7. Yes.
Yes.
Now that written statement did not have many documents. In this written statement, in the in the schedule, in the amended and the proposed amendments, various documents have been shown. Lordship would find that at pages 53 onwards, 57. The proposed amendment starts at page 39. Sorry, the page not page 39.
Proposed amendment we have indicated in a
42.
supplementary affidavit. I have disclosed that on last occasion because there was some mistake. So we have given a supplementary affidavit.
Yes, yes.
Yes.
Supplementary affidavit copy আছে দাও।
Lordship will find there we have indicated the change and also the statement of truth which is mandatory under the Commercial Code Act. Supplementary affidavit and video just to help করছি। Lordship will find page 18 statement of truth is given and prior to that the indication what are the changes I have indicated also that is the supplementary affidavit. The documents may be in the application of course,
No, I am
but
not,
this is has to
I am not yet on the added part of the, I'm only saying that what are the new documents, what are the documents that they now want to file with the written statement. Because Lordship has to consider, because this according to their own stand, this was ready with them in 2019. Now in that page 57 are the list of documents that they want to show now. With the, they want to file with the written statement. Page 57. List of documents relied upon by the defendant. Lordship would find that all these documents, all of them, whichever they want to show, want to produce now, are prior to 2019.
But this document has not been in the original
No,
written statement.
no.
Then this is
was
not the
there.
list.
No, not this was not there.
Where is the earlier written statement? You disclosed in an affidavit.
I think I have disclosed that.
subject to correction, Malat. In earlier, Malat, we never used to disclose any documents.
Not disclose, but the list of
If
documents.
annexed, you should have annexed, and list of documents always has to be there.
Not to annex and disclose, but you have to
Yeah, of course, give it.
আগে
List
যে
of
পুরনো
documents.
রিটার্ন স্টেটমেন্টটা যেটা ছিল,
List of documents.
যেটা আগে এটা ছিল।
Yes.
No, Lordship would find, in fact, that can be figured out from these documents itself, because here this is the new one that they want to use. If had it been there, they would not have disclosed this as the proposed amendment.
Okay.
This list, I'm not saying list was absent. There was a list, but without all these many documents.
Correct.
Oh, they only had 3 documents. I'll find out from my record that I'll give a copy in the before your lordship. ওটা এখানে না করে রেকর্ডে খোঁজো, ওখানে তোমার কাছে আছে। Now, these are the documents Lordship would find. All these documents are pre-2019. It is not that they had now after 2019 they have found out these documents and that is why they could not disclose it at that stage and now they are producing. I am arguing on the point of amendment. That in the amendment they have to say that they were bona fide, they were bona fidely carrying on with the proceeding, and despite their best effort they could not file the correct written statement. That's why the amendment is required. That is the stand in all amendments, irrespective of commercial, non-commercial. Here, their stand is that now, interestingly, prior to this suit, there was a winding up proceeding under Old Companies Act. In the winding up proceeding, that was a contested proceeding. They had filed their affidavit. So my case, whatever I have in my plaint today, I also place the same case in that winding up proceeding. And they had disclosed their defense in the winding up proceeding. Considering that defense, my winding up proceeding was relegated to a suit. And accordingly, the suit was filed. So the case that I have narrated in my plaint is not a new case that they did not know is coming on in 2014. They were from 14, they were all along aware from 2012 onwards when the winding up proceeding was going on, that what is the case I am making out. And these were the documents, 2008, Caesar list, the SGS, India Private Limited Defendant letter, the debit note, all Lordship would find 2012. This was the company proceeding matter, which they want to now want to show before this court. Except 2 orders of 2013, which are matters of record. Orders yes, those are available in the server, public documents, and the copy of some document of 4th July 2023. This, I suppose, is another order of 2023 by which they are allowed to. Most likely, this is the order by which they are allowed to participate. Now, all these are new old documents which they did not disclose. Now they are disclosing. Now, apart from that, let me kindly place the proposed amendments that they want to page the proposed amendment that they want to now introduce. Page number 43 is the first. So So, my lord, according to them, now according to them, this suit is barred by limitation. This is a point of law. Then, my lord, gross suppression and material facts. Thereafter, my lord, page number 45, 44 end. They are giving explanation why that document, which they are now annexing Caesar list, they could not do. Kindly, these are the pleadings. There is nothing. What is the new pleading that they want to introduce? That if not allowed, will prejudice them. What is that pleading? Page 45, paragraph 4. It is stated that the goods level 20 were of the deficient quality and were not commensurate with the requirement of the specification of the said goods required by the defendant, as indicated in the purchase order. The invoice was received by the defendant at a time when the quality of the said good was not ascertained, and it is denied that the invoice was received and accepted. Then in the same paragraph, they say the price of iron ore is based entirely on the content of the iron ore. If in the iron ore finds the price of rupees such and such as agreed. So these are the new part which he is now. Now Lordship would find this part, paragraph 4, the new added part is তোমার মেইন অ্যাপ্লিকেশন থেকে এটা একই আছে কি দিয়ে দেখো supplementary you have not changed this part. How can you change this part in supplementary? Anyway,
that supplementary I am placing. That is the amendment thing.
Supplementary.
Now this is not.
But my learned friend has said that not to look after for these pleadings, not to look after.
Because I argued on the basis of this way, the confusion will be created in Lordship's mind.
But that is my point, that that once I file a application for amendment of written statement, I affirm it, saying this is the proposed written statement I want to disclose in the court, and then I file a supplementary affidavit and a new written statement is now being filed. The first two paragraphs are same, page supplementary page 8.
Yes.
Then the portion that I was reading from other, that is that Lordship would find that at page number 10 of the supplementary affidavit as paragraph 4.
Yes.
This is the pleading that they want to introduce. They are now, after these goods were supplied in 2008, February 2008, Lordship would find paragraph 4, they themselves will write. Invoice 2008, February. Now, Millard, after from 2008, they took, now in 2025, they took Millard all these years to realize that these goods were bad. And because of that, there was denial in payment, and accordingly, the suit was filed. This defense was all along available with them. From 2008 onwards, there was company petition, there was prior suit, which now is converted into a commercial suit. The prior written statement is there. All along, this defense was available with them, Millard, but they could not produce the defense. What is the explanation for this? This is what, Millard, we have to figure out. I am, so far as the other amendments are concerned, those are mechanical. I am not, Millard, considering them. More or less, Millard, why annexures, pleading in support of annexures, those are there. I am not considering that. Kindly now see their explanation in respect of the pleadings which they say were missed out from incorporating in the written statement. What is that explanation? That is my question, Millard, that I am asking to myself. Kindly take their application, Millard, up to paragraph 8. These are, Millard, procedures which took place. Then, Millard, in paragraph 9, they say talk about security. Then paragraph 10, these are not at all on the explanation part. I am saying, Millard,
paragraph 13 onwards.
Yes, paragraph 13. Kindly comes to paragraph 13. The said written statement was not in proper form and was also not commensurate with the requirements of Commercial Codes Act, read with such and such. That apart, the present management of the defendant, after going through the said defendant, discovered that certain relevant facts germane for the effective adjudication of the present suit has been inadvertently omitted from the said. This is the explanation. The present management of the defendant. Company is same, new directors, maybe managers have been appointed, they feel that all the facts are not properly pleaded. Can that be a ground for amendment of written statement? That's the question that I'm asking to myself. According, if Lordship, I'll place the order 6 rule 7, Lordship kindly sees whether that is permissible in law or not. But whether they have a right in amendment or not, that's besides the point. They have to first show that they come within the purview of the section. Statute doesn't provide so. Change tomorrow, my company management will change and I'll come with a different absolutely new different set of facts.
Yes.
If this is permissible, then if no suit will ever end between corporates, because there will be new management in every corporate after some time or the other. Yes. And in every case, they will say that now new management has come. So old, whatever I have written, please forget. Let me come with new case. Apart from that, Miller kindly sees the paragraph 15. This is, the Lordship would remember, I said the old written statement that they admit in paragraph 15. Order dated hence passengers, the Honorable Court was pleased to observe that written statement was prepared and was kept ready. The said written statement, which was affirmed on 12th December 2017, contains 11 pages, whereas defendant had now filed written statement, which cannot be accepted as the Honorable Division Bench by order dated hence gave liberty to the defendant to file written statement, which was already affirmed and thus no written statement was filed. So 17, in 2017, they admittedly had a written statement. These facts were not cleared there. Absolutely new defense is being now raised regarding quality of the goods. So far as there lies my second limb of my argument, that whether if a party through pleadings, I am saying that I have supplied you goods, you are supposed to make payment of X amount of rupees. He nowhere has said that the goods were defective. He did not make payment. So I proceed with the suit, and there lies an admission of onus on their part. The moment he introduced this new defense that the goods were bad, he is trying to withdraw that admission which is there in the written statement. So that was my ground for objection, that a written statement you are already prepared and shown to the court. After showing to the court, you cannot withdraw your stand. That was your stand recorded in that written statement, that you can't change. Amendment.
No, they have not prayed for any deletion of the earlier statement.
Yes, they're adding. They're adding.
They're intending to add.
Yes, they're adding. They're not deleting. They're adding.
They're adding.
Yes.
So think on that way, because this was filed, this written statement they have prepared or supposed to be filed in the non-commercial division.
Yes.
Correct. And in the non-commercial division, there was no provision or there is no mandatory requirement to give all the documents in the written statement.
Yes.
Subsequently, when they have been allowed to file by the appellate court, while allowing the defendant to file the written statement, by that time the case has been transferred to the commercial division. Rightly or wrongly, whatever it is, so they have been allowed to file the written statement, which they have disclosed before the division bench.
Yes.
And they have filed that. Now, as per the new provisions, as per the Commercial Court Act, because the written statement was affirmed in terms of the old provision and original division, now they have to comply with the Commercial Court Act. So they have to disclose the document. Now, whether what would be circumstance of what at present, what would be the faith, how the defendant will bring the document on record?
But so far as the documents are concerned, if they want to disclose, only disclose documents, subject to that, with deepest of respect, probably we, for the sake of objection, we may object, but without.
Correct. That's
ultimately documents I can't stop.
Because if it is filed in the commercial court and they not file the written statement subsequently, then
it is now in this present circumstances, because the appeal court has those documents I cannot stop. I have shown those list of documents for the purpose of indicating that nothing new is being brought into record. So far as documents are, it is not that with new documents they now come to know that the goods were bad. All documents they are showing are old documents which were there in their custody from 2008 onwards. But the pleadings that they're adding is new.
Okay.
I am restricting
on the pleading.
Yes. That paragraph 4, the supplementary affidavit paragraph 4 at page 8, page 10. That those new, they are now introducing this case. Documents, if the amendment is even allowed in part, Lordship can allow the amendment in part. Lordship can allow them to allow to make reference of these documents at the time of trial. Those are not. I cannot probably oppose that legally, but so far as these pleadings are concerned, there should have been sufficient explanation why those pleadings were not there in the original written statement. I have shown that one paragraph which says change of management, new management. It is also not their case that the old management was not diligent or the lawyers were not properly advised. That's not their pleading. They said that the new management now thinks pleadings were not sufficient. That is their case. And paragraph number, there's another paragraph here, paragraph
17.
number 70.
17.
Paragraph number 17.
And then 21.
And then 21. 21
seeking the document.
The document. 21 I'm not, but because.
Yes.
Yes, paragraph 18. In the written statement affirmed on then such by Shishendu Rashuduri synthesis, certain relevant pleadings have not been made which are extremely germane for the effective adjudication of the present suit. No explanation. Why these pleadings were not there? What happened on that day? This person and this written statement was with them. They did not file it in the court. They showed it to the appeal court. All these while, it was never pointed out to any forum before any court that the written statement did not contain all proper pleadings. And thereafter, there is no explanation of a single line regarding their silence or regarding their omission of these particular pleadings which they are now introducing. That this is the core objection that I am making. So I am threefold. One, the amendment which they are bringing, they are introducing new facts on the basis of old documents, which means the facts were already known to him. Therefore, those facts ought to have been treated in the original written statement, which they did not do. There is no explanation why those facts were not properly pleaded. Only explanation provided is that the new management feels that something more has to be pleaded. If that is the stand, then no litigation will ever come to an end between the corporates, because in every matter, new generation new management will come and say that we want to change the facts. That's not permissible in law. Now, Order 6, Rule 17. Kindly, Lordship takes the Order 6, Rule 17. Under what circumstances this is permissible, Miller?
Yes.
Just give me 1 second. Yes. Yes. Order 6, Rule 70 is the provision for amendment. The court may at any stage of the proceeding allow either party to alter or amend these pleadings in such manner and on such terms as may be just, and all such amendments shall be made as may be necessary for the purpose of determining the real question in controversy between the parties, provided that no application of amendment shall be allowed after the trial. This is at this stage. So, they have to say that what is the real question that could not be adjudicated in the absence of those proposed amendments. And they also have to show under what circumstances they failed to give these pleadings at the right time. None of these are. এটা বলা হয়ে গেছে এটা বলেছি one more thing, Lordship asked me the old written statement. This is the I'm carrying a copy.
Yes, no.
Only 2 documents were there. I just but in document time anyway no. So this is
That's all.
Now, yes. So, in that circumstances, since in the absence of any explanation in support of the amendment cannot be as a matter of court. Somebody cannot come into a court and say, I want to amend, and that won't be amended. There has to be some requirement, and that requirement must be established and must come out from the pleadings of the parties as content, not from the submissions of the counsels from the bar. So even if my senior friend from the other side comes and tries to give an explanation, that should not be considered. But there are two cited and there. On the earlier occasion when we argued this matter, before the coordinate bench, some judgments we already cited. I don't want to repeat my just indicating the points and the judgments, so that otherwise again I'll have to make the same submission once again and with waste of time. I am indicating the point. Lordship would find the judgments on record.
Which one, Sudhir Kumar?
In fact, I can file the notes that we prepared in the and this note contains those judgments. Copy kindly come to page 5 of the notes. Yes. These are the points of law that.
Yes.
The case of the petitioner, the defendant. So, these are the points that argued. A, B, C, D, E, F, these 5 points. Arguments in rebuttal, that's me, plaintiff. First point that I am arguing that delay in making this application, 2017 written statement amendment in now they are trying to get in 2024. The second point is bar under provision of Commercial Courts Act. The Commercial Courts Act says if it's a commercial court, all everything should be filed at the, and in 2017 the commercial court was already in place. In support of that contention, I filed this application. We have cited these 2 judgments. 2022 SCC Online Delhi 2099 and 2021 Volume 13 SCC 71. These are on the point that since in 2017 the Commercial Court Act was already into place and the appeal court prior to 2017 had already converted this suit into a commercial suit. Their written statement, which they say was ready, that should have been made into the commercial form, into the form of the Commercial Courts Act, and therefore should have been filed at that stage. Since they have not done it at this stage, they should not be permitted to file it. The appeal court now has nowhere said that the amendment has to be allowed. The appeal court only said if law permits, only then. Now, whether law permits or not, that your lordship is deciding. Now, the next point that we have already argued is that the liberty granted by the court is subject to judicial. This liberty of the appeal court is subject to judicial scrutiny. Not because the liberty is there, they will get a absolute right. That's not there. So that in support of that, 2020 Volume 16 SCC 230. I have mentioned the paragraphs. I am not repeating. It is on that point that if liberty does not mean a right, liberty only if it is already permissible in law. If their application for amendment is permissible in law, only then. Liberty does not give them any further favor. And the next point is that the amendment of written statement cannot be permitted, deprive the plaintiff of valuable right which has accrued in favor of the plaintiff. This is in the context, the new pleadings, that the goods were defective. Those were absent in the written statement. A right has, this is advantageous, this if the old written statement is taken on record.
Okay, I will see.
So these 2 judgments on that aspect. And the other 5 judgments that I wanted to place. But since in order to save the time of the court, only this. And the explanation point which I have cited. So far as the only last point that they had cited, 2 judgments or many judgments on this aspect of amendment of written statement. Also on the context that the admission can be explained subsequently, although that was not their case. Be that as it may, we'll file a one-page supplementary note considering those judgments which subsequently has been referred by them. These are my submissions.
In short reply,
How much time?
5 minutes. Won't take much time. Lordship first, they have tried to portray before your lordship that we have discussed a lot of that. If lordship takes the old written statement, some things have been given. Now, 2 documents written, but it is not really 2 documents. What might be like learned folks say. When copy of the written statement, kindly have a look at page 11, and apropos to this, kindly come to page 16 of my application. Now, lordship is
Page 11, my lord, all written statement.
I'll take your lordship.
Yes. Page 16 of the new of my application or the written statement.
Yes.
Present written.
Page 11.
Page 11 of the old, page 16 of the new written statement of the documents now I want to design. My lord, everything will be clear. My lord, we'll find first is the cost papers of orders of APOT 271 of 2071. That is the
Now,
one.
with regard to the documents,
So that is gone. Now, my lord, second is white. Second is documents as correspondence with Soneco Marketing Limited. That is the plaintiff. So, my lord, the debit note and everything also comes.
That's why. See, with regard to the documents, I don't think they are objecting so much. Only with regard to the pleading, how the pleading can be allowed at this stage.
Now, my lord, this proposition which my learned friend is arguing, my lord, is so element. Now, my lord, written statement was prepared, which could not be filed, and the order was also passed under old act.
Correct.
So that is why now it has to be decided as a new thing.
Hmm.
Now, my lordship sees, now, my lord, if I am preparing something and found something which is very relevant for the proper adjudication of the case, this is not a very elementary proposition of law. Now, my lord, if lordships find that yes, the controversy is this, that if that is why a short debit note was issued, not entire amount was paid, is defect in the goods, well, the lordship has to, the court should allow it. And the lordship sees they have objected
No,
to paragraph.
that's why you have to give the explanation.
Well,
Why you have not stated all the things in the earlier written statement? Only by changing your managing committee cannot serve the purpose. So tomorrow you will change another managing committee will come.
Lordship ignored that part.
Where is your explanation? Show me the explanation.
Explanation 13 and they have taken 13 and 18 place.
Show me the explanation.
So come to 13.
Yes, 13 we have
Present
gone through.
management.
Correct. Present management.
Certain relevant facts. German for
When the present management has come. When you have shown the old written statement to the appellate court, your written statement was ready and the appellate court has accepted your written statement. That you have not disclosed all the things.
Paragraph 18, Lordship.
Yes, I have gone through each and everything.
In the written statement.
Because see, your cases you have not filed. They got the ex parte decree. You challenged the ex parte decree. You went to the appellate court. In the appellate court, it stated that, sir, my written statement was ready. I may be given chance. Court, on the basis of your written statement, set aside that ex parte decree, send back the matter to the this
Not
court.
only set aside ballot, I have secured the entire.
Whatever it may be, and you stated that at that point of time also the court you have not prayed before the appellate court. No, my lord, this required some correction. You stated that my written statement was ready. Just a minute. Then you come to this court. You wanted to file the new written statement. This court was not allowed. Correct. Then you went to the appellate court. Appellate court stated that if the law permits. Now you tell me, 2017 you have affirmed the written statement. You appeared before the appellate court. In the appellate court, nothing was done. You have not prayed that yes, that written statement was not correct. That's why it could not be filed. You have taken the benefit of the old written statement, which was affirmed by your client prior in the 2017 itself. Correct. And 2022, you got the order from the appellate court. 22.
Recorded in the appellate order as well as.
And you're telling that the managing committee, you have not stated that yes, this managing committee after have joined after the 2022 when the division bench has passed an order.
This person who was legally in charge, who has affirmed this, he died during. And thereafter this order passed. That is also recorded in the appeal court order.
No, that's correct. That's why he died. That is subsequent because when he died.
He died during
COVID.
So
and when you got the order? When you got the order? After the COVID? After the COVID, the new person has come. You might have been gone through that when you made a submission before the division bench. My restatement was written statement was ready.
Well, to be honest, before the lordship on that, before the appellate court, the endeavor was, my lord, to get the order set aside by securing that company and to file the statement. Well, when we really looked at the written statement, and when we, my lord, lordship is in the process of taking the written statement, my lord, only one point, my lord, that needs, my lord, explanation, and that is necessary is, my lord, the goods are defective. My lord, SGS report.
Okay, you show me the letter. You have given the letter prior to that the goods were not were defective. Where the communication?
I will come back on next. I have
in the document which you are relying upon, now you wanted to introduce, you have sent a notice to the plaintiff stating that your we already informed in 2017 itself that the goods were defective.
Lordship, in that event, I have to come back. I have to come back before your lordship and show the earlier pleading that, well,
because that is not the document which you want to introduce here. There is no such document that you have informed the plaintiff that the material which was supplied, that was not up to the mark.
Well, I will come back, well, because, well, kindly come to page 108. That is there. It's not there. Well, kindly come to 108. Lordship will find an earlier letter. Well, here, well, Lordship sees there was a report indeed of 2008 in respect of the quality of the goods.
Request for providing report.
Lordship,
Where is that?
Where
is that your the good was not up to the mark?
My lord, Lordship will come by page 58.
Okay, you come on the next day.
Next day, I will satisfy your lordship on the fact. On the fact, my lord, only on this issue, my lord, I will come.
So appearing for the plaintiff. So appearing for the defendant. Counsel for the plaintiff has concluded his argument and filed written note of argument in connection with GS7 of 2024. Counsel for the due to paucity of time, the counsel for the defendant could not give reply to the submission made by the counsel for the plaintiff. According case is adjourned. Let the matter appear on 2nd July.
Lordship?
2nd July.
Lordship. Only on this point I will come.
Lordship, perhaps my learned friend had handed up a copy of the
old written statement. I am grateful to you.
Yes, next.
Your Lordship. Your Lordship takes up the 3 p.m. matter, Your Lordship. Item number 41, the next matter, Your Lordship. I appear for defendants number 1, 2, 4, 5, and 6, Your Lordship. I will pray for an.
Okay, let.
Will I appear in item number?
Yes, 10. Yes. In this matter, I appear for the defendant.
What has happened?
The amendment application was heard, disposed of. Some amendments allowed, maximum not allowed. But only thing is that order was passed. Yesterday we received the copy, so I have to draft my amendment plaint and I have to file on 27th June. So, Lordship, there were 4 GA. First was his injunction application where ad interim order is still existing. It has been extended from time to time. GA2 is my application where I have prayed for his interim order to be vacated on the score that there is non-compliance of order 39 rule 3 and B. GA3 is my section 10 application, which is the main application according to me to decide whether the suit will continue or the suit will be stayed for. And GA4 was his application for occupational charges, which as of now, Lordship has passed an order that 50,000 rupees per month you go on giving with arrears and all this thing. So, Lordship, regarding the occupational charges, current the per month we are paying. No,
areas not paid.
Areas not paid per month. Even yesterday also some money has been paid. Be that as it may, Lordship, what I was praying that my GA2 can be taken up because GA2 is unnecessarily pending. Whether it's
what is the GA2 section 10?
That is that it's non-compliance. It's a small issue. That,
3A.
3A and B. Whether non-compliance is at all, if is there, and if it is there, then whether is entitled for interim order or not.
Okay. And with regard to the injunction application,
that main application is pending. That we have filed our affidavit has been exchanged.
Have been completed.
Injunction because
I think GA3 is the stay of the suit. That has to be heard out first. That is the
demurrer, section 10, GA3.
GA3
is a
no,
demurrer. GA3
GA3
section 10, but GA section 10
GA3 is vacating the stay order.
Just is GA2.
Acha, GA2 is the vacating stay.
Vacating is pending for long. That's the reason I am saying, my lord, my injunction and GA2 is obviously the.
And GA3 ka?
GA3 section 10, which
GA3
I was. I'll tell you, lordship,
No, but if his interim order is obtained, if he is not complied, how would be allowed to be extended? That is my question. I'm disturbing.
If this court satisfied the section 10, then automatically.
That is true, lordship. But now section 10 is only thing which is now standing in between me and my friend.
I'll tell you.
That I have to file my amendment plaint.
No. That what happened, I have to tell you.
What the amendment is
these
allowed?
These are the two amendment applications before the City Civil Court, my learned friend. And this is what is the order passed. I'll just explain, my lord, in. Now she will, after the recording in the order, the ordered portion, the last page. The petition dated 29th of August, I've handed over. Under section order 6 rule 17 is allowed in part on contest without any leave to the amendment. The next page, the amendments mentioned in item 1, 2 and 3 of the schedule of the amendment application. So the petition of 29th of August, the first one, to the extent which is allowed is 1, 2 and 3. One is with regard to some FSI license. The amendment is the schedule. Yes. The 2A and 2B of the plaint, FSI license. 2B is they had another business at Kumotuli Sheva Shomiti in Bagbazar. Second is with regard to the principal agent of Tiswa's Kitchen. And 3 is once again Calcutta Brew. What was not allowed is the other rest of the, including a prayer. This is exactly the prayer which he wants the main amendment, but it was not allowed. So 1, 2 and 3 were allowed.
Yes.
So these and 4, 4, 5, for the 2, 4, whatever, 4, 5 and 6 were not allowed. So on these 3 were allowed, and so far the other application is concerned.
Total dismiss.
Absolutely. So on this score, I say, and now if we lordship's pleasure to see my prayers in the present suit,
So now the section 10 can be taken up.
No, section 10 can be taken up. Because had these been allowed, then the situation would have been a different. I must be candidly saying to your lordship. Now the section 10 can be taken. That has to be first taken, section 10.
Now, lordship, my friend has correctly pointed out whatever has been passed. Now the thing which was like lordship, if he's saying that section 10 is there, there should not be other application should not be considered. It's a demurrer application.
No, not that. This code is also of the way because
that occupational charge was considered by section despite my section 10 pending.
Correct. That's why I'm telling. If the section 10 is taken up,
Correct.
if this court find that this suit is to be stayed.
The thing, lordship, to be very honestly and very, this should be unofficial, but the thing was disturbing whether this amendment has reached to my satisfaction or not. The court can decide. The court has got the power. I'm just appearing from a client. Now, whether I will accept it and file my amended plaint or whether I'll go to the upper court.
That is different.
So we'll just take 10 days time to decide all these things. So if your lordship, my date is fixed in the trial court is 27th June for compliance. I've even, to be very honest, I prepared my amended plaint. I have not wasted time. But I was just consenting because yesterday itself the order was passed. We have received the order. Lordship, if I start with section 10, and subsequently we realize with my client sitting there, no, you go and challenge in 227. So where will I stand?
So you do one thing. I am fixing it in the month July.
I'll tell you.
Fix it on 2nd July. Will I not delay lordship?
There is no object of doing the matter. He will go to 227. Then we'll go to Supreme Court. So you cannot forecast something and not do a matter. This matter was kept after the.
When I was making submission, he stopped me. So please don't interject.
You will not do the matter.
Don't interject.
That is the only thing.
Lordship, only I'm requesting this court to fix on 2nd July. Because 27 is my compliance. If my client agrees, if we discuss, we take some opinions, so we'll go. Otherwise, probably, lordship, it's not that I'm not satisfied with the part amendment of my plaint. Because I think somehow I have also reached my target, which I wanted. So only this thing. Now that order 39 rule 3 and B is a small application. And he's enjoying the interim order despite
blatantly non-compliance of the order direction of, the mandatory provision of 3 and PN.
See, now there are two limbs. One is with regard to your section 10. If your section 10 is allowed, automatically all goes. If your section 10 is not allowed, then you are this GA3.
And even if you also kindly remember, even occupational charge I pointed out, because I cannot canvass my case in according to my satisfaction. Lordship said, look, now your section 10 is pending. Since you have admitted there was some money was to be paid, so I'm passing this order. In view of that, if this section 10 is rejected, you can come with a supplementary affidavit or something like that.
This court is telling, because
Lordship, that is
now the two limbs. One is with regard to section 10.
Correct.
If your section 10 is allowed, we don't know. After hearing, the court will decide. Automatically, all will go.
Correct.
All will go. If it is not, then you are with regard to the interim order.
Interim order and even occupational charge, I will again revive back with my
you can
first.
continue with the occupational charge, or the interim order is to be
That's
made
true.
absolute or is to be vacated. These are the things.
Kali, don't make it a long. I just 2nd July I'm asking. It's not. It's 20 days time I'm seeking for. In the meantime, hopefully we'll take a conscious decision. To probably we will contest the matter. On 2nd July, I am paying his current money. It's not that
2nd July, he will come up and say, I filed
227,
which is item number 500 in the list.
I will fix on 15 or 16 July. I will fix on 15.
And he will not allow me to
15 or
proceed
16
with the
July.
suit also
If
by
you
this section 10.
Filed also, see, 227 filed, no stay, so the court can continue with.
That he will come and say, 227 filed.
He's saying I will not have to proceed with the suit. I have not received the copy of the suit
I
till
don't
date.
think in the 227
He has not served me with the copy of the suit till date.
In this type of the order, the court will take much time.
No, there's order in the motion state will take around 1 month to be called.
No,
1 month in the motion state. That's the reality, my lord. Now he will keep on taking adjournment.
My client is paying
today, and he is enjoying my property off
I
Park
was paying
Street.
30,000 rupees per month. Now I'm paying
He's
50,000
not
rupees.
paying me 10 lakhs of rupees the area.
Come on, 15.
No, he will not do the matter.
Come on, 15.
I'm
Otherwise, I will take your hearing.
You are saying 2nd July, you became a soothsayer saying I will not do the matter.
Matter was fixed on today to do the matter. He lost in section 10. He will not do the matter.
Section 10 I've lost.
Suffering for the defendant.
I've lost section 10.
List of counsel for the
He
defendant submitted the implementation application
কোথায়
Leonard City Civil Court was allowed in part. And the compliance of the order of amendment is fixed on 27th of June 2020. According counsel for the plaintiff for fixing the date of hearing of all the application hearing on 2nd of July 2025. Counsel for the plaintiff raised objection and submitted that one or the other reason the defendant is taking time and is not to argue the matter so that the matter can be expedited. At the learned counsel for the respective parties, this court party for the interest of justice, the case is adjourned. Let the matter appear on 15th of July 2025 under the same heading.
3 p.m. Lordship.
Same heading.
But I have a small request to Lordship. Lordship, kindly take the plaint once. Without the beyond the applications. I am facing a bit of a difficulty, my Lordship. No, the interim order is still today. Sorry.
Interim order is extended till 18th of July 2025 or until further order whichever.
Now, my Lordship, see the cost title once. There's a typographical error in the cost. Lordship will see this CAC, the partnership firm.
Where?
The first page.
CAC.
CAC. 2 is Rajiv Chand. 3 is Miss Anisha Chand. 4 is Varun Chand. And then it's gone down defendant number 2 with 3 and 4. So this should be the plaintiff. Now, for this, the department is because that is only mistake. And then versus Shutapa Ganguly and other things has been there. So for this is the only difficulty we are facing in the department. I don't know.
How the department has accepted the print.
That
now application and do is this.
No.
I will not object to that application.
I know, but making this. Well, will kindly give me the leave term.
No, Lordship. This should be done to the proper correct because
come with an application contesting.
You have to submit the copy again.
Contesting come.
Grateful, Lordship.
Yes, call them.
Grateful.
Lordship, in item number 41, I appear for some of the defendants, Your Lordship, 1, 2, 4, 5, and 6. Your Lordship, I'm praying for an accommodation.
Milord, I appear for the plaintiff. Milord, no issue, Milord.
Your Lordship,
Whenever she wants.
Mr. Dasgupta is not objecting.
No, as long as I am enjoying Milord the interim order, why should I?
interim order is till June 26th, Your Lordship. I'm praying for 10 days accommodation, Your Lordship.
Have you filed the affidavits?
Yes, my lord was hearing this matter. My lord, in the midst of.
When suffering for the plaintiff, when suffering for the defendant.
Which one? That Coal India? Steel Authority.
Steel Authority, yes, yes.
Vital number plate.
Yes,
yes.
49 and 50. Clause 49, 50.
When suffering for the defendant number 2, 4, 5, and 6. 2, 4, 5, and 6. Counsel for the defendant prays for accommodation. For the interest of justice, the case is adjourned. Counsel for the plaintiff submit that the interim order may be extended. In view of the submission made by the counsel for the respective parties, the case counsel in view of the submission and the let in view of the submission made by the counsel for the plaintiff, the interim order is extended till 18th of July 2025 or until further order, whichever is earlier. Release the matter on 16th of July.
Great.
My lord, it extended the interim order, my lord.
18 July.
My lord, oblige. Oblige.
From the verified account.
I think there's some mistake.
Yes.
Lord, I am for the plaintiff, my lord. My suit, Lord, Lordship was hearing IAGA 2, which is the defendant number 2's application, wherein, Lord, they are essentially praying for a direction upon the plaintiffs to serve a copy of the, Lord, Order 11 application, Order 11 affidavit, my lord, which is supposed to go with this plaint. My lord, it is our specific contention that along with the plaint, all the documents had been, Lord, given to my learned friend's clients. Lord, my learned friends have to show, Lord, and this is my respectful submission before your lordship, Lord, that the defendant number 2 has to show as to what steps he has taken.
You are appearing for?
Lord, I am for the plaintiff.
Acha. Yes.
Lord, so, Lord, my learned friends need, Lord, it's their application GA2. Lord, they have to show what steps they have taken. Lord, to ask us if it is actually true that they have not been served with the affidavit under Order 11. Lord, they have to show what steps they have taken. Lord, absolutely no steps taken. Lord, they write to us only after expiry of the
GA3 for extension of time.
Lord, I don't know who's appearing.
GA3. You are appearing for whom?
I am for the plaintiff, defendant number 1 and 2.
Defendant number GA3 is disposed of. That is a performer defendant. GA2 is pending.
My lord, I will.
You are appearing for the defendant number 2. You are appearing for whom?
Number 1 and 2 actually appeared.
Yes, my lord. I am appearing for defendant number 1 and 2.
And you are for the 4. Who is for the 3? So you file this as GA2.
GA2.
For what?
Lord,
for my lord. I am led by Borun Kothari, who is absent. My lord, I am.
Mr. Kothari was there on the last occasion.
Yes.
Affidavit on reply.
Fine. Yes.
My lord, fix a date for hearing.
Every matter hearing date fixed. What the court will do, since morning only the administrative order is passed. Not today, next week, next month. Which document is not served?
Which document?
Lord, may I assist your lordship, Lord?
Immediately
Lord, kindly.
Where is Mr. Kothari?
Total is here.
Okay, come to
a few minutes ago.
Lord, in answer to your lordship's query, lordship will find at page 4, paragraph 3 and 4. Lord, that is the application. My lord, what has not been served? Order 6, Rule 15A, my lord, the statement of truth. And my lord, lordship will find Order 11, Rule 1. My lord, they say that these were not served to them. My lord, on that basis, they contend that my time to file my written statement has not even commenced. My lord, they need to show before your lordship and through documents as to how diligent they've been, my lord, in pursuing this, because, my lord, admittedly, my lord, the sheriff has served them on 4th October 2024. My lord, we also as plaintiffs, my advocate on record, they have also served, my lord, the defendant number 2. My lord, so therefore, my lord, they need, my lord, and your lordship will find from the application as also from the rejoinder or the affidavit in reply, not one single document to show what diligence they've exercised from the date on which they were served with the copy of the, my lord, plain. My lord, I'll address your lordship, my lord, since your lordship is... Yes,
It's not here. Record a note. Census offering for the plaintiff, census offering for the defendant 1 and 2. And census offering for the defendant number 4. As per the prayer made by the counsel for the defendant number 1 and 2, case is adjourned. Let the matter appear on 24.
Lord Lordship.
24 July. 24 June.
Great.
Next.
Item number 43, I am for the
Respondent number 12. I am for the respondent number 11, HDFC Bank.
Lordship, I was seeking accommodation for the day and tomorrow because the junior counsel who is appearing in this matter is not well, your lordship.
I would like to file an affidavit in this application. Nothing will happen.
We have filed our affidavit for the defendant 11 bank.
Recorded in the order.
There are many, there are 20, more
As per
than
your
20 respondents.
last direction, all affidavits have been filed. The replies have also been
You are
filed within
appearing for
14th of...
You are appearing for?
I am for the plaintiff petitioner, your
For
lordship.
the plaintiff petitioner.
Lordship.
I am for the bank, my HDFC Bank.
Yeah.
My lord, thereafter, since your lordship was not available, my lord, the interim order was extended by Honorable Justice till 16th of June. My lord, I was humbly praying if, my lord, 2 consecutive dates can be fixed for hearing of the injunction application.
28th of Acha.
28th and 29th April at 11:30 p.m. 11:30 a.m.
And my lord, GA2 which has been filed subsequently, that can be heard along with the injunction application?
What is the J2?
Oh, J3. Forensic?
J3.
Sorry, my lord, J3.
GA3 is filed by...
They are asking for a copy of the report. But at this stage, there is no question of giving them a report. Your lordship will be hearing the injunction application. At that stage, your lordship will consider this application.
So matter is fixed on when? Till 16 June.
16 June, my lord, the order has been extended. Till 16 June. Lord, any day, my lord, prior to...
Any day on Thursday, your lordship can keep it on Thursday. Or Friday, whatever is convenient to us.
There are quite a few respondents.
Yes, there are quite a few respondents.
Several respondents are there.
That's why saying that...
lucky that readings are at least complete. I should be on that side, but there's no space there.
I am for HDFC Bank, my lord, for respondent number 11. Kindly record my
My
presence.
affidavit in opposition, and I'm praying for leave to file it, my lord, in GA1. The notarized
Defendant number?
I am defendant number 13.
13.
I'm respondent number 6, my lord. My affidavit in opposition is also.
Of the GA1?
GA1, my lord. Only
yes, GA1.
Your lordship, I'm appearing on behalf of defendant number 18, your lordship. Your lordship, one request. It has been on order dated 28th of April 2025. It has been incorrectly recorded that our affidavit in opposition is not on record. But your lordship, that may be clarified in today's order.
Which one?
My lord, if your lordship can you see the order of 28th order, your lordship. Last
28 April.
Yes, 28th
Yes,
April.
your lordship. Your lordship's paragraph 16.
Your lordship in the your lordship getting page 4,
that Lordship, defendant number 10 and 18 have not filed their affidavit in opposition, Your Lordship. Lordship, we are trying to correct ourselves. Lordship, it was filed on 9.
Where is that? Affidavit है वहाँ पे?
Yes, Your Lordship. It was filed on
Defendant number
13th
10
March,
and
Your
18?
Lordship. It is, well, I'm
Lordship, for defendant number 18 was filed on 2nd of January 2025.
18 का ये वो है?
we have filed on 10th 13th March, Your Lordship. 13th March. Different number 10.
Different number 10 and 18.
ও আচ্ছা, তাই ভাবছি সবাই আছে প্লেন্টিফ।
When you filed?
On 13th March, Your Lordship.
13th March.
Different number 10, Lordship.
Your Lordship, defendant number 18 on 2nd of January 2025.
হয়নি
किसका? डिफेंड नंबर 13 है। 2 जनवरी का तो ऑर्डर ही नहीं है।
If I may place this.
Yes, yeah, na. Defend number 11 and 18 have filed their affidavit in opposition after copy to the judge. The 10 है 18 18 है 12 है 18 है तो रिप्लाई है 18 का यहाँ लिखा हुआ है 11 and 18 filed. You filed in the court or in the department? Madam, you defend number 18.
Your Lordship, we would have filed in the department.
Department. अच्छा की Yes, Rico.
Your Lordship, may I be permitted to file the all the affidavit in replies, Your Lordship?
Just a minute, just a minute. ये सब देख के लिख दे appearance.
My lord, may I make one small prayer, my lord?
Yes.
Kindly allow, my lord, because my lord, the nature of allegation is such, kindly give us leave to obtain the affidavit in opposition filed by the defendant number 1, because that is most germane, because the allegation of the plaintiff is that there is a collusion between defendant number 1 and defendant number 11.
And you filed affidavit.
Yes,
and another who was
5, 6. Lordship, respondent number 5.
13.
One is
Defend number 13, 6. Defend number 5, 6, and 13 have filed their affidavit in opposition. Police counsel for the plaintiff has filed affidavit in reply to all the affidavits.
Few were filed earlier and the balance.
Filed the affidavit in reply. Let the same be kept with the record. Counsel for the defendant number 10 and defendant number 18 has brought to the notice of this court to the order dated 28th of April 2025, wherein this court in paragraph
16, Your Lordship.
16, it is recorded that the defendant number 10 and 18 have not filed their affidavit in opposition, but it is fine from the record both the defendant, that is defendant number 10 and 18, have filed their affidavit in opposition. And as such, in the order dated 28th of April 2025, in paragraph 2017, though it has been recorded that the defendants number 10 and 18 have not filed their affidavit in opposition, then that same may be read as the defendant number 10 and 18 have filed their written statement, have filed their affidavit in opposition. Full stop. Counsel for the plaintiff prays for time. For the interest of justice, fully prays for time. It is informed to the court the interim order granted earlier is extended till 16th of June 2025. In view of the above, let the matter appear on 16th of June 2025.
Obliged.
Grateful.
Great.
There is no order.
Yes.
Item number 44, my lord, I appear for the plaintiff.
appearing
There are
for
two applications.
Subway. I'm appearing for defendant number 2.
My primary interlocutory application, which is GA1. GA2 is by the defendant number 2 for expunge. Lordship was hearing GA2, my lord, let defendant number 2 start, my lord. I'm led by Mr. Dutt. He is on his way, my lord.
GA2 he here. My lord, I'm appearing for defendant number 2.
Yes.
I'm holding the brief for counsel Mr. Manoj Bhad, who is appearing before the NGT. I've been instructed by my senior to appear in his stead and argue on the matter. So, if your lordship permits, I would like to commence the arguments.
Yes.
May it pleases your lordship. My lord, the plaintiffs have filed the present suit for declaring that the notices dated 27th of April 2024, 27th of September 2024, and 16th of December 2024 were bad, of no effect, and are liable to be set aside, delivered up, and cancelled, and also sued for specific performance on the agreement against the defendants.
Which application you are arguing? In which application?
GA2, my lord.
GA2
I have filed this application for deletion of the name of defendant number 2 from the array of parties, my lord.
Yes.
More than that, I am prejudiced. I am for Subway. I am prejudiced by the interim order. If that is not done, this really has no substantial significance.
What application you filed?
My lord, I filed this application for deletion of my name. That is the name of defendant number 2.
Taken up, but injunction application.
That is the main application. I am suffering for this order for the last 6
Injunction
months.
application pleadings completed.
Yes, my lord.
So okay, start.
Very good.
ये 345 मैटर है क्या? फिक्स मैटर है? क्या है? हियरिंग है? विटनेस सेक्शन है? Come tomorrow.
Very well. My lord, day after.
Day after.
Day after.
So suffering for the plaintiff, so suffering for the defendant, due to paucity of time, hearing could not be, due to people chief from defendant, let the matter appear day after tomorrow.
And I have my interim order till 16, so I'm not seeking any.
My lord, just one indulgence. Will the matter be posted for hearing on GA2 or GA1, my lord? Interim application.
I will take both applications together.
Very
My
well.
lord,
Very well.
would it be my lord's pleasure to fix some time?
Time, that is the problem. Take the chance. Because if the time already all matters, then it will go to the August.
Which is why I'm not pressing, my lord. I understand the difficulty.
I was waiting here and I've seen your lordship saying that if you wanted time, it has to be in August. So I did not say anything, my lord.
No, my lord. We'll take our.
That's why if the time is fixed, somebody is taking adjournment, then it's very difficult.
That is unfair.
That is the problem.
My lord.
Yes.
Once I
Very
have
well, my lord.
suffered because of that, my lord.
Such a time, sir.
Yes, call the matter. $45, nobody? Not today.
My lord, I am appearing for the plaintiff in item number 45, my lord.
Yes.
My lord, I am appearing for the defendant number 1. We have
My lord,
filed an application under Section 8 of the Arbitration and Conciliation Act.
Was heard.
No. On the last occasion, my lord, the plaintiff had taken time, my lord, to file an affidavit in opposition, but we have not yet been served with any copy of such.
My lord, I have instructions to withdraw this suit, my lord.
It's more than 6. So you are withdrawing?
Yes, my lord.
Have you written instruction?
My lord, I have written instructions, my lord. If it can be made not today, then tomorrow I can hand over the
Yes, sir.
communication as well.
Record and not. Swens offering for the plaintiff, Swens offering for the dependent number.
1, my lord.
Dependent number 1. Counsel for the plaintiff has handed over the communication dated 10th June 2025 issued by the plaintiff to the learned advocate on record of the plaintiff, informing that the plaintiff informing that the plaintiff is not intending to proceed with the matter and requested to withdraw the suit. In view of communication dated 10th June 2025, learned advocate appearing for the plaintiff pays for withdrawal of the suit. In view of the submission made by the counsel for the plaintiff and peruse the communication dated 10th June 2025, CSCOM 828 of 2024 is dismissed as withdrawn. Consequently, all the connected applications also dismissed. The communication dated 10th June 2025 be kept to the record.
Most grateful, my lord.
Much obliged.
Yes, call the matter.
Takes out the fixed matter, item 46. 46.
Case management.
It's just only thing that is left to be done in the suit. Here, my lord, the defendant was to take or rather give inspection of their documents. That has still not been done. Twice Germans have been sought for. So, my lord, I believe a date has been fixed finally on 12th, I believe, 12th June.
Okay,
Yes.
complete and come.
Yes, my lord, will kindly adjourn the matter till after that so that we can complete that discovery and inspection.
As per the prayer.
These are the 2 weeks in the meantime we can.
As per the prayer made by the counsel for the respective party, time to complete the discovery and inspection of the document and the other formalities as directed by this court is extended for a further period of 2 weeks from date. Let the matter appear on 3rd July 2024 under the same heading.
Well, this can appear under the heading suits because the applications have been disposed.
Case management.
Case management. Obliged.
My lord, similar prayer, my lord, of the same nature, my lord, extension of
which one? 14?
47, my lord.
No. Fixed matter.
Grateful.
My lord, item number 14, I beg to appear on behalf of the decree holder, my lord. My lord, the judgment debtor was being examined, my lord. My lord, may I continue, my
lord? Item number 14.
Yes, your lordship.
Yes. Present judgment. Who is for the judgment?
Yes, I appear for the judgment that is there. Little bit. My lord, Mr. Ghosh is leading.
Speaking
Hindi.
Hindi. Are you coming for the first time today?
No.
You are on oath, correct?
Yes.
What's your name?
Ankur Kumar Mishra.
Indian Army code language
होता है
আমাকে জায়গাটা বলে দিয়েছিল কি করে কোথায় শেখা যায় ISHRA রাইট
কোথায় কিভাবে পাঠিয়েছে একটা মানে কাভারিং লেটার দিয়ে পাঠিয়েছে হ্যাঁ পাঠিয়েছে
এই মানুষ
তো এই যে কাগজটা দিয়েছো আমাদের এটা দেখি
Yes.
My lord, pursuant to the last the questions put on the last occasion, the witness through his advocate has forwarded some documents which we had asked for. Now, my lord, we have taken the liberty of paginating it. My lord, may I show him these documents because these are the documents he has, my lord, disclosed. রাখুন তো একটু আমি কিছু কিছু পাতা দেখাবো নাকি কাভারিং লেটারও পাঠাইনি কাভারিং লেটার পাঠাই কবে রিসিভ করেছো কিছু তো একটা বলতে হবে
Yes.
Kindly come to witness shown. Witness shown a bunch of documents forwarded by his advocate by way of a covering letter dated 25th March 2025. Kindly come to page 23 of this bunch of documents and tell my lord as to the nature of the entry made by you from your HDFC bank account, HDFC bank account, Dhanbad, Jharkhand branch on 15th July 2024, being the third entry from the top.
थर्ड एंट्री है ना फ्रॉम द टॉप, इस एंट्री का नेचर बताइए।
মানে এটা কি করবে? এটাই তো স্যার, আরো আছে সেটা বুঝছিস তো? নেচার অফ দ্য এন্ট্রিটা মানেটা কি একটু বুঝিয়ে দিন, মানে এটা কি ক্ষেত খাতে তোলা হয়েছে বা কি কারণে তোলা হয়েছে?
एंट्री किया गया है।
নেই ধ্যান এটা কি দেখাচ্ছে সেটা বলুন। কিস वजह से নেই, কি দেখাচ্ছে?
cannot remember.
I cannot recollect.
I cannot recollect from the document. Okay.
If I suggested to you that this is a self-check that you have drawn on the bank to withdraw 1 lakh of rupees in your own favor, would I be incorrect?
अगर मैं कहूँ कि ये एक सेल्फ अकाउंट चेक है जिसको आपने जमा किया था,
Withdraw, okay.
1 लाख रुपए, क्या वो सही है?
Debited portion है ना?
Please look at page 23 and 23 only. Don't shuffle pages.
यहाँ पे डेबिट क्रेडिट नहीं लिखा हुआ है, मतलब ये विड्रॉ हुआ है।
वकील साहब का बोलना है कि जो एंट्री है वो एंट्री के हिसाब से आपने सेल्फ चेक से 1 लाख रुपया विड्रॉ किए।
आपका खुद का
आपका क्या बोलना है, मानना है? विड्रॉ किया है आप सेल्फ चेक से?
किया होगा सर, सेल्फ चेक है मेंशन्ड।
Yes, it has been withdrawn.
Kindly come to page 27 of the self-same documents and come to the sixth entry from the top made on 8th August 2024. Please tell the Honorable Court as to what is the nature of this entry made by you.
इस एंट्री का नेचर क्या है जो आपके द्वारा किया गया है? जमा हुआ है, किस खाते जमा हुआ है? या
ये वाला जो है ये सीसी अकाउंट से
8th August 2024.
सीसी
Sixth entry from the top.
सीसी अमाउंट सीसी से इधर आया है, सीसी अकाउंट से इधर आया है।
কোনটা দেখছেন উনি একটু দেখান তো, কোনটা দেখছেন উনি দেখান তো, কোন জায়গাটা দেখছেন? ওনাকে এনসার্কেল একটু এনসার্কেল করতে বলুন। দেখ তো কোনটা এনসার্কেল করছে।
This one, no?
सिक्स तो एटाई होता है।
কোনটা দেখাচ্ছে কোনটা পেয়েছেন?
ये विड्रॉ है, ये विड्रॉ है।
Yes, next.
It was withdraw.
This one is withdrawal.
If I suggest,
आपने जो आंसर किया वो क्या
नहीं नहीं वो withdrawal है this
Then says,
withdrawal हाँ
then says,
की बोला last withdrawn. If I suggest to you that this amount has been transferred stroke withdrawn by you from your HDFC bank account to PNB bank account of your own business, Sai Shakti Traders, would you be in a position to controvert me? No, sir. You are right. Kindly tell the amount that has been transferred from your HDFC bank account to your PNB bank account on 8th August 2024 under this entry. 1 lakh. Similarly, come to page 30 of your banks of the bunch of documents handed over, and kindly come to fourth entry from the top. Kindly tell this honorable court what is the nature of this entry made on 22nd August 2024 and what is the amount thereof. 75,000.
The amount is 75,000. And nature of transaction?
And withdrawal from this account
The amount was withdrawn.
and transferred to PNB account, CC account,
Was transferred to a CC account.
loan account. हाँ जी, yes.
PNB bank.
Yes.
Twenty-six কি কি দেয়া আছে সেটা দেখ 26 এর কোন অ্যাকাউন্টে আছে সব অ্যাকাউন্ট কানেক্টেড টু 26 এ দেয়া আছে কিনা দেখ সেটা না এটা না কোনটা হয় এটাই তো 26 টা দেখ HDFC ব্যাংক এটাই না এটা শ্রীরাম প্লাজা ধানবাদ ঝাড়খণ্ড ঠিক আছে হ্যাঁ এটা
But copy আছে order. But may I kindly take from your lordship's court records the order of 21st of March 2024 passed in the instant execution proceedings.
21st of March?
21st of March 2024. The first order that was obtained. A tabular statement টা ওনাকে একটু দেখাবেন। I can show him that এখন দেখুন 21st যদি না থাকে তাহলে আমি লিখে দিচ্ছি 21st March আছে তো আছে আর tabular statement টা দেখুন very well my lord will retain the order I will show from my records দেখুন witness shown an order dated 21st March 2024 along with prayer C of prayer F of the tabular statement filed in the instant proceedings prayer F টা tabular statement থেকে বার করে দেখানো tabular statement Do you agree that as on 21st of March 2024, this honorable court had injuncted you from operating any of the bank accounts, in particular the concerned bank account with HDFC Bank, without keeping aside a sum of rupees 37,58,376? তখন কত ছিল যখন এই ট্রানজাকশনটা করছিল ব্যালেন্সটা একটা কত ছিল কত ছিল কাছাকাছি জেলে যাক ऑर्डर देखाओ ना
21 मार्च 2024 को आपको एक ऑर्डर दिया गया था कोर्ट में उसमें आपको बताया गया था कि वो 37,58,376 रुपया छोड़कर आप ट्रांजैक्शन कर सकते हैं HDFC बैंक में वोट पे आपको रखना ही पड़ेगा
मेरे को इस डेट में मिला नहीं था
माइक
मेरे को इस डेट का जानकारी नहीं था ये वाला चीज 21 मार्च 2024
इस ऑर्डर के बारे में जानकारी
नहीं था
I didn't have the information about
this order dated 21st March 2020.
When did you first have information about the order dated 21st March 2024?
आपको इस order के बारे में पता चला पहली बार? नहीं बोला ना, इस ऑर्डर के बारे में पता नहीं था, कब पता चला पहली बार?
I think maybe मई और जून में मुझे पैसा जून में
Year
this year
of 2024.
2020 চিঠি থেকে জানিয়েছিলে দেখো তো দেখো কবে ডেটটা করো চিঠি কি বললেন মে
It may be in the month of May or June.
May or June. Where did you come to know from of the order in month of May and June 2024?
कहाँ से आपको इस ऑर्डर के बारे में पता चला? May और June के महीने में?
इस ऑर्डर के बारे में प्रॉपर पता नहीं चला पर यहाँ से एक ये वहां से मतलब वारंट इशू किया गया था तो मुझे पता चला कि
I did not get the proper information about this order, but a warrant was issued from which I came to know that. बोलिए.
मतलब मुझे उस पे पता चला तो देन आई कनेक्टेड द एडवोकेट एंड फर्दर स्लोली
हमने का डिवीजन बेंच
এটা তো এটা কি এখানে ফাইল করা আছে নাকি তো হ্যাঁ না কি করে এটা তুমি ফাইল করেছো নাকি এটা ফাইল করতে হবে এটা অ্যাফিডেভিট আছে এটা চিঠি ওটা পুরো অ্যাফিডেভিট হ্যাঁ তখন তো অর্ডার আপলোড হয়নি আমি প্রপারলি নট দিস অর্ডার বাট समथिंग इज गोइंग ऑन सो कॉन्टैक्ट एडवोकेट
आप वारंट इशू हुआ था, आपको पता चला, आपने एडवोकेट से कांटेक्ट
हाँ 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 तो तुम्हें नहीं जुड़ा रहा आगे बोलছি ভালো बस तो फिर वो एडवोकेट ने जैसा
Yes, next.
आंसर चेंज मत कीजिए
नहीं
ऐसे।
একটা অ্যাফিডেভিট অফ সার্ভিস আছে দেখুন তো 2nd এপ্রিল 2024 এ অ্যাফার্ম করা ব্যাকশিটে 3rd এপ্রিল 2024 লেখা আছে দীপরাজ বাসু witness shown an affidavit of service dated 3rd of April 2024 and particular page 3 thereof. Do you see a letter dated 23rd March 2024 addressed to you written by the advocate on record of the petitioner setting out the prayers and the order dated 31st March 2024 to 21st March 2024?
लेटर दिख रहा है जो आपको भेजा गया था ऑर्डर
ये तो दिख रहा है
सेकंड सीट
kindly turn to page 4 of the said document annexure B thereof. Do you find that you have refused the said letter? Page 4 and page 5 which will show that you have refused to accept the said letter.
क्या आप देख पा रहे हैं कि आपने इस लेटर को लेने के लिए मना किया था?
कोई रिफ्यूज नहीं किया मैंने 4 और 5 দুটোই দেখাও 5 টা দেখাও मैं रिफ्यूज कोई नहीं किया
I did not refuse to accept the letter.
অন্য এটা দেখাও ওর যে অ্যাপিয়ার করেছে সেটা দেখাও হ্যাঁ না না এটা না এটা রাখো মাথা আছে প্যাক করো এটা দিয়ে অসুবিধা এটা 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 হ্যাঁ না না পুরোটা কথা কি বললেন উনি আনসারটা কি গেল at least you will not deny that that on 1st July 2024 Mr. Ashok Pandey representing you appeared before this court একটু দেখান তো 1st July 2024 এর অর্ডারটা হ্যাঁ 1st July 2024 আছে সার্ভিস ওটা করেছে দেখো তো বলছে আমি পাই না রিফিউজ আছে না ওই জন্য ছেড়ে না এটাই এরপরে
1st July 2004 को अशोक पांडे ने रिप्रेजेंट किया था कोर्ट में आपके बिहाफ से
क्या होगा किया होगा, किया होगा शायद, किया होगा। क्योंकि
First,
নামটা দেখাও, অশোক পান্ডে অ্যাপিয়ার করেছে।
अशोक पांडे appear अशोक पांडे appear किया था।
हाँ,
आपके भी
एडवोकेट साहब, हाँ।
Yes, he was my advocate.
So by 1st July 2024, you had knowledge that the order dated 21st March 2024 has been passed, restraining you from operating this bank account?
इसका मतलब इस तारीख को 1 जुलाई 2024 को आपको नॉलेज था कि आप उस बैंक में जो ऑर्डर था उसके बारे में आपको नॉलेज था।
नहीं, उस समय मुझे ये चीज का नॉलेज नहीं था। इस डेट को मेरे को वो लीगल जो पुलिस आ रहे थे अरेस्ट वारंट वाले में, तो मुझे जब पता चला तो मैं उसके लिए ये किया था, और बाकी सारे चीज जो वो सर देख रहे थे, मुझे मतलब इसका
I did not have the knowledge about the order. I had the knowledge about that warrant, and that is why I consulted with my lawyer.
Only a few questions back, in fact, you have admitted that you had knowledge of the order dated 21st March 2024, even before 1st of July, that is from May, June 2024. Do you want me to read it? Do you want the court officer to read it back to you?
3 क्वेश्चन पहले आपने बताया कि जो ऑर्डर था 21st मार्च का, उसके बारे में आपको
मई जून
मई
और जून के महीने में आपको पता चला था। 2-3
सर ऑर्डर के बारे में नहीं पता चला था, वो मेरे को
आपने ही बोला था।
नहीं सर, मैं वो बता रहा हूँ कि जो मैं
Mr. Witness,
sir,
this is not the film shooting. You are on oath. I will take you in custody. Just before 5 minutes, you stated that April or May, you have received you came to know about the order. Can I take you in custody? Or you are playing drama here? What the statement you are making, that is on oath. And before the court. Whatever you want to say, think 10 times, then you give the answer. What the statement you have made earlier, that was incorrect. Say incorrect. It is incorrect. What the statement just 4 questions before you have given? You're telling that was incorrect or not?
Sir, I was.
Court is asking only one thing. 4 question before, you stated that you came to know about the order on April or May 2024. Whether that statement was correct or not. May or June, something. May or June.
May June.
कहा था ना, मई और जून के बारे में आपको इस ऑर्डर के बारे में पता
Whether that statement is correct or not.
स्टेटमेंट सही है या गलत है?
I am asking one question. You tell that answer first. Question to the court.
To court করে দাও. Sir, proper.
You have given answer just before that you came to know about the order dated 21st of March 2024 in the month of May and June 2024. Whether the statement is correct or not. Give the answer. बताइए सही है कि गलत है? जो इससे पहले जो आप आंसर दिए थे, आपको जो ऑर्डर के बारे में मई और जून में पता चला, वो गलत है कि सही था? वो छोड़ दीजिए, वो डॉक्यूमेंट के बारे में मैं नहीं पूछ रहा हूँ। आपने 2 क्वेश्चन पहले जो आप बोला था कि आपको ऑर्डर के बारे में पता चला मई और जून के महीने में, वो सही है कि गलत है?
सही है सर, पुलिस से पता
इट वॉज करेक्ट।
वो वारंट वाले में तो कुछ है, प्रॉपर सारी चीज नहीं पता था, लेकिन
यस नेक्स्ट।
Then, knowing that the Honorable High Court at Calcutta has restrained you from operating the bank account in question with HDFC Bank, how did you operate it at least thrice, if not more, to siphon off
large sums of money to the extent of 2,75,000.
फिर कैसे आपको ये पता होने के बाद कि हाई कोर्ट ने आपकी अकाउंट में एक रेस्ट्रिक्ट ऑर्डर दिया हुआ है, आपने 3 बार लार्ज अमाउंट जो कि करीब 2,75,000 का है उसका ट्रांजैक्शन किया है, उस अकाउंट से दूसरे अकाउंट में भेजा?
Apart from others, এটা ছাড়াও শুধু এগুলো বড় অ্যামাউন্ট গুলো বললাম।
ये बड़ा अमाउंट 2,75,000 का बड़ा अमाउंट का आपने ट्रांसफर किया है, कैसे? कोर्ट का तो रिस्ट्रिक्शन ऑर्डर था ना, रिस्ट्रिक्ट ऑर्डर था उस अकाउंट में, ये जानने के बावजूद भी आपने कैसे किया? जैसा ये वकील साहब ये पूछ रहे हैं।
सर मेरे पास वो करेंट अकाउंट है जिसमें मैं ट्रांजैक्शन किया हूँ, और मेरा सीसी अकाउंट लोन अकाउंट सीसी अकाउंट जिसमें मैं
एक एक करके I have a current account from which I have made the transactions and I have a loan account
जिसमें मैं ये सब ट्रांजैक्शन किया, मतलब भेजा था पैसे।
from
क्या हो কি গেল উত্তরটা?
I have
एक बार
and I have a group account to which I have transferred the money.
You were restrained. I'm suggesting it to you that by the order of 21st March, you were restrained from making any transfers, 2024, from making any transfers without keeping a sum of rupees 37 lakhs in the account.
वकील साहब आपसे कह रहे हैं कि मार्च 2026 के ऑर्डर के चलते आपके ऊपर एक रेस्ट्रेंट ऑर्डर था कि आप बैंक अकाउंट में 37 लाख नहीं रखकर कोई भी ट्रांजैक्शन नहीं कर सकते। 37 लाख आपको रखना ही है बैंक में।
So how did you do those transactions?
फिर आपने कैसे ये ट्रांजैक्शंस किया?
मेरे पास सीसी अकाउंट वाला नहीं था, मैं किया हूँ, मैं तो ट्रांजैक्शन किया हूँ।
दूसरे आपने कैसे किया? आपने किया है, उनको पता है।
He said I have done it. Just record that I have done it.
Yes, next.
Yes. Contempt petition করবে যখন আর দেখা শেয়ারগুলো পর kindly take page number 72 of the bunch of documents handed over by a covering letter of a bunch of documents handed over by you. Kindly encircle the entries made the first, second, fifth and 10th entry made in this page. First, second, fifth and 10th entry made on this page.
Page number 70.
ठीक दिया था ना? First, second, fifth, and 10th. 4/4/2024. What is the nature of these entries?
ये जो एंट्री है ना, इन सब का नेचर क्या है? क्या जमा हुआ था, उठाया गया था?
ऑर्डर पास करो आगे भाई একটু পরে যদি কিছু থাকে से ही पैसा निकला है।
आप माइक में बोलिए सर।
यहाँ से विड्रॉ हुआ है।
The first transaction
विड्रॉल
the first transaction of amount कितना पैसे विड्रॉल किया गया?
50,000
Withdrawal of an amount of 50,000. Second,
it was general nature बताने से भी चलेगा। It was also and
सब
withdrawal.
एक साथ भी बोल सकते हैं, जनरली भी बोल सकते हैं।
What is the nature of this
Specifically बोलने की जरूरत नहीं है।
हाँ, ये से विड्रॉ हुआ था.
All of these entries are withdrawals.
If I suggested to you that these entries have been made, these withdrawals have been made by you to pay a stockbroking firm by the name of Angel Limited for buying of shares, would you be in a position to contradict me?
वो आपको बोल रहे हैं कि आपने ये सब पैसे
Angel.
yes
What were these shares that were purchased?
वाले शेयर आपने परचेज किया था.
I don't know. It was for trading.
I do not know, it was for trading purpose.
So you used to do trading also?
आप ट्रेडिंग करते हैं.
Rarely.
Really?
What happened to these shares that you purchased, which will appear from page 72 and other pages of this bank statement?
इस वाले 72 पेज और दूसरे वाले बैंक स्टेटमेंट के पेजेस में जो विड्रॉल किया गया उसके चलते आपने जो शेयर खरीदा था उस शेयर का क्या हुआ?
ये वाला जो स्टॉक ट्रेडिंग के लिए था, और वो जो पुराना वाला जो बता रहे हैं, जो जिसमें वो सीसी अकाउंट का पेमेंट का लोन अकाउंट पेमेंट का था.
ये वाला
इस अभी जो है ये स्टॉक ट्रेडिंग पर्पस से था.
ये जो एंट्री
स्टॉक ट्रेडिंग का पर्पस है वो नीचे की बोले. देखिए
शेयर्स का क्या हुआ? जो शेयर्स आपने
जो शेयर्स यू हैव परचेज्ड उसका क्या हुआ?
खरीदे ना वो शेयर
সবই বুঝতে পারছো? It was for trading purpose of trading.
ना जो आपने ट्रेडिंग में तो शेयर खरीदा है ना, तो शेयर का क्या हुआ? वकील साहब का बोलने का मतलब है वो शेयर है या क्या हुआ उसका?
नहीं सर, वो तो उसी समय
क्या हुआ वही बहुत पूछ रहे हैं.
क्या हुआ? What happened to the shares?
शेयर का क्या हुआ?
अब तो पैसा लगा शेयर में.
लॉस हो गया. You must be having a statement of your demat account that you had maintained with Angel Limited. When was the last? Yes, answer is yes. When was the last time you dealt in shares through Angel Limited? Dealt in shares through Angel Limited?
इंजन लिमिटेड के थ्रू आपने लास्ट टाइम कब शेयर में डील किया था? लास्ट टाइम में शेयर परचेज कब किया था?
किया हुआ, रिसेंटली भी किया हुआ. Recently. Would I be incorrect in telling you, in suggesting it to you, that apart from Angel Limited, you also deal in shares through SBI Cap Securities Limited?
वकील साहब कह रहे हैं कि अगर वो कहे कि एंजल ब्रोकिंग
उनको छोड़ करके एसबीआई कैप
के थ्रू भी आप शेयर खरीदते हैं, क्या वो गलत होंगे? एसबीआई कैप के थ्रू भी आप शेयर खरीदते हैं?
अकाउंट है, खरीदा हो.
I have an account and I may have purchased.
Okay. Apart from these two, what are other broking firms that you deal in shares with through?
और कौन से ब्रोकिंग फर्म है जिसके साथ आप थ्रू आप शेयर खरीदते हैं?
All submitted, all provided to. He will say?
Submitted all the documents.
Or provided to, all details provided. I will provide it. No, sir. Already provided. Already provided. Already provided, sir. একটু affidavit of assets টা দেখান তো নাকি, যেটা ফাইল করেছেন উনি on 7th of August 2024. I am suggesting it to you that we have credible information that on 7th of August 2024, when you affirmed this affidavit, you had substantial shares standing in your name through these broking firms. But despite that, you have mentioned only your own company shares at page 5 of the affidavit of assets.
सब आपसे कह रहे हैं कि उन्होंने क्रेडिबल सोर्स से ये पता किया है कि 7 अगस्त 2024 को आपके नाम पर बहुत सारे शेयर्स थे कि आपने सिर्फ आपकी कंपनी के शेयर्स ही यहाँ पर मेंशन किया है पेज नंबर 5 का.
ভালো করে বোঝাও কোশ্চেনটা.
आपको ये सजेशन दिया जा रहा है, ठीक है?
শোনো,
वकील साहब आपको सजेशन दे रहे हैं कि उनके पास क्रेडिबल इंफॉर्मेशन है।
কাগজটা বার করো যে ওর কাছে শেয়ারগুলো তখন ছিল, বার করো
7th August
ছিল
2024
আমাদের কাছে ওখান থেকে।
2004 को जब आपने ये एफिडेविट को अफर्म किया था,
হাতে রাখো, এক্ষুনি বলবে তো, না আমার কাছে ছিল না, হাতে রাখো ওটা।
आपके पास आपके नाम से सब्सटेंशियल शेयर था। बोलो
কোয়েশ্চেনটা কি গেছে, নাহলে একবার বলে দিতে পারি। We have credible, আমাদের কাছে আছে।
Substantial share standing in your name to this booking booking limited, but
No. Through these broking firms, apart from the shares that you have mentioned in page 5 of the affidavit, which are your own company shares.
आपके नाम पे सब्सटेंशियल अमाउंट का शेयर्स था, जो ये यहाँ पर आपने जो कंपनी के शेयर्स
खुद का कंपनी का
मेंशन किया है उससे अलग है।
जो शेयर्स आपके पास थे,
जो शेयर्स आपके थे वो अलग है, कंपनी का अलग है।
7 अगस्त में था।
नहीं सर, ये
क्वेश्चन समझ लीजिए पहले, उनसे पहले।
7 अगस्त 2024 को आपने जब ये
सुनिए,
एविडेंस को अफर्म किया है,
ये जो अफर्म हुआ है ना, कौन सा डेट में हुआ है?
7 अगस्त
7 अगस्त को हुआ है।
सर
उस दिन जिसने अफर्म किया है, जो आपने यहाँ मेंशन किया, उसके अलावा भी दूसरे जो है ट्रेडिंग फर्म्स में आपके पैसा थे, आपने डिस्क्लोज नहीं किया।
शेयर्स थे,
शेयर्स का।
सर ये जो है ना, ये वाला सर, ये कंपनी का है, जो कंपनी
वही, वो तो बोलते कंपनी के, और आपके पर्सनल भी था,
सब मेंशन्ड, सब दिया हुआ है।
उसमें डिस्क्लोज नहीं
नहीं
किया है
किया है।
आपने, एफिडेविट में डिस्क्लोज नहीं किया है। उनका बोलना वो बात है, डिस्क्लोज किया है या नहीं किया है?
नहीं पता सर,
किया है?
यहाँ पे तो नहीं है सर, यहाँ
नहीं
पे
है, बस वही पूछ रहे हैं वकील साहब।
So I suggested to you that you have made false disclosures and statements on oath before this honorable court, despite knowing that there are other stocks and shares belonging to you as on 7th August 2024.
समझे कि नहीं समझे? वकील साहब का बोलना है कि आपके पास और भी काफी शेयर्स के फंड्स थे, लेकिन आपने ये जो एफिडेविट सही तरीके से नहीं दिया है, बाकी को डिस्क्लोज नहीं किया है, गलत एफिडेविट आपने दिया है। क्या बोलना है आपका?
क्योंकि वो सब शेयर्स का कोई मेंशन नहीं है आपके, तो
क्योंकि आपके जो पर्सनल शेयर
कॉलम्स है ना, इसके अंदर तो सिर्फ 2 है, आपका बाकी शेयर भी था, आपने मेंशन नहीं किया है,
आपने नहीं दिया, इसलिए जो एफिडेविट है वो
गलत
गलत
है।
एफिडेविट है। आपका बोलना क्या है?
सर सर यहाँ पे तो मेंशन नहीं है सर।
नहीं है ना, तो ये ठीक नहीं है। तो इट इज करेक्ट, इट इज नॉट मेंशन इन दी प्रेजेंट एफिडेविट।
बट सर मुझे लगता है सर शेयर नहीं होगा, वो चीज तभी नहीं होगा इसके कंपनी वाला मेंशन किया गया था।
आपका पर्सनल का बात कर रहे हैं।
Kindly take your answer to question number 5, 4 and 5, conducted on 29th of August 2024. Specific question was put to you whether you have concealed any assets or properties to this honorable court, assets or properties from this honorable court by filing the affidavit of assets, and your assertion in answer to question number 5 is also incorrect and false. Am I correct?
वकील साहब का बोलना है कि जो क्वेश्चन नंबर 5 में जो आंसर दिया वो गलत है। आपका क्या बोलना है?
सर मैं तो सही दिया था सर।
आई हैव गिवन द राइट आंसर।
But now, today, in light of today's testimony, where you have yourself admitted that the shares belonging to you in your personal name has not been given in the affidavit of assets, answer to question number 5 is not correct because you have concealed.
That's a matter of argument.
Very well. Very good.
The matter of argument.
Very well. I stand correct.
हाँ कौन सा बेंच हाँ वो आएगा रिकॉर्ड में
But I'm making an oral prayer. Let him go to civil prison right from here. Because your lordship has seen, he has substantial sums of money. He has transacted even after the order of court. He has transacted to the extent of 1,75,000, 1 lakh. He has bought shares and he has deliberately not disclosed these in the affidavit of assets. Only when inadvertently these documents have gone into his disclosure that we have come to know. Let him get to know what are civil prisons like in this country. Is a person who is, I could have understood, he does not have an advocate, does not have legal help. That is not the case. His advocates understand what is the meaning of an order of injunction. It is an advocate who has drafted this affidavit of assets. So he may have concealed from his advocate also.
Yes. Any further question?
But there are a few questions. I don't, even on the basis of what I have told him and what he has discussed before you, your lordship was there. He should be sent to civil prison straight away. He is a person who has no regard for the law. And he has not deliberately, kindly see the cunningness, he has disclosed everything, but he has not disclosed the demat account statement, which will show how much shares he has. He has shares worth lakhs.
Okay, Mr. Ghosh, witness is on box. You put whatever you
I'll make out an
and
application.
It
No, I'll
will
take
be,
out an application
it will be
also.
decided at the time of the
I'll take out an
final
application.
disposal of the EC, whether it will not pay, then automatically
Would you be, yes, let me ask for the demat account statement.
Correct.
Would you be in a position to produce the demat account statements of all the trading firms with whom you have done trading or you still do trading from 2024 January onwards?
2024 की जनवरी से आपने किसी भी डीमैट अकाउंट से किसी भी कंपनी के किसी भी डीमैट अकाउंट से कोई भी ट्रेड किया है या शेयर खरीदा है, सबका आप स्टेटमेंट प्रोड्यूस कर सकते हैं अगले दिन?
अगले डेट में नहीं, अगले डेट से पहले, before the next date.
I can.
On the last occasion, I had asked you to also produce a copy of the notice under section 13(2) of the Securitization Act. Why have you not produced the same?
वकील साहब ने आपको कहा था ना एक नोटिस ऑफ द
13(2) of the
लास्ट समय जब आपके एग्जामिनेशन हुआ था, वकील साहब ने आपके बोला बैंक से एक नोटिस आया था ना लोन का, वो आप बोले थे प्रोड्यूस करेंगे, वो क्यों नहीं प्रोड्यूस किए?
दे दिया सर, भेज दिया गया था सर.
किसको भेज दिया?
देखा कागज तो देखा. Is it the document at page?
I have sent the document.
Is it the document at page? Is it the document at page 98 or 99 of the bunch of documents handed over to you? Are you referring to? Are you referring to pages 98 and 99 of the?
ये 98 और 99 में जो डॉक्यूमेंट दिखाई जा रहा है यहाँ पर, इस डॉक्यूमेंट के बारे में आप बात कर रहे हैं?
Are you referring to these documents as 13(2) notices under Securitization Act?
Yes, this is the document.
I am suggesting it to you that these are not the documents, these are not the notice under section 13(2) of the Securitization and of the SURFACE Act. Kindly produce the actual notice given under 13(2) of the Securitization Act before the next date of hearing.
वकील साहब का कहना है ये वो नोटिस नहीं है, अगले दिन से पहले नोटिस का कॉपी सेंड कीजिएगा. क्या आप
तो ठीक, मैं कोशिश करूंगा। मुझे यही लगा था, पोजीशन नोटिस
কি বললো? I had also called upon you on the earlier occasion to produce the loan statement from the bank in respect of the car that you own. Why haven't you not produced the same?
लोन, आपकी कार की लोन स्टेटमेंट मांगा था आपसे, वो भी आपने नहीं दिया, क्यों?
में दिया सर, दिया हुआ, लेट मी सी, दिया हुआ सर, सारा स्टेटमेंट में निकाल के दिया,
स्टेटमेंट
दिया था सर
स्टेटमेंट
सारा।
Sure. Kindly take out that statement from the bunch of documents that has been circulated. লোন অ্যাকাউন্টটা প্রডিউস করে, ওর যে এটাও করে, এটাও করে। এটা তো আমি বলিও না। ও আচ্ছা, হ্যাঁ, ডিটেলস অফ ট্রান্সফার এটাও প্রডিউস করে।
97
পেজ
90
এটা
appeared at page number 97 of the bunch of documents. 97 of the bunch of documents.
I am suggesting it to you that this cannot be the entirety of the statement and only is a part of the statement, if at all, relating to the car.
सब कह रहे हैं ये पूरा स्टेटमेंट नहीं है, बल्कि उसका एक पार्ट है।
जहाँ से मांगा गया था दे दिया था मैं, और फिर फर्दर चाहिए तो दे दूं। सर आप जहाँ से बोले थे वहाँ
I have given the statement from where, for which portion it was.
I am not asking you from any portion. Kindly produce, kindly produce the entire statement from the beginning till date in respect to this loan account.
The statement आपको देना होगा, ठीक? अगले दिन
In question number 90, in question number 90 and 93 on the previous occasion, I had called upon you to produce the statement of your brother's bank account to show that he had paid 1.5 lakhs to you from his account to buy the car. Have you disclosed such statement of your brother?
क्वेश्चन नंबर 90 से 93 तक आपको पूछा गया था, तो आपको पता है कि आपके ब्रदर ने आपको 1.5 लाख रुपया दिया था कार खरीदने के लिए। आपने आपका भाई का क्या बैंक स्टेटमेंट दिया हुआ है? बोलो क्या है आपने उससे मांगा गया था?
नहीं, भाई का नहीं मांगा गया था, नो सर, भाई का नहीं मांगा गया था।
কি বলছো?
Saying that his brother's statement was not required.
Would you be in a position to show any bank statement of yours to
The
show that your
document
brother
has not been asked for.
paid 1.5 lakhs as down payment?
आपके पास कोई डॉक्यूमेंट है जो दिखा सकता है कि आपके ब्रदर ने ये 1.5 लाख रुपया दिया था डाउन पेमेंट का?
I will try.
Kindly take the tabular statement that you have affirmed. I'm sorry, the affidavit of assets that you have affirmed on 7th August 2024. ওটা দেখান একবার affidavit. Come to page 6 thereof. Page number 6.
अरे वो नहीं
Patla.
Yes, page number 6.
These fixed deposits under column E of 50,000 and 34,976 are still there. Am I right?
ये जो दो फिक्स डिपॉजिट है 50,000 का और 34,000 का, ये अभी भी है, राइट? ये तो फिक्स डिपॉजिट अभी भी है।
HDFC वाला नहीं है और ये वाला होगा।
The HDFC fixed deposit here right now, but
It is not there.
The fixed deposit of rupees 34,000 may be there.
So you have so I take it that you have liquidated the fixed deposit of 50,000 with HDFC Bank even after affirming the same in the affidavit of assets of 7th August 2024.
It is auto pay.
It is
Auto pay on maturity auto pay.
the fixed deposit was auto pay on maturity.
Did you give auto pay instruction?
And that amount you have withdrawn by self check. Am I right?
आपने सेल्फ चेक से ये अमाउंट विड्रॉ किया है.
ऐसे नहीं है, डेली लाइफ में गया हो.
आपने विड्रॉ किया है या नहीं?
हाँ तो अब हाँ विड्रॉल हुआ है. For livelihood. So am I correct that you have continued to operate the bank accounts and is continuing to operate the bank account till date despite an order of injunction by withdrawing or depositing
क्या
money
वो
into
सही है
them?
जब वो कह रहे हैं कि आपके ऊपर एक रेस्ट्रेंट ऑर्डर था बैंक अकाउंट को यूज
बैंक अकाउंट्स को
यूज करने के लिए ऊपर, इसके बावजूद भी आपने बैंक अकाउंट को ऑपरेट करते रहे.
आज तक कर रहे हैं.
आज तक कर रहे हैं.
ये सही है या गलत है?
सही है या गलत?
ऑपरेट कर रहे हैं. But if this is the attitude, well, what more do I say? He's represented by lawyers. Well, this cannot be just a layman. He is not a rural layman, illiterate.
Next.
Could be. Already I have overstretched my limit. Well, I'll make an application. I think I have enough material to.
Any further? You will examine further?
No, Malad. Yes, I will. But let him come another day. And in the meantime, I'll make that application also. Let him go to jail.
So and so offering for the decree holder. So and so offering for the judgment debtor. Judgment debtor is present. And the examination in judgment debtor resumed. But due to paucity of time, examination could not be completed. Accordingly, examination of the judgment debtor is deferred. Let the matter appear on एक डेट कोई टाइम दो इसका.
But kindly fixes a time so that it's better. Whichever day your lordship says, we will come back.
1 जुलाई बाद
15 राइट. फिर फर्क जाएगा सब. कब है? 17 जुलाई 3:45 for examination of further examination of judgment debtor.
Yes, just leave to mention one matter, my lord. Lord, item number 99 of your commercial list, my lord. The matter which is not called on today. We are the time for filing the written statement 120 days is expiring on 15th of February, my lord. We have already affirmed the
expiring on
15th of June, my lord. We have already affirmed the written statement, my lord. All I'm praying.
When you receive the writ of summon?
My lord, 15th of February 2025.
February.
My lord.
Then 30 days March.
30 days March, my lord. Thereafter, 120 days expiring on 15th of June, my lord. That we have affirmed it, my lord. All I'm praying, leave to file it, my lord.
You file wakalatnama?
Already filed, my lord.
Liberty is given to the defendant. No. Liberty is given to the defendant to submit the written statement in the department. In today you will file. By tomorrow. By tomorrow. Liberty subject to acceptance.
Well, the only thing that document I was showing, let my advocate on record make a proper bunch before your lordship and submit it.
Okay.
But it will be done without. I'll just inform your lordship. Much obliged.